Well, if I may,
There is the order 41 matter one.
by the lead, so this was mentioned earlier by my junior Mr. Banerjee. The only unique feature, this is assigned matter I am seeking, only unique feature in this I can think of is a professional's office. She's out of
Mr. Mitro, কবে রেখেছি আমরা? Next Tuesday, we'll keep the assigned matters before the other matters.
Great.
So that we have already directed that.
Great.
We'll try to do that regularly so that we can take up the assignment.
Then I am ready.
I know, Milord, your Lordship for the time being is not, Milord, taking mentioning of hearing, but your Lordship granted me leave, Milord, to remind your Lordship at the time of application hearing that in a suit for death declaration of death of a particular person, Milord, the police authorities has been added as one of the defendant, but Milord, the suit has been dismissed on the
Section
first
80.
day. Section 80. Milord, it will take 1 minute of your Lordship's time. It's really not a
It's
hearing.
happening for the other side.
Milord, everything is being served. Milord, the notice of service of appeal, paper book, everything is complete. Milord, it's 10 pages paper book. Milord, nothing in it.
Let it appear as 4 orders on Wednesday, next Wednesday.
I'm great.
4 orders.
I will just hand
For
the
orders,
slip, Milord, to your Lordship's officer.
to be mentioned এর পরে 4 orders দিয়ে দেবেন বুধবার।
দিদি আমি এক্ষুনি স্লিপটা দিচ্ছি।
Yes.
Lordship, may I be
Pardon?
Order 41.
Yes, yes.
Order 41 for inclusion,
Yes.
Lordship. My lord, order 41 for inclusion, my lord.
Yes.
And contempt application.
Yes.
Grateful, my lord.
Thank you. Accordingly, the above appeals are allowed, thereby setting aside the enhancement awards impugned therein, respectively, and remanding the matter to the referral court for the purpose of rehearing of the references under Section 18 of the Land Acquisition Act 1894 in all the said cases in the light of the above observations, proceeding to ascertain market value on the basis of the set forth market values as shown in the 5 sale deeds executed in favor of ECL, which shall be marked as exhibits by the learned trial judge by dispensing with further formal proof, and calculate the compensation payable to the claimants in each of the cases accordingly and in accordance with law. Upon such marking of the said documents as exhibits, adequate opportunity shall be given to the claimant respondents to adduce rebuttal evidence, if they so choose, for the purpose of displacing the presumptive value of the said documents. Thereafter, upon giving further opportunity of hearing to the parties, but on the evidence already on record, including the additional evidence permitted by this court, the referral court shall decide all the reference cases afresh and in accordance with law in the light of the observations made above. In view of the long pendency of the cases, it is expected that such exercise shall be completed within 1 year from the date of communication of this judgment and order to the court below. The particulars of the judgment set aside and the corresponding appeals are given in the chart below. We have given a chart, number of the appeals and the impugned awards in each of those. And there will be no orders to cost. All interim applications are disposed of. Interim orders stand vacated. Appellant shall be at liberty to withdraw the amount deposited by it pursuant to directions of the court in each of the present appeals along with interest after deduction of the necessary expenses and statutory deductions. As and when so approached, the learned Registrar General shall release the amount accordingly to the appellant. Appeals, yes. কি জন্য আসছে কোনো আইডিয়া আছে? রিপোর্ট দেয়
কোডটা খুঁজে পাইনি, ডেটটা চেঞ্জ হয়ে গেছে তো আমি বুঝতে পারিনি। দিদি না না
বলবেন না, রেখে যাবে।
এটা একটা অর্ডার রয়েছে জাস্টিস রাজীব শর্মা 2014 ওই Honorable Second Judge's copy furnished by the department be treated to be the original. Full stop. Next para. The matter be placed for hearing under Order 41 Rule 11 of the Code of Civil Procedure in the list of June 23, 2025. Sombar din Order 41.
Responding. No, I think the responding.
You're appearing?
For the responding, Lord.
It will appear under the Order
Fine.
41. If you can, please inform the appellant's advocate, whoever is there.
No, I find Lord. I'll find out. Lord.
Item number
Well, I'm
12,
appealing
my
for the
lord, is in-
respondent number.
My lord, I am waiting for the respondent number 1, my lord. I'm praying for a short passover, my lord.
No. Specially fixed matter, no possible.
No, Lord, specially fixed, my lord, in this sense, my lord, this matter was appearing down the list, my lord. It was mentioned
have
at his
mentioned- I have
instance, my lord, and my lord has been pleased to fix the matter specially fixed. That is one issue, my lord. The other main issue is that, my lord, this is a will by a father. The mother's will is also under challenge. My lord, on the almost self-same facts, my lord, both the trial courts have held differently. My lord, here, my lord, the father's will have been probated.
Which was earlier.
Mother,
Bill is earlier.
mother's will appears. That appeal is not appearing. The father's
Even if the mother's will is allowed, probated, it depends on this.
but
if this is-
similar
Here, probate has been dismissed.
No,
probate
allowed.
has been
Wait,
granted.
wait. Suppose if you lose the appeal here,
Right.
then mother's will become that appeal becomes redundant in any event.
My lord,
And if you win here,
Right.
then only we'll direct that to appear. That has nothing to do with this. Move the matter.
no, my lord. So far as the facts involved in both the cases,
Maybe we are not interested. The facts involved in this case are before us in the paper book, and we'll hear the appeal independently.
my lord,
If the father's will prevails,
My lord.
then mother's will appeal will just take it, put it as to mention and dismiss it. And if you win in this appeal, then we'll direct that appeal to appear.
my lord, in
Move
that,
this appeal. No.
my lord, in this, that event, my lord will kindly take it on next week, my lord.
Why?
Because my lord, suddenly it has been
No,
brought
I
to
will
the top
put on
and-
No,
notice.
notice was given to
My
you.
lord,
They
no
have
notice
give
was
me a
given, my lord, it
notice.
was short notice. My lord, any day next week, my lord, next week for as specially fixed, my lord. No, I'm almost ready, my lord. Some final because matter was appearing in the list.
First appeal sometime should be.
Very good.
On the prayer of the appellant, the matter is adjourned till June 23, 2025, when it will be listed under the same heading. একই রকম ভাবে থাকবে।
Lordship. Lordship, may I be given one indulgence?
What indulgence?
Lordship, item number 11, Lordship. At the time of calling item number 11, Lordship, I was in the courtroom number
It will appear in the list under the heading Order 41.
order 41, Lordship. But Lordship, one stay order has been passed, Lordship. Once,
There was a direction of Justice Rajiv Sharma
yes,
that
Lordship.
no substantial question of law was formulated, neither what is admitted formally. So we have placed it under the heading Order 41 on Monday. Please come and move the matter.
Lordship.
Yes.
I'm deeply obliged, Lordship.
Thank you. Yes, who is appearing? Item 13. Ridiculous. অর্ধেক hearing হয়েছে।
I don't know the petitioner.
দেখি 1 মিনিট দেখে নি। আবার পরে এসে খ্যাঁকা খ্যাঁকা করবে। একটা order record করো। It is surprising that although the matter is appearing at the top of the part-heard list, comma, and the same is a continuing part-heard matter, comma, the none appears for the appellant at the time of call, full stop, as a last chance to the appellant to continue their arguments, comma, the matter is adjourned for the day. অদ্ভুত ব্যাপার, সকাল থেকে 10:41 বাজে। Mr. Banerjee, you are for the appellation.
We are for the appellate, my lord. We were to give reply, my lord.
You have argued, they have argued.
They have argued. The point, my lord, whether part of, my lord, rent includes, my lord, the air conditioning charges on.
Yes.
My lord, may I pay this?
No,
my lord?
don't
We shall-
scratch
we
your
shall
head.
file a- We shall file a short note. We have almost prepared note. We shall file the note and, my
Then
lord,
we'll conclude arguments today. File a short notes, no difficulty. We'll conclude arguments. We won't keep it pending as a part-heard matter. No further part-heard, burden over our head. And Mr. Banerjee, we are being candid. We never know what will happen, whether the bench will survive after the new judges come. Because two senior judges are coming. If this division bench goes, then these part-heard matters, it will be very difficult to reassemble. In fact, if that happens, we'll cancel the part-heards.
this is a stage of reply.
You had argued.
we had argued. No, basically, my lord, the crux of argument was not that rent was rupees 2,000.
Why were you asking for time? You are not reading them. Are you?
Because it's a closing argument. That is why, my lord, I wanted to just not.
You are not led by anybody. You are the person.
No, Mr. Chatterjee is also appearing. my lord.
So, Honorable Chatterjee, will not. You are sufficient.
देखो ना तो Lord, in this case, my lord, if your lordship, my lord, takes the plaint, which is page 13 of, my lord, paper book 1,
Just shortly remind that yes.
the
But
point
then
is, my
included
lord,
within
rent
rent.
was 2,000 rupees 2,000,
Yes.
and the air conditioning charge was rupees 11,000 admittedly.
Yes.
So our case is that, my lord, it is necessary for beneficial enjoyment of the tenancy.
There are two components, extra components. One is the municipal taxes, another
Other
is this air
Air
conditioning.
conditioning charges. Total, it comes to around 13,000 and odd.
Was the amount fixed per month?
My lord, yes, 11,000 air conditioning was fixed, and the occupational charge, my lord, is, my lord, as and when raised by the, my lord, KMC, it was fixed for the time being, but
That was a rent, the taxes.
that is a
So
tax.
even if you don't have a good case on taxes, air conditioning, you are saying that it was not dependent on any variable.
No.
It was a fixed amount, and since it was essential for enjoyment of the
Enjoyment.
premises, as per your judgment, it should be included with that.
Should be included. Now,
That-
their
that-
argument, their argument is, my lord,
Yes.
that air conditioning, firstly, it is, my lord, a separate agreement. That is,
Yes, it is
the
connected with the electricity consumption and electricity.
electricity bill is separate, my lord. Air conditioning charge. This is for air conditioning of the, my lord, centrally air
So they
conditioning.
sought to argue that it is connected with the electricity variables.
No, electricity bill is paid separately, my lord. Electricity bill is
That is
separate.
your argument.
This is
Yes.
yes, my lord.
That
It is
electricity
the
bill
air
is-
conditioning charge, which is, my lord,
That's fixed.
fixed amount as per it was fixed enhanced from time to time. Right? Initially, another suit was filed previously when it was within the 10,000 bracket. The amount was 7,000.
Right.
Another suit was filed before this honorable court. That was, I mean, the notice was served under the Premises Tenancy Act, and suit was filed. That was a separate suit.
What happened to that suit?
That suit is pending. That is one of the points taken by them, that during pendency of that suit, you cannot proceed with this appeal. To that note, our submission would be, my lord, that during pendency of the suit, my lord, the air conditioning charge was enhanced from 2006 June. It was enhanced to rupees 11,000 from
So it went
7,000.
outside the party.
Went outside, my lord. So
You filed this suit from which the appeal arises during pendency of that suit.
during pendency of
That suit is still pending,
suit
but
is
you have
pending.
got this suit decreed and dismissed, and then you have preferred the appeal.
No, that suit has not been, my lord, disposed of. It is
So
pending.
the previous suit remained pending,
Remain
but
pending.
this suit was in the meantime
In the
disposed of,
meantime,
and you have
filed on a
preferred an
separate cause of action by virtue of the fact that the, my lord, amount was
Why didn't
enhanced
you
from
not
7,000.
press that suit? You are taking a chance in both the suits.
My lord, that was not done, but that will not invalidate the subsequent suit. My lord. It should have been done maybe, but that will not invalidate.
Order to rule 2 comes in.
My lord, if the cause of action is completely different, my lord. Cause of action there
Relief
was
sought is the same.
property
You
may
could
be
have
the
clubbed this. That is order to rule 2. You should have clubbed this cause of action along with that. Unless you could have converted that suit or clubbed this, could not have clubbed this cause of action with that.
could not have
It
been.
is
Because
contrary.
It was a separate notice, my lord.
Then you were
Separate-
taking a chance.
It was a separate notice, separate cause of action, and not separate suit was filed, arising out of a not separate cause of action, completely different cause of action. Because the previous suit was
This was initiated upon 106 notice.
106 notice.
So obviously the cause of action will be different.
Different. My lord. So we say, my lord, since the cause of action is completely different, my lord.
But then you are keeping something in reserve. If you lose this suit, you can go back to that suit again.
If the court holds, my lord, that it is not coming, if it is not part of the, my lord, rent,
Yes.
and it is governed by, my lord,
Then you have that
Tenancy Act, my lord, then so this is the position, my lord. But we say that, my lord, since completely, my lord, different cause of action arose by virtue of the enhancement, which is admitted,
Different cause of action, put it in your read notes of argument.
my lord. And, my lord, so far as, my lord, the argument that's a separate agreement, my lord, we say, my lord, that it is part of the, they are paying it to us. it is paid through one urban services
That,
company.
yes.
So they are the collecting agent, but the amount they have admitted, I'll show the admissions. They have admitted that they are paying the rent or the air conditioning charge to us. There's clear admission to that, and admission to the fact that without the air conditioning, the tenancy cannot be enjoyed.
No, regarding the first admission shows that
My lord,
they're paying it to you.
my lord.
If it's a different arrangement altogether with urban whatever.
It was not a different arrangement. I'll show me the pleadings, my lord. Kindly comes to me, lord. The
Show us the pleadings and
I'll show the pleadings.
put the page numbers in your written notes of
My
argument.
lord.
Just put the page numbers.
Page 13 of the paper book, first paper book, FA 66.
Yes. Yes. Page 13.
Paragraphs, my lord, 5 and 6 are the averments, my lord, regarding the rent being paid to us.
That is your plaint.
Paragraph 4, 5, yes, my plaint, my averment 4, 5, 6.
Yes.
Case made out that they are paying the rent to us. Now, my lord, if your lordship takes up the written statement, which is, my lord, from page 20. No, my lord, case has been made out. That is a separate agreement. It is not payable to you.
Yes.
They have to then make out that case. So kindly
therefore-
comes to me, lord. Reply to that. আমি যেটা পাঠালাম টাইপ করেছো ওটা আমি যেটা পাঠিয়েছিলাম ওটা শোনাও।
Page 38, paragraph 7 of
Page
the written
38,
statement, they have
my-
categorically
My
stated.
lord. With reference to the allegations contained in paragraph 4, it is specifically denied that as on June 2006, as a tenant of the suit property, defendant became liable to pay 13,000 per month. It is specifically denied that apart from
But that denied that the monthly air conditioning charges
Yes.
either could or ever formed part of the monthly rent.
monthly rent. So they have not made out any positive case that it is a separate agreement. The case that they seek to make out now is
Agreement you have not mentioned in your plaint, so why should they make out a
we
case?
have said that not it is the total rent.
Agreement is a part of the evidence. So they need not plead evidence. You did not plead the agreement. If you had pleaded, they would have dealt with it.
We have said it's a composite. Not
You said it's a composite
It is
amount, they deny
payable
that
to
and
us.
they say it's a different amount.
They say this amount is not part of the rent. That is the
So if
only
you did not mention the agreement in your plain pleadings, why should they deny? There is nothing to deny. You don't rely on the agreement in your,
I'll
don't
just
mention
show
the agreement in your plaint. It has come up in evidence only.
Kindly comes to me, Lord. Paragraph.
Where is the admission that you said there is
Yeah.
an admission?
Paragraph. Now, kindly come to page 32, my lord.
Yes.
Paragraph 32, page 32, paragraph 18, Roman 18.
Yes.
On August 3, 2007, defendant handed over 2 checks bearing check number so and so, both dated August 3, 2007, for a sum of rupees 11,000 and 3,000 respectively, drawn on Union Bank of India, being monthly air conditioning charges and electricity charges. Defendant also made over 2 further checks, both dated so and so, respectfully, and the same were duly received by the plaintiff. So they are paying to the plaintiff. And my lord, 17 also, the previous paragraph. The previous page, paragraph Roman 17 also. They have said that they are paying to the plaintiff.
Where is that? Which paragraph?
The previous paragraph, paragraph Roman 17. Here also, in the meantime, plaintiff had accepted 3 checks of rupees 11,000 each, and further 3 checks of 3,000 each for monthly air conditioning charges and electricity charges. So this shows me that the electricity charge is separate. Air conditioning is different. Roman 17 at page 31, my lord. Page 31.
Yes. This is a part of which paragraph we are trying to look into that.
Well.
2.
paragraph 2. Page 31. 66.
Is it their case that subsequently they started paying to Urban?
No such
No,
such case.
nothing of that. Very well. Very well.
So, my lord, this is the one first admission. The other admission is not.
Page is not telling.
66, paper book 1, page 32.
This is FA 66, Mr. Sarkar. FA 66 paper book.
Pages are not actually.
Page 31, 32.
31, 32. Roman 17.
31, 32, Roman 7.
Okay. Styling.
Yes. What next, Mr. Banerjee?
Next is, my lord. Kindly come to page 88.
Yes.
Or rather, my lord, 80s. 80. Yes. First line is the defendant firm is paying 11,000 per month for the AC and 3,000 for the electricity consumption. Then
But the previous paragraph says since the time of urban
urban
services,
services.
firm has been enjoying electricity and AC.
So
And this does not say that they pay to you or for you.
no, but the written statement that I have shown that they
Written
have,
statement you have shown, but this sentence does not say so.
this will not specify to whom it is paid.
No, before the cross examination, page 87,
My lord. Page 87, last paragraph.
he says two challans showing payment of rent, electricity, and air conditioning by the defendant firm in favor of the
Favor of the plaintiff company. That is not. ওইটা বার করো। No, এটা কোথায়? Without electricity, ওইটা লিখে রেখেছে। Kindly come to page 91, next pillar. Page
90?
91.
91.
Last 2 lines.
Yes, yes.
It is a fact that without air conditioning,
That they admit.
so it is an integral part of the tenancy to not show that we have relied on this. So, the contention of separate agreement, my lord, we say is not founded on any pleading or evidence, because the checks are also, my lord, they have tendered, my lord, checks. This paper book 2, my lord, part 2.
Part 2.
Part 2, my lord. Check
Yes.
check গুলো ছিল। I'll find out the page, my lord. The check. Check-এর পাতাটা check গুলো ছিল বার করো। Page 3 is the bill raised by Silica, the appellant. Page 3. To Advana.
Yes.
So, my lord, bill was raised by, my lord, the defendant. They were page 3 of paper book 2. And, my lord, page 5 is the letter by which defendant is sending the check to Silica. Silica is the appellant, my lord.
But those checks were in the name of this urban.
But they were the collecting agencies, my lord. The urban collected, my lord, but the checks are raised by
Any
Silica.
of the checks were exhibited.
I'll just not kindly give me not 2 minutes, my lord. তুমি আবার দেখো চেকটা দেখেন না অ্যামাউন্ট না চেক গুলো কাছে কিনা চেক গুলো they have been exhibited or not দেখো bills and letters আমরা চেকটা পারলে দেখো দেওয়া আছে কিনা No, this is the extract. Check থাকলে দাও। The check not possibly is not exhibited.
Check was not exhibited.
Check. Now the next point taken by them is Lord. এটা দাও note করো। First is not that tendency of the suit, to which our submission is that not it's a completely different cause of action, different notice. Second is two agreements.
AC different agreement.
But no, we say that not it was paid to. Bill was raised by us, paid by us, and they agree admit.
Yes.
Now the next point is, my lord, they have said that not rent for the purpose of my lord collection and not.
Apparently rain has stopped.
Right.
Apparently rain has stopped.
No, it's raining heavily.
But you and Mr. Bhattacharya come in. The Sarkar was feeling helpless.
ওটা কি করবো? হ্যাঁ তোমার দেয়নি বলেছিলাম no we shall not keep the baggage. The other argument is, my lord, rent for recovery and my lord for the purpose of section 3 are different. That argument has been not sought to be made. ওটা কি বলবি rent হ্যাঁ না ওটা are you prepared on that point? Admission
That Mr. Banerjee was probably in respect of municipal taxes,
my lord,
not AC.
no,
AC is a different concept.
if
So you are even without that municipal taxes component,
without
you
that
still
also
the AC component would take it outside.
take
the
it
pot.
outside 2000 plus 11,000.
That's his admission.
I've shown the admission. So not and beneficial, necessary for beneficial enjoyment. So not this argument that is defined for the two purposes, this will not help them because of the reason that only the air conditioning charge will not takes it outside the scope.
It's a part of rent.
I think আর কিছু বলা reply? So not these are the points not dealing with their points.
So if you want to file short written notes, if
We shall.
you said you wanted to.
Judgment is distinguished করে দে করে
দুটো municipal tax আমি বলেছি
ওটা
না
দেখুন করে আমাদের নেই এখন
CPR hotels was on municipal tax.
ওটা আমাদের নেই আমি দেখিনি কি বলো তো মানে he'll just not deal with kindly allow him to not deal with the judgment not cited by
Dealt with it, Pilot. If your lordship remembers that East India Hotels judgment, which my learned senior friend, that was on municipal taxes.
Yes, municipal taxes is a different
It's
yardstick.
a completely different yardstick.
That was on rent, including municipal taxes and rent for the purpose of. That was on this point only.
Yes,
the last
absolutely.
so that
We'll use
short. Mr. Sarkar, you have already filed a written notes of arguments opening. You qualified it.
Opening submissions that can be treated. If lordship wants, we can file a detailed notes on arguments.
What can be more detailed?
What I've indicated is the bullet points, what they call in.
No, we want bullets only. We are accustomed to bullets.
Nowadays. The world is getting accustomed
Yes,
to
we
bullets
don't
now.
want a larger explosion.
Lordship,
Bullets would do for us.
as
Very
your lordship.
specific, hitting the right target.
And lordship.
So you have given your bullets. Let them.
Lordship.
Yes, Mr. When do your bullets come in? If these are the points, no bullets are required. In fact, but if you want to make it,
It's up to your lordship. Lord. If your lordship wants, we can.
these are the 3 points. Previous suit, you say separate cause of action.
Completely.
AC, Mr. Banerjee has placed in detail in the written statement. He says there was an admission.
Basic point is those previous suits were at a time when the component was less than 10,000.
Yes.
And now, my lord, moment it went up to 11,000, and this is not variable.
But you have not given up on those suit. You have taken a chance by keeping both the suits pending.
Lord, in my respectful
Why
submission,
should order to not rule to not come in? Because
separate cause of action complete.
cause of action separate definitely, but
Then order to rule to doesn't.
reliefs you are seeking the same.
Relief will be the same, but the gamut of the relief will
Let
change.
us once see language of order.
Have a look at.
Just bring out the CPC there. Just we have to check that.
করবো কেন? আর আমরা withdraw না করলে, there was one decision which said that every day I could have filed a suit if there was a cause of action, because it's a continuing cause of
No, but not in case of this premises tenancy is a specific cause of action, and here also 106. It's a 106 suit.
Yes, my lord.
Specific causes of
The
action.
other one was under the premises tenancy act.
We hope that is not a division bench judgment.
No, no.
Because this is a specific cause of action. 6-5-6-4 now. Previously 12.
Wow, no.
Then you have to give every day. You have to give notices for eviction. Order to rule to
Every suit which shall include the whole of the claim which the plaintiff is entitled to make in respect of the
no
cause of action.
rule 3 rather.
My lord,
Rule
When a
rule
plaintiff
both are on reliefs and causes of action.
different. My lord, in that suit, if I had not prayed for something which I ought to have prayed, then my second suit is barred. So here, my lord, my cause of action is Transfer of Property Act, and there was Premises Tenancy Act. So order to rule 2 in my respectful submission doesn't, my lord, lie at all.
But 2 says relief also.
Yes,
You have to, but the whole relief you have to.
on the basis of the cause of action, my lord.
All right. So you file, you would file your written notes of
Up to
arguments.
your lordship,
No,
your
then
lordship.
they need not. This is sufficient.
Fine.
These are the 3 points, basic 3 points. So we'll close arguments, Mr. Chairman. Right now.
3 sentences.
Why 3 sentences? Reply to reply.
Well,
Then it will go on reply to reply to reply to reply to reply ad infinitum.
well, what is good for the goose must be good for the gander.
Yes. Are you meaning the judges or the
No, no, my lord, we, my lord, when we cite, my lord. So, only decision cited by the appellant is Popat Kotecha to show that whatever you pay, that is rent.
No. They probably, my lord, my learned senior friend missed out that inside Popat Kotecha, there was another decision which was quoted. Sushma Ghosh.
Acha, we want a clarification on this. Mr. Shorkar,
Lordship.
you have you are relying only on the judgments which are mentioned in your points of submission, right? You are not going beyond that. You did not cite any other judgments, we hope.
Possibly no.
Because there are several judgments you have mentioned there.
Yes, yes.
One was not relied on, that is 1988 SCC online. You said you are not relying on.
Thank you.
The rest are mentioned in your written notes of arguments. You are relying on those. We have taken our notes also on those.
Lordship.
And Mr. Chatterjee, you are relying on 2018 9 SCC 149.
My lord, and
Popat Kotecha.
inside
Popat
that-
Kotecha.
Popat Kotecha and
And
inside,
the judgment inside that.
yes, my lord, because I did
What
not,
was that judgment?
Lord, it was 1990 volume 2 SCC 651. I did not cite that because the entire
Did not.
judgment
You
was
just give us the
there.
paragraphs of Popat
Paragraph
Kotecha.
3. Popat Kotecha judgment.
Para 89 and 91.
No,
No, not that. That is something else. Sorry.
For that one, my lord, is paragraph 10
You are relying on para 10.
of
Three-
Popat Kotecha.
3 and 10.
3, my lord, in the Sushma Ghosh judgment.
Acha. All right.
That is quoted, my lord, in this judgment.
Para 10 is what you are relying on. Popat Kotecha.
That contains Sushma Ghosh, that it's a compendium of charges which is to be paid for the enjoyment.
Yes. Sushma Ghosh was mentioned. We recollect that. What are the 3 sentences?
One. So, Popat Kotecha was cited
Rent.
to say that whatever you pay is rent. Now, subsequent development is Section 3 of the Westbengal Premises Tenancy Act came of consideration before our single judge, before Honorable Division Bench, and before the Honorable Supreme Court.
You have cited those judgments.
Lordship.
Yes. That
Supreme Court
rent for the
say-
purpose of recovery and
Lordship.
difference.
Lordship.
Yes. You have categorically
So-
mentioned. That's a
so-
part of your arguments also. Did
So,
not-
now, Sushma Ghosh has merged into Kotak Popecha.
Yes.
So, if we see from that angle, that for the purpose of recovery and for the purpose Section 3, the concept of rent is different, they not Sushma Ghosh also falls into that.
All right.
And Section 5, subsection 8 of Westbengal Premises Tenancy Act.
That was considered in those judgments.
Lordship, that's a
Considered in
concept.
those
5-8
judgments.
is
3 read in context of 5-8.
Right.
In the judgments itself, those are considered. We have gone through. those.
5-8 says municipal taxes,
Yes.
but air conditioning charge is totally separate. And in our case, my lord, documents
Rent in 3 does not mention this.
cannot be added.
Mr. Gupta is satisfied and Mr. Bhattacharya? We are not concerned with Mr. Shorkar. He is a creature of instruction. You're also satisfied? Then we are closing arguments. Yes, Sharath. Here, heard learned counsel for the parties. First of hearing is concluded and judgment is reserved. What is next? আমার আগের বার যখন করেছিল তখনই ওয়ার্কআউট করে
End at some point of time.
Not just good things, but bad things as well.
গাড়ি খারাপ হয়ে গেছে item 17
Lordship, I'm for the respondent.
yes
Mr. Banerjee was arguing in this matter, my lord, on behalf of the respondent.
yes
There is a breakdown in his car in Ma flyover. He is praying for an accommodation for 10 minutes, 15 minutes. That is what it is parted better. I know, my lord, it cannot be adjourned. I know the predicament, my lord.
now he can veritably argue that mere paas maa hai ma flyover as in the flyover
This is a difficult.
if he has mother in his side then we have nothing
My lord.
But can he
Very
passes it over for
no passover acha very will pass over if he comes I mean,
কটার সময় বল?
Yes,
yes very we are
it is-
passing over you are
he
right
will come after 11:30. The advocate on record has gone to
we are
rescue him.
making we are passing it over if because we don't know the whether today if some other large matter is called on then it's all right we are passing it over for the time pass over kore rekho pass over
Lordship.
whenever he comes just inform Mr. Ali and just come and try to
Great.
yes
Kindly, Lord, takes it up next week.
next matter no your matters don't adjourn. We have got you we generally don't get you you and Mr. Rai together rarity nowadays so every good thing must have a start also no we are starting
It's a probate matter, my lord. I
no
haven't.
no
been
appeal hearing day we are not leaving anybody whom we are getting within our within the range of our control
The
if
problem
you
is
come
that-
into our courtroom you are trapped it's a valve
Just for today, only for today.
no you are the appellant no let him start yes.
Then let him continue.
You can argue extempore. Most of the matters you already argue extempore, Mr. Don't come prepared and you argue extempore in any event. So it's not a new thing for you.
My lord, can you defer?
Mr. Rai comes prepared.
My lord, can you defer with this?
No,
at
don't
least
defer.
have some
My
sort of
learned brother is absolutely with me.
sympathy on me.
No.
Some sort of sympathy on me.
No. If he starts having sympathy, then tomorrow, if my learned brother has empathy with you, it will be difficult. It will be difficult. Then we'll have a difficult bench. Yes, Mr. Rai, you start.
Let
He
him,
will prepare himself during arguments. Mr. Chatterjee prepares.
he
Yes, sir.
probate,
Sufficient experience at the bar.
probate.
We have conferred a gown. Be satisfied with that. This is the reason we have conferred a gown, so that we cannot escape us.
One appeal in.
Oh, you will also ask for a prayer there. Ask for an adjournment there.
Cannot because it's.
So I know what
into
you. No, we have seen through your.
I said, looks to the live streaming from your lordship's device.
No. Yes. What is the matter about? You are the
I am the
plaintiff.
plaintiff. Plaintiff is a probate.
You keep somebody, Mr. Chatterjee. You keep
That's exactly. Kindly sees nobody.
Keep your clerk. Will hear you. We'll hear him. Keep your clerk. We don't have any difficulty. We don't have any ego problem. He can address us also.
না কিছু বসতে হবে না আমি আছি
Put a wooden post, Mr. Chatterjee. Let him start. Put a wooden post. The wooden post will take notes. Whenever you come back, you'll start arguing.
So what I can do is that I can in the evening look to the live streaming and see what Mr. Rai
You won't get till the evening. Mr. Rai is very fast.
very fast.
Yes, don't underestimate the power of the Rai. Yes, Mr. Rai. What is the short point involved? Against probate.
Against probate.
Ms. Agarwal, your penalties you have to wait for the rest of the day. But you have made it not today.
Otherwise also I'm ready after this matter.
No question. You have made it not today and you have made probably caustic remarks also against you. Check up the server copy. Yes, Mr. Rai.
Now that I know you also will not impose the cost.
Not so caustic, but sarcastic maybe.
No, that will, I will take as a compliment.
Mr. Rai, you start. You save us from the other submissions
What are the
of
original?
Ms. Agarwal and
This is
Dak.
Prabhat Sarkar. One Prabhat Sarkar was
But was granted.
refused.
Prabhat Sarkar's will.
Will.
You are the,
I am the son.
they are the widow and the daughters.
Yes.
Usual formula.
Usual.
So what is different?
The difference is that why not initially is two wills are there. Instead of one will, which is in favor of the son, a particular property mentioned that in this will I want to give this property in favor of my son. Subsequently, another will was executed by Prabhat Kumar Sarkar, stating that earlier will I gave this property to my son. So these are the properties I now want to give to my wife and my daughters. These are the two wills which are prevailing. Now, my lord,
No, their will was probated.
no, they did not apply for probate.
Your will was earlier.
My will was earlier. Now, my lord, what is which will be the last will? No, that is why in the subsequent will it was categorically mentioned that by earlier will I have given this property to my, and excluding that property, the remaining property.
Oh, then it is immaterial.
That is what one is taking the vaccine.
Yes.
So on that,
Mr. Shanal has something to add, which is different from what you said. No. Yes.
Well, can I turn to?
What is the ground? Basically, what is the ground on which it is?
So, but the objection is taken in one stage. The objection taken that the subsequent will, so the earlier will cannot be probated.
Yes, yes, please comment. Yes, yes.
Subsequent will cannot be probated.
Yes.
Earlier will cannot be probated.
But that is your defense, as you have said.
Yes.
Different property.
Apart from that, in the written objection, nothing has been stated.
Was the second will exhibited?
Yes, yes.
So we'll find out from that by a comparison.
Not only that, the scribe of that will also admitted, yes, he has executed the earlier will. Now the question is, what in the evidence it was said the scribe put the signature on the date of the execution of the will. Subsequently, it appears, my lord, your lordship, can you turn to, because that is the main thing which I want to draw lordship attention. Can you turn to page page 1 of the exhibit part, last document is the will. It is necessary why, my lord, I am submitting, my lord, if it technically. Page 1, your lordship will find the date of the notarial certificate. 27, 2004, my lord, got it?
Page 1.
Yeah, exhibit part, my lord, exhibit part, last.
Yes. Page 1 is this.
Last.
Page 15.
Yes.
That is page 15.
Page number
Oh.
Not page 1, page 15.
Two wills are annexed, lordship, lastly.
Page 1 is something else from what you're saying. My lord is looking at page 15.
No, not. May I? Notarial certificate. My lord is
at page 15.
Yes.
Exhibit part.
Oh, but my I beg to
Part 2, page 1 is something else. The application error. Anyway, we've got it. Yes.
The date of the notarial certificate my lord is 27th. My lord got it?
Yes. Notarial certificate. 27th.
At the bottom, 27th September 2004, my lord, at the bottom.
Yes.
That exhibit is.
Yes, 27.
Because
the pagination is peculiar.
No, there is an exhibit. Two wills are being exhibited separately. That's why, my lord, it was.
This is your will.
This is my will.
Yes.
The date of notarial certificate on 27th September 2004. Now, if your lordship may kindly turn to page 4. That is the internal page of the will.
Yes.
Your lordship will find the date of the execution of the will is on
This
10th
is
September 2004. 10th September 2004, my lord got it. At the bottom,
yes.
এক নম্বর তফসিল পরিচয় মৌজার before that line.
Yes.
Now, my lord, can you turn to the signature portion, page 8.
$27,900.
These are the attesting witness, my lord got it, Bhakta Mondal and Meher Ali Sheikh. Left hand side, my lord will find এই উইল খানি লিখিতাঙ্কে অর্থাৎ দাতাকে পাঠ করিয়া শুনাইলাম নির্দেশ অনুসারে আমরা আমার কর্তৃক ড্রাফট করা হইল। This is a signature of the learned advocate who have drafted the will, that is
What
Binoy
is the signature of the testator?
at the top.
No, at the bottom there is no signature. At the conclusion of the will, there is no signature.
It is on the
And she does not sign. She has to sign in a place where, as per the provision, she has to sign in a place where it would indicate that she intended this to be a will.
in the top all the pages.
Top all the pages, but that can be manufactured.
Yes, I could have understood that.
The will ended, she has to sign there, either at page 4 or page 8.
It is only on the top.
That is suspicious, Mr.
Yes, I could have understood. If that is suspicious, I could have understood. I can explain. But what was the suspicion and what are the grounds taken, that I have to explain before your lordship.
Yes.
Now I can turn to that page. Shubinoy Ghosh, my lord got it.
Where? Which page?
The signature.
Yes, signature. Shubinoy Ghosh.
The date your lordship will find, this is advocate, 27/9/2004.
Yes.
So these are the dates which is because I showed to your lordship because of the ground, but this is the dispute which has been mentioned by the court below. Date of the signature of the learned advocate or the
and
scribe.
Something else is also important. There is a signature of the executant attested by me on 27/9. The notary says that.
Yes.
But that was not marked probably as an executant.
No, it is not marked. Identified by Shubinoy Ghosh.
Not only identification, below that.
Below that, the
stamp of the notary.
Yes.
The notary's stamp is signature of the executant attested by me. That date is 27/9. Anyway, that does not mean that.
It was not. Below to that, my lord, your lordship, only identified by below that, my lord, your lordship got it.
Yes, yes.
Shubinoy Ghosh.
That you have seen.
That is the date is because that date which was doubted by the learned court below. Why, my lord? Now, my lord, can turn to next page. The next will which have been produced.
This is the second will. There.
Second will. There will.
Yes.
At the top, my lord will find.
Yes.
And the last 1, 2, 3, 4, 5, 6, 7, 8. 9 lines from the bottom of the said will, my lord.
Yes, we have seen 10/9 তারিখে সংশোধন.
Yes.
Yes. So this was exhibited by them. There.
From there. Now, my lord, can you turn to their objection?
But then, Mr. Rai, there is a suspicion. Their will says 10th of September 2004 that was executed. This is a subsequent will. So if it is executed on 10th of September 2004, how come then the testators, the attesting witnesses signed in her presence and vice versa? The attesting witnesses, they signed on 27th.
No, that is the date which has wrongly been mentioned. That is why, my lord, because at the time.
How can it be retrospective? I mean.
No, it was initially it was executed on 10th. Subsequently, notary certificate was obtained. That is the case made out. It is not a case I could understand blank paper. That is why my lord Kali considered the what is the
Case is that the will was executed on
exam
10th.
10th. Subsequently, it was identified and put before the notary. Notary certificate was obtained on 27th. If your lordship can turn to the objection once, after that I'll objection. If your lordship can turn to objection, page 60.
Page
60. It starts on page 60. I'm drawing lordship at page 61, paragraph 7.
written objection.
Written objection.
Yes.
The statement paragraph 3 of the petition are totally denied. The statement of the para that the written the writing annexed herewith is the last will of the deceased Prabhat Kumar Sarkar, and the said will was duly executed and also duly attested by the witness. The deceased Prabhat Kumar Sarkar and the said will was duly executed and also duly attested by the witness. The executed Prabhat Kumar Sarkar was physically fit and mentally alert. This was the denial. Now, my lord, paragraph 10, the specific case which was made out. The site is submitted where Prabhat Kumar Sarkar was the owner of the property described in the schedule of the petition. Prabhat Kumar Sarkar during his lifetime came to understand that the relation between only son Pradipta Kumar Sarkar and his wife Sevali Sarkar and 3 daughters, namely such and such, are very bitter and unmanageable. He also felt that the petitioner will create various troubles in inherit the possession of property by his wife and daughters led by him after his death. So, he protect the preserve the security interest of the wife daughters. He executed will on 23rd March 2006. My record that the corresponding to 9 Chaitra in respect of 50% of his share in the properties as described in the schedule of the petition in favor of the in their favor in presence of 3 witnesses, Apurva, Meher Ali Sheikh and Nirmal Kanti Sarkar. And the same was drafted by Nirmal Kanti Sarkar and notarized by Rabindranath Ghosh, which was the last will executed. Any will in respect of his property.
What is German here is 50%.
Yes. And no, there's cases that it is not the last will, but the will executed in their favor is the last will. So this, it is not a case that it was created on a blank paper. Or it does
No, what is important for you is 50%. Therefore,
that is the only thing.
even if this is the last will, you are admitting that. Last
Yes.
will, but in respect of the rest of the.
That's 50%. That is the thing. Because in the objection, my lord will find this is the only objection which was taken. Now, my lord, kindly turn to the evidence of attesting witness, your lordship can turn to page 79.
79.
Out of these 2 attesting witnesses, my lord will find Meher Ali is the attesting witness of both the will. In their will also, in our will also.
Who is Bhakta Mandal?
Another attesting witness, my lord. Last, page 79, last 3 lines. I signed on the said will. My lord got it. As attesting witness. This is the said will in which I sign as an attesting witness. This is my signature on the last page of the said will. As per instruction of the testator Prabhat Kumar Sarkar, the said will was drafted by Shubhinay Ghosh, advocate. After the contents of the will was read over by Shubhinay Ghosh, advocate to Prabhat Kumar Sarkar, the testator, and after it was explained to him, the testator Prabhat Kumar Sarkar signed on the will by putting his signature in my presence. After the testator put his signature on the said will, I accordingly put my signature thereon in his presence as attesting witness. When the testator put his signature on the said will, he was physically fit and mentally alert. I cannot say after the drafting of the will by Shubhinay Ghosh, advocate to type the said will. This is my signature on the said will as my attesting witness. The signature witness of the mark exhibit 1. The said will of the deceased Prabhat Kumar Sarkar exhibit 1 by 1 with objection. Now, my lord, the consider cross-examination.
Yes.
Page 81, my lord, these are the question put forward. Where is it?
Conveniently vague. Month of September. So month of September covers both September 10th and 27th.
Apart from that, anything to the extent that this is not the will. It was executed on blank paper, subsequently it was converted to the will. If that be so, my lord, then my lord, there cannot be any signature of the person and the will.
They don't have a case in the written objection that it was a blank.
Nothing.
That is not there in the written.
My lord, I have to prove the execution. The place of the signature, my lord, is not very well. That is, but for the purpose of satisfaction of the court, irrespective of fact whether they took that objection or not, being a probate court, I have to clear the conscience of the court also. Therefore, I draw your lordship attention to both the wills. It is the practice of the person who has executed the will at the top corner of the.
In the second will also, she did not sign at the bottom of the will.
That probably could have been signed, but in the top there is signature is there.
She has signed at the
Yes.
top. Everybody signs, but at the bottom it should be signed to indicate that. In the other will, he has signed at the bottom.
Yes, that is why, my lord, this 10/9/2005 was already mentioned there, and it's clearly mentioned which property he has given.
All right.
So if they relied upon that document,
They don't have a case that any other alternative will.
Yes. Now, my lord, so for the cross-examination of the attesting witness, my lord will find.
Property আলাদা property আলাদা শুধু করেছে সে যখন যুক্ত দিয়ে দিয়েছে নথি যুক্ত দিয়ে দিয়েছে but then let us take the marginal case. I mean, let us accept your case. It was executed on 10th, attesting witnesses signed on 10th because there is no date of signature beside the attesting witnesses to show that it was signed on 27th. No, nothing there. Only thing is that the scribe, he signed, gave the date of signing as 27th, the date of
That's the only thing.
The scribe then signed on the date of the notary, on the date of notarization.
Date of the execution put his signature. That is why, but the date which is appearing in the subsequently is 27th. That is for the purpose, my lord, for identification. Why, my lord, I want to dispel the suspicion, my lord, at the bottom, my lord will find was identified. If your lordship can turn to page 8 of the last portion, my lord. At the bottom, my lord will find number 21 at the bottom, left hand side bottom. Page 8, left hand side bottom, my lord will find. That is the, and it has not been put. I could have asked Mr.
The date of the signature was not put on the date when it was executed.
He is executed.
Date of the notary, he grew
Yes, it was identified as if this date was, whether this date was put by the Subinoy Ghosh or not, that is also not clear.
He grew wiser or more foolish, we don't know, but
More wiser, that was given. I could not understand that this question was put forward, any cross-examination to that effect, nothing. It is a third case made out by the court for the purpose of adjudicating this issue. That is why, my lord, what is the question put forward by the cross-examination, my lord will find. The will was drafted by Advocate, my lord. May I read out, my lord, page 81, the cross-examination of PW2. That is the.
Yes.
Or my lord has gone through and my lord is of the opinion there is nothing question put forward to the PW2 in cross-examination.
It was not.
There is no question put forward regarding the execution, attestation, nothing. Mental capacity, because mental capacity, they cannot say that subsequent to the will created in their favor was subsequent to that.
There was only PW1, your one witness.
This PW2.
Sorry, PW2, sorry, yes. PW2 is the attesting witness.
Yes. Now, I can turn to PW3, who was another attesting merely because he was the attesting in both the wills. That your lordship, page 83. My lord got it, page 83.
83, yes.
The last paragraph is the compliance of that in presence of something, my lord. May I read out after that? Next page, your lordship will find the signature witness of the will is marked Exhibit 1/2. I signed on the said will as an attesting witness. Another person, namely Bhakta Mondal, was present at that time. Bhakta Mondal also signed on the will as an attesting witness. When I put my signature along with Bhakta Mondal, Prabhat Sarkar informed to us that he saw us putting our signature on the will, and Prabhat Kumar Sarkar had signed on the will. Myself and Bhakta Mondal were also present at that point of time. The will was drafted, Adil Kumar De. Then the witness said will was drafted by Shubhinay Ghosh, and notary of the will was Adil Kumar De. The will was finalized after seeing the draft of the will. Shubhinay put his signature on the final typed copy of the will in my presence. This is everything comes, my lord, these two lines. My lord, can mark this portion, my lord, because the court below has taken an adverse inference regarding this.
Please, which one?
The Shubhinay Ghosh put his signature on the final typed copy of the will in my presence.
No, you say the signature was.
Yes, yes. That is why, my lord. That is why precisely why I'll argue, my lord. This is the signature Shubhinay Ghosh on the said will. The signature of Shubhinay Ghosh is marked Exhibit 1/3. This is a will which was executed by Prabhat Kumar Sarkar, and has already been marked as Exhibit 1/1. Now, my lord, the kindly consider the cross examination.
Yes.
I cannot collect fourth line from the top because the first of the addresses and other things.
Yes.
I cannot recollect and say at this moment where Bhakta Mondal resides. I know Advocate Shubhinay Ghosh because he is the ex such and such, as well as he is a lawyer. But I cannot say in which court he practiced. Shubhinay Ghosh initially prepared a hand, my lord, it is handwritten draft, and subsequently it was typed. I cannot recollect and say whose handwriting the draft was prepared. The court, Shubhinay Ghosh has prepared the handwritten draft of the will. I cannot say at this moment who typed the will. I did not go through the contents of the will. W miss. It is fact the date of the execution will is 10th September 2004. I cannot recollect the said date when the will was typed and executed by Prabhat Kumar Sarkar. I cannot say date when this will was drafted by Advocate Shubhinay Ghosh. In this will, Bhakta Mondal signed before me as an attesting witness. I cannot say the schedule of the parties mentioned in the will or which parties are bequeathed under the will. I do not know the wife and daughter of the this is Prabhat Kumar Sarkar. I can recollect from my memory and say whether I signed on the will as attesting witness executed by the deceased Prabhat Kumar Sarkar on 23rd March 2000. I cannot say whether the signature is myself or not. Not a fact that my statement of Prabhat Kumar Sarkar executed a will in favor of Pradipta Sarkar is false. Not a fact that my statement as Shubhinay Ghosh advocate drafted the will as per instruction of the deceased Prabhat Kumar Sarkar is false. Not a fact my statement after drafting the will Shubhinay Ghosh was read over and explained to the deceased Prabhat Kumar Sarkar is false. Not a fact my statement that after will was read over and explained by Advocate Shubhinay Ghosh to the deceased Prabhat Kumar Sarkar who executed the will in my presence is false. Not a fact my statement Prabhat Kumar Sarkar who saw me to sign the will as an attesting witness is false. The fact my statement that I saw Prabhat Kumar Sarkar to execute the will is false. These are the suggestion, my lord, to that effect, my lord. And turn to the next page, 87. The question put forward, and which is not a fact that after death of Prabhat Kumar Sarkar, I signed on the will of the Prabhat Kumar Sarkar on request of his son Pradipta Sarkar after the death of Prabhat Kumar Sarkar. So this was the question put forward. So the execution, if I take it into this question to be the admission on their part by saying the will was executed, my lord, may I consider this question in such a way?
It's your consistent case that the will was executed on 10th of September.
Yes.
And he does not say that 27th, the scribe signed on 27th. There is no admission to that effect.
That is
so your case is, if you could understood you correctly, correct us if you are wrong. Will was signed was executed on 10th of September 2004 when everybody signed, including testator, scribe, attesting witness, everybody. Subsequently on 27th it was notarized. There was no date put beside the signature of either the scribe or the attesting witnesses or anybody. On the date of notarization on 27th, this scribe, he was the identifier also. He put a date against the identification erroneously to put a seal of correctness probably. He put a date to the signature
under the seal of
in consonance with his identification.
Of the date. That is
the only
error
mistake he committed.
That is right. That Malar Kali Tata, I am not disturbing a lot.
This is your case.
It is my case. And Namal Kali consider how the learned
also you say that in their written objection they did not make out such a case. In the cross-examination, they did not make out such a case
Such a
that
case.
he signed on some other day the scribe signing. All right.
On
What
this
else?
basis, my lord, can I turn to the judgment in 105, my lord. This is the sum and substance of the objection, cross-examination, and the deposition of the witnesses also. Page 106, my lord. Petitioner case can be summed up in the following words. Page 106, my lord, placing from 106.
106, huh?
As your lordship, or
Did not.
then my lord can turn to 109. These are with reasons.
These are also not clear. We have underlined the portions. You point out if there is something else in the pages you want to. Each of the pages we are just indicating what we have underlined. Page 109 at the bottom, PW1 did not make any utterance as to the date of execution of the will.
Yes.
He need not because he's not one of the attesting witnesses. Bhakta Mondal, one of the attesting witnesses. Next page, contents of the same were read over. So 63 compliance is there.
Compliance,
Subhanaya Ghosh put his signature, everything is there. We have underlined the portions where 63 compliance have been highlighted. And page 111, executed a will on 23rd, bequeathing 50%. 50% you highlighted for that purpose,
For that purpose.
different property. Next page, not the last will has been stated somewhere midway. And page 113, 50% reiterated. Page 113, second paragraph, transpires the testator has mentioned in the will about the execution of another will dated such and such, because some properties you highlighted.
Yes, some
50% telling is some
and it is their admission also in the objection that 50%. Well,
yes. Next page, nothing of importance. Learned advocate says and such and such. Page 115, let me examine.
yes.
After that, he says, I find that in the contents of the will, it is specifically mentioned, Prabhat, executed on 10th of September.
Yes.
From evidence of DW1, again to 50%. From contents of the will dated 23rd, comes into picture, Prabhat Sarkar had specifically stated that apart from the properties which he had, apart from the properties you highlighted,
Yes.
and other properties in the next page you highlighted, clear picture. End of page 116, question which arose.
Page 115, you will lordship the middle portion.
Yes. I find that the contents.
Yes, I read we examine whether the will dated such as executed Prabhat Kumar Sarkar is prior to the will executed such as such.
Middle of that page, I find
Yes,
that in the
yes.
contents of the will. That we said we have put a margin, note on the margin. 116, other properties again.
Yes. Now, 116, your lordship will find what is the argument advance? My lord, can you record that? What is the argument advance by the learned advocate for the cities? The argument on the issue that the will of the testator is that executed on 23rd March and such.
Their premise was second will.
Only second will.
Second will.
So argument was advanced not on the ground that the signature was not there and it has not been executed. Now, my lord, can you consider page 170, subject to question, probably, my lord.
Recidenda is not squarely applicable, court says itself.
Yes. That's squarely applicable. On consensus, I do not feel any anything of hesitation to surmise that the contention of the respondent side is will dated such and such is the last will. It was disapproved and held. Yes.
Genuineness then.
Then this is the page 118. This is the only thing which court now, my lord, make out for the first time.
So you say this is the third case also?
Third case also. Because I have shown to your lordship the argument, the manner of cross-examination, objection, nothing has been stated.
But in probate cases, it
that
may be said court of conscience and all this.
Then, my lord, is something, my lord, even a court of conscience, the person.
But you should be given an opportunity.
I need an opportunity to counter it, because if this captured the mind of the learned court below, they should have given. I can ask the person to be deposited on that Subhanaya Ghosh should come and say what is the exact state of affairs and other things. They can also consider, but nothing has to that extent has ever been make out either by the cities or the court totally at the time of and at the time of delivery of judgment, this has been cropped up.
That is the only thing apparently.
That's the only thing, my lord, on the basis of which page 119 your lordship find the findings, ultimate findings. So the signature of Subhanaya Ghosh, my lord, got it 119
yes.
at the top. So the signature of Subina Ghosh along with the date was identified and proved by one attesting witness of the said will who was present at the Subina Ghosh put his signature on the said typed copy of the will. Well, this identification
signature এটা বসিয়েছে পরে signature পরে একটা identification petition add করতে গিয়ে তাদের থেকে yes, that was the premise of the judgment.
and it is one of the logically considered. So the signature Subina Ghosh along with the date was identified. But this identification is not on the date of the execution. It is identified on the ground that you are the notarial or obtaining the notarial certificate. That is why at the bottom, my lord, you will find who have identified.
This was a serious error but by an advocate. Anyway.
Having a pen, my lord, it will like pillar, double L. Only
we love page 121, this part, rice taking ceremony part.
rice taking ceremony.
Read that out.
That is the premises, my lord. The expression which I can offer or actual happen, it is the case. No question was put forward to me. Nothing to that extent. The court for the first time at the time of delivery of judgment.
Yes.
The instructions in the hand, it flows out from the contents that the will was written and the scribe on 27/9/2004. And it was apparently executed on 10th September 2004. But this is not the case made out by either of the parties. On the contrary, the question was put forward that the will was executed by my father, the only question put forward, but you have put your signature subsequently. That was the question put forward, my lord. Your lordship find by the cites to the PW3, one of the attesting witness. That is why, my lord,
who signed subsequently?
It is the case that the attesting witness put their signature subsequently on the will executed by my father. That was the question. If your lordship can turn to that.
Exam of PW3.
PW3, my lord, may I draw your lordship attention to that portion only. Page 87 at the top. Not a fact, well, the questions are not there, so I can. Not a fact that after the death of Kumar Sarkar, I sign on the said will of Prabhat Kumar Sarkar on the request of his son Pradipta Sarkar after the death of Prabhat Kumar Sarkar. So execution by
scribe's signature was never any question.
It has not been questioned in that aspect also. And that is why, my lord, if these findings can be read along with the question put forward, then it cannot be said that on 27th this will was executed.
Very well, yes. Read this, this to believe such a thing. Read that and get it over with. Anyway.
Yes.
So anything else, Mr. Rai?
The rice taking ceremony I've gone.
Actually, we don't want to give time to Mr. Chatterjee to come.
No, it was
hard.
It is excessively hard, but practically both of us.
We know we have marked everything there.
We have concluded our argument at that point of time. It appears that one of the person died, and that for that reason, it has been. That is why your lordship will find that in the order itself, after considerable argument, it appears.
Yes, yes.
And the judgment.
What was your argument actually? Just remind us.
Mr. Chatterjee is on his legs in court number 37.
No, that is not your argument. That cannot be an argument.
No, I was specifically
one thing, subject to question.
Yes.
আমি দেখিয়ে দিতে যতটা তোকে ইয়ে করা যায়
so many judgments on what?
Not two.
Same proposition. If there
no, I'll not multiply.
The party who cites two judgments on the same proposition loses. Outright loses. We find two judgments on same proposition, you are gone. We'll find out reasons. And it's easier to affirm, remember that. We just have to quote those propositions of law that appeal court should not
the third case, only that.
Substitute its own findings for the trial. You only have to say that. So remember that while citing judgments.
My lord, only one thing, my lord, I am citing this judgment on this code, my lord, whether the third code made out. That is reported in 2014 SSC Online Calcutta with 19.
How many judgments you're citing?
Three, only three.
Three. What is the first judgment?
First
The
judgment
citation?
is 2000, AIR 2015 Calcutta 106. The case not made out by the parties, court cannot travel. That is the, huh? 2015 Calcutta 106.
It's a division bench judgment.
Division bench judgment.
Any particular paragraph?
Yes, my lord. Your lordship will find paragraph fifth page. My lord, your lordship will find fifth page number 5 at the top. My lord will find the page numbers are there. 7. My lord will find
page number 7.
No, page 5.
Yes.
Right hand top, left hand top, my lord will
7.
7. That is, the court cannot travel beyond the pleadings as no party can lay evidence on the issue point not raised.
Quoting a Supreme Court judgment, actually.
Yes. And subsequently, my lord, in view of the above law, on admission can be summarized to the effect that the admission made by party through not conclusive after that, because I am on the basis of which to what extent the appellate court can consider for the purpose of adjudication.
What is that?
The
Same paragraph.
Yes. Admission, no. This is the only thing raised in the pleadings in the case. And such evidence has been adduced or finding fact has been recorded by the court. It is just to be ignored.
No, where are you reading?
The 7. It was quoted from the Supreme Court.
7, 7 itself.
Yes. Yes. After that, you will also find.
That is about all in that judgment.
Yes, that is the only thing.
Yes. What is the next?
And owner's discharge. To what extent the duty of that is your lordship 2006 13 SCC page 449.
In what context are you?
To what extent owners,
your owners,
my owners discharge the purpose of proving an appeal. 449. 449. The 449. Yeah. 2006. 13 449. এখানে আছে বার করা আছে 2006 What are the suspicious people?
No, cite it. Cite it. But they will take the point of suspicious circumstance.
Suspicious to what extent? Suspicious, my lord, I could have understood suspicious. They have raised question preferred and unable to perform. There's nothing to that extent.
Mr. Chatterjee will definitely harp upon judicial conscience, court of conscience.
Yes, that is why, my lord. That is the argument.
In that context, still, all of us know what arguments Mr. Chatterjee may not know, but we know what arguments will be making.
The conscience of the court should be clear at the time of
Conscience
this
of
is the
court,
last.
yes, court of conscience.
That is why
That context he'll bring in suspicion.
suspicious circumstances. So whether
may cite the judge.
Oh, yeah.
Take time in your rejoinder.
30, 46, 97, দেখতো? তাহলে একটা দিয়ে দিই, page paragraph 40, my lord, your lordship. This is regarding the third case, once, my lord, because that is the judgment which has have handed over to your lordship 2015 Calcutta. The quotation was made, but my lord, kindly, if your lordship can takes up this one, paragraph 40. Elaborate discussion regarding the 2013 for Supreme Court cases, page 97. Suspicious consent actually what করছে?
Yes.
Suspicious. দেখি একটা কথা।
So your quota of three judgments is complete now.
Yes. Well, that's onus, my lord, will find everything is there. Well, judgment which I have handed over to your lord.
Para 14.
Yeah, the onus. Yes.
No, you said third case?
Third case, paragraph 40.
40, 40.
40, 40.
Oh.
কি আছে?
This is not exactly third case.
This is regarding the should be. My lord, I want the
Yes, witness should be given opportunity.
Because-
if party raises, this is on a different proportion. If a party wishes to raise any doubt as regards the correctness of the statement of a witness, said witness must be given an opportunity.
that is why, my lord, the court
How is
is
it relevant?
the court is of the opinion that the PW2 has stated that the scribe had executed the will on that same date. The court raises doubts in his mind that it is not the date when the signature was put, it was put subsequently, and the will was created subsequently. My lord, be clear to you.
No, then in every case, the court evidence is laid. Court will pass its judgment on the evidence which has been laid.
Yes,
In every case where there is a doubt, every time another opportunity cannot be given. Regarding the correctness, the veracity of the statement of a witness, he got an opportunity to explain his statement. Why should the court draw its attention? It's not the duty of the court. Not at all the duty of the court. This judgment does not say so. Unless it's the trustworthiness of a witness otherwise.
yes, otherwise.
You may argue that they did not put this question
This
in
question,
cross-examination.
that is
That is a different, that may be inconsistent. This is not so, German.
as your lordship. It is not the cities, but the court have expressed its doubt regarding the and without
Yes. So this is all.
this is
Yes. Where is he?
Court number 37.
You start. What is your point? You are an advocate. You have been engaged in the matter. You should start it.
I can start, but I am.
What is your answer to his questions?
12 বাজে 10 মিনিট 12 বাজে
But Specifically, my lord, what my lord, it has fallen from my lord, my lord, that the court of conscience, my lord, it has satisfied my lord's conscience first, my lord. That was my first point. You know, secondly, my lord, the suspicious circumstances which are there, my lord, the attesting witnesses, my lord, in their evidences, my lord, it's not specifically clear, my lord, as on date, around on 10th it was executed, and the witnesses has seen it. My
It
lord,
is not there in your written objection. It is not there in the counter suggestions.
my lord, I bowed on, my lord. It is not there, and I cannot develop, my lord, better from what's already there. My lord, but in the objections, my lord, what has not been taken up, despite that, my lord, this is, my lord, kindly consider, my lord, this is not a regular court, my lord, it's a probate court. And my lord is sitting only for adjudicating only on the genuineness of the will, whether the will is genuine or not. On that, you know, the first thing that the propounder has to satisfy, you know, is the conscience of the court, that whether the will is genuine on the face of it. Unless the genuineness of the will is established up to beyond reasonable doubt, then will the subsequent cases come. Even if a case has not been taken in the objection, despite that, the honorable court can go into the issues for adjudicating whether the will is genuine or not. Secondly, my lord, the witnesses, my lord, the attesting witnesses, my lord, which has even pointed out by my lord and also found by my lord, the date on the signature put by the attesting witnesses, there is no specific date. So there is always a possibility that the signatures has been obtained afterwards, and the evidences are tutored.
Dates, no dates against the attesting witness.
Attesting witnesses, the signatures that they have put, there is no date specifying that they have put the signature on that particular date. So there is always a possibility that even after the notarized was done also, it can be obtained on a future date also. That doubt remains, and there is no evidence on fact which says that yes, they have put their signature on this specific date. All the questions, all the answers that are given in the evidence say that whether executor has put their date on that particular date or not, whether this signature is there or not, but there is no evidence which says that yes, he has put the signature on the date when the executor put his signature. There is no evidence.
No, but their evidence says that they saw him sign.
No,
they signed in their presence.
The questions that I'll place.
They signed in their presence, then it has to be on the same date.
That is why what my case is, it is tutored. They have been tutored.
That is a.
Secondly,
even if tutored witnesses, all witnesses are tutored by their advocates.
Thirdly, there is another specific point. The witnesses, in the evidence, there are certain areas where they say they cannot even identify their own signature. I'll show that to my lord. They cannot even identify whether this is their signature or not. If my lord may kindly take up.
We'll come back. When you come back after this 5-10 minutes, you just point out those portions where witnesses can't identify their signatures.
I shall, Mr. Chatterjee will,
We'll continue with this.
He's leading me, he is on court.
He'll lead you. He'll sum up.
No, my lord.
I would.
It was predicted that you.
No, we know him from his childhood and our adolescence. Yes.
I thought I should not leave him, my lord,
No, Mr. Chatterjee, actually, the plinth of your argument will definitely be court of conscience. Even if you don't take the point in your written objection, court
Even
can
then,
look into it.
not.
It's palpable. But what about Mr. Rai has given an explanation that first of all, this is the third case, no opportunity was given to them to
I
contradict.
would say, my lord, since this is a court of conscience, and your lordship is really, my lord, looking into a person's last wish.
Yes.
So if he feels that he wasn't given an opportunity,
Yes.
Lord,
We
it is-
can.
Yes, the thing is, if the court finds, after looking at the will, that there is a situation which needs an explanation, then my lord will not stop your lordship's hand, my lord, in sending it back for a limited remand. I am coming down, my lord, to that extent also. If he feels that ways, if he feels that he doesn't need and he wants to go ahead with whatever is there, that's a separate aspect altogether. He has not made that prayer before your lordship. So I feel, my lord, that he wants to go ahead with whatever is there and he's accepting the animally what is there. Once he accepts the animally, my lord, whatever is there, it has to go against him. Because he cannot in any manner explain before the appellate court what is absolutely on the, my lord, on the
Mr.
face of
Chatterjee, is it such a great anomaly? That is another
Please,
aspect of it.
absolutely. I'm trying to
Because
show
this
you.
is the scribe. 63 provides that testator and attesting witnesses sign before themselves and whatever. Now, 63, the
But
evidence.
there is also a problem there.
Why?
My lord, in some of the witnesses, your lordship will find they have said that I don't know who typed it. Another
Those
one,
portions we requested you and Junaid
yes,
to just point
I'll
out
show
when you
it to your
come back.
lordship. Yes, I'll show it to you.
So let us start with that.
Yes,
Yes.
Just one prayer, my lord, if it comments to your lordship, I'll show everything factually. Just the judgment part just gives me another date.
Judgment?
Judgment part. Just give me
Citation.
citations. Just give me one more date. On the next day, I'll show everything.
Only the citations.
Yes, please, just the citation. My lord, if your lordship turns to page 79.
Yes.
Bush. No, ঠিক আছে. My lord, this is the.
We more insisted because Mr. Chatterjee, you are aware of this case. We had heard you on the last occasion also, and you are abreast of the facts.
My
So
lord,
that's why we. If you really felt that you
Lord,
would be out of water, we wouldn't insist.
I'll tell you, lordship, Lord, if I really, my lord, was not in difficulty, I would not have troubled
We have
your lordship.
always got cooperation from all of you. I mean,
My
therefore,
lord,
if you are really in difficulty, definitely no point.
No,
So whatever you can do, you do. Citations, we'll put it as forwarders on a date and give you citations and we'll close out.
absolutely. So grateful. Lord, I made this submission. If Mr. Rai was there, my lord, if he would have taken note of that and given something on that, then also it would.
Mr. Shanal is substitute.
Channel is there. He will. No, the earlier submission about remand. That will not whether Mr.
No,
Shanal
he
can-
need not pray. If we feel we can remand.
Exactly. Lord, he did not pray for that. So I'm saying, my lord, that if he hasn't prayed for it, he can't explain by, my lord, his word of mouth, whatever it is here. That is
Not necessarily, Mr. Chatterjee. We can also offer our own remand if we feel.
yes, yes. Then, my lord, kindly turns to yes, page 80. Just for the sake of, my lord, continuity,
Yes.
after the testator put his signature, my lord, kindly got it, about 5 lines from the top.
Yes.
Of the said will, I accordingly put my signature thereon in his presence as an attesting witness. When the testator put his signature on the said will, he was physically fit and mentally alert. I cannot say, after the drafting of the said will by Shubinoy Ghosh, who typed the said will. This is important in the circumstances of the anomaly, what is there. This is my signature on the said will as an attesting witness. The signature of the witness on the said will is marked as Exhibit 1. This is the said will of the deceased. My lord, need not trouble. I'm sure Mr. Rai has shown your lordship there. Then kindly turns to, my lord, page 81. 4 lines from the top, or rather 2 lines from the top. The will was drafted by Advocate Shubinoy Ghosh. My lord, kindly got it, lord.
Shubinoy Ghosh in the month of September 2004. I cannot say whether Advocate Shubinoy Ghosh directly prepared the final copy of the will or gave a draft copy of the will to the testator, Prabhat Kumar Sarkar, for its approval. Not a fact I did not know the deceased Prabhat Kumar Sarkar from before. Pradipta Kumar Sarkar is not present in courtroom today. I cannot say whether any other incident occurred on that day in connection with the execution of the said will. My lord, thereafter, if your lordship sees, if your lordship just goes back a little bit at the top, my lord will find in the month of September 2004, he
Yes,
says
we
it
told
was
Mr. Rai he's conveniently vague on that.
conveniently.
10th and 27th both fall in
My
September.
lord. Then, if your lordship turns to PW2, my lord, I have shown your lordship, page 80.
This is PW2?
Yes. Then turns to PW3.
Yes.
My lord, kindly turns to page 83. And turns over, my lord, to 84. I'll just read for your lordship, my lord, from the top for the sake of continuity. The signature of the witness on the will is marked as exhibit 1/2.
Not half. 1/2 should.
1/2. I sign on the said will as an attesting witness. Another person, namely Bhakta Mondal, was present at that time. Bhakta Mondal also signed on the will as an attesting witness. When I put my signature along with Bhakta Mondal, Prabhat Kumar Sarkar informed to us and he saw us putting our signature on the will. And when Prabhat Sarkar had signed on the will, myself and Bhakta Mondal were also present there at that time. The will was drafted by Adhir Kumar De. Now, this is the anomaly again. Then the witness says that the will was drafted by Shubinoy Ghosh. This is where, my lord, there was a lack of chain of communication.
Notary of the will was Adirko. He confused the name of the notary and don't go over.
And the notary of the will was Adhir Kumar De. The
that is
will
only
was
normal after so many years.
after so many years. He's not that old.
No, not old. The span between the execution of the will and evidence was in 2012.
For 5
of the will was
yes, that is there.
just a confusion between that.
Then, my lord,
but we'll take note of that definitely. Yes.
Then turns to page 86. This is a little weird. I do not know the wife and the daughter of the deceased Prabhat Kumar Sarkar. I cannot recollect from my memory and say whether I signed on the will as an attesting witness executed by the deceased Prabhat Kumar Sarkar on 23rd March 2006. I cannot say whether the signature is of myself or not. Now, this should clinch the issue. And I'm sure Mr. Rai Miller did not show that before your lordship.
Yes.
Would have skipped it.
Now, this vitiates his status as an attesting witness also.
Yes.
No, Mr. Rai, since he's here, he did not show us this.
He did not. I'm sure he did. Not a fact that my statement that Prabhat Kumar Sarkar executed a will in favor of Pradipta Sarkar is false. Next statement. Not a fact that my statement that Shubinoy Ghosh drafted the will as per instruction of the deceased Prabhat Kumar Sarkar is false. My lord, your lordship need not trouble my lord's self. Your lordship has seen that. My lord, Mr. Rai then goes on to show your lordship, my lord, the other will. Lord, I'm not too sure whether this was exhibited or not.
He said it was exhibited.
Because I find from my, my lord, whatever I had, this was marked X for identification.
Oh.
If I'm not mistaken, my lord, subject to correction.
Can somebody please check up, Mr. Shanal? You can check up from the records.
From the
in the meantime.
records, because what I find.
In the meantime, you can check up.
Yes. My lord, if your lordship looks at page 90.
Yes.
Kindly sees, my lord, the second paragraph.
Yes.
This is my father's signature on all the pages of the will. The will is marked as X for identification. Whether this was later, my lord, exhibited by anything, I have no instructions on that. Now, since Mr. Rai has relied upon it, a very important line, my lord, in that paragraph explains a lot of things. Looks to, my lord, page 10 of that will.
1 minute, give us half a minute. Page 10, yes.
Page 10 kindly comes, my lord, about 5 or 6 lines from the bottom. কিন্তু সেই সময় আমার পুত্র শ্রীমান প্রদীপ্ত কুমার, Lordship, kindly got that? About 7, 1, 2, 3, 4, 5, 6, 7, 8, 9 lines from the bottom. কিন্তু সেই সময় তাহার আমার পুত্র শ্রীমান প্রদীপ্ত কুমার সংসারে নানা প্রকার অশান্তি করায় এবং তাহার দাবি মতে
But all the same, he
বিগত ইংরেজ such and such. So coercion is admitted by the, my lord, testator himself. If he is going to, my lord, rely upon this, kindly, my lord, in my respectful submission, looks into, my lord, the recital of that will and sees the coercion. So this is a very important aspect in the matter. They might not have exhibited it because of this.
No, you produced the document.
Yes, yes. Might not have been keen, my lord, in exhibiting, my learned senior friend. So whichever way, my lord, he is saying that the will, in this will, it is recorded, my lord, that there was a will previously, my lord, executed by him, where the citation is because of his dabi that will, my lord, was executed. So coercion, undue influence on the face of it.
But then he goes on to say, এক্ষণে আমি ওই উক্ত such and such তারিখে কর্তৃক সম্পাদিত উইলের কোনো প্রকার পরিবর্তন সাধন না, he could have done that.
He
if
could
it is
have,
by
but
coercion.
there was not an influence on that gentleman.
That was at that
in
point
the
of
Poribar.
no, Mr. Chatterjee, in the same breath you cannot say that influence was persisting and but he executed the
At the
second will.
time when he, my lord, executed that will,
When he executed the second will,
question before your lordship is when he, at the time of
we cannot read it in isolation.
No, no,
When
no.
he executes
No, no.
the second will, if you read the first sentence, we have to also consider
Absolutely.
that he had every opportunity during the second will,
I bow down.
because that pressure was not
I
persisting.
completely bow down.
Only
Lord, my
that's why he could
submission is-
write this down.
I bow down.
And if he could do that, he could change that also.
I completely bow down. Lord, my submission before your lordship is the probate court sees the mind of the testator when he, my lord, executes it. Not any circumstances, my lord, whether he could have changed it, my lord, we don't know.
No, not that, because if he was under coercion, if he did that under
May
coercion,
not be a coercion, my lord, forever. But when it was executed, once execution is done, at the time of execution, my lord, if the coercion is there and it's proved by the basis of the document which he
then
wants
this
to
was
rely upon,
stands by that will.
I have not, I'm
Stands
not
by
saying,
that will.
I am not saying that he
Before his
cannot.
demise, he goes on to
Lord, it's a very
execute another
practical
will.
situation. Kindly appreciates, apart
It's
from
a ratification sort of.
apart from legality, a very practical situation. I, as a son, ask my father to give me this right now. You've got to give me this, and I do what? I do Ashanti in the family.
Ashanti is not coercion. Coercion is, yes, in a sense coercion, but coercion has to have an element of force.
I'll tell you, Lordship,
You are
very-
compelled.
Very simply, I'll tell
This
you.
is persuasion, at best coaxing.
Exactly.
Coaxing is not coercion.
No, but doing an act, well, I'll satisfy your lordship on this. Doing an act by which you are forcing somebody to do something which might not have been his will to do it at that point of time.
Wills may be molded, Mr. Chatterjee.
No,
Yes, I may be to avoid trouble, I may do something.
Exactly.
But that is not coercion.
Avoid
Is on a
travel,
higher
I
footing.
do something. Avoid
Coercion is a
travel,
higher footing. Coercion, I didn't have any option. I mean, coercion, I was compelled.
That's what I'm saying. That's why the word Ashanti comes in.
Ashanti is
Ashanti
always
in the
there when
house, like Mr. Rai Milord, he loves Ashanti.
you always give him Ashanti. So that does not mean that he's coerced into arguing what he's arguing.
No, my submission is, Milord, I completely bow down to what your lordships have said. Milord, it's absolutely right.
That's one of
But
the
I have
coercion is on a higher
different
footing.
thing. Yes, but I have a different footing. Will is a very important, Milord, document in a person's life. It is basically, Milord, a last wish. Now, if a person is saying that ওই সময় ওই লোকের দাবি মতে আমি একটা জিনিস করেছি, Milord, I am only trying to, Milord,
Because he's under the influence of you when he executed the second will.
no, that after that he realizes that he has to give to everybody. That's why
Put it on balance. Therefore, he did it.
has to give a balance. That's why, Milord, he probably said that whatever he
If you are so coerced, Mr. Chatterjee, you would have given the entire property to him, not 50%.
No, Milord, at times
Coercion was introduced by your client. So
there's a difference.
put some line in. We can see it happening.
No. Milord, I don't think that happened. I don't think that happened.
We are on more on ground of surmise in these things.
Absolutely.
But yes, we take your point.
Since
We have
it's a-
noted down your point.
Since it's, Milord, a will. and your
Ashanti,
lordship-
dabi mote,
Dabi
these
mote.
two things going
So
together.
a
So
will
coercion.
has to be a free will.
Yes,
Mine has to
own
be
volition.
own volition, and out of my own thinking, my love and affection, I'm giving it to somebody else. So if he himself says that it's a dabi mote thing, then, Milord, freeness, in my respectful submission, is watered down. And your lordship will take the entire situation into consideration and see, Milord, that what's the, Milord, the problem. The trial court, Milord, if your lordship looks to the judgment, I'm sure Mr. Rai hasn't placed it.
He tried to place the entire judgment until we
Lordship,
convinced him that we have it underlined and cut and dried. So that's
Start
why he
from
only
105.
we have seen the judgment, Mr. Chatterjee, on the last occasion also and now also.
Right.
So you can place the portions you want to highlight.
Sees 117, bottom.
Yes.
But whatever we've said is basically discussed here, so I'm not going to trouble your lordship with
Need not, need
and since my lord has got me, it just gives me one more date. I'll just, my lord, cite those decisions.
So this is all.
With the facts,
This is actually all. So you'll be citing judgments on probably court of
suspicious
conscience and
circumstances and court of conscience.
Correct.
And onus. There's one very
and you also deal with his judgments. He has cited it.
I already have that.
Good.
The last one is a good one for me, actually.
Good. Heard learned counsel for the parties substantially, full stop, on the prayer of learned senior advocate appearing for the respondents, comma, the matter is postponed till June 23, 2025 for the purpose of citation of judgments by the learned senior advocate for the respondent and rejoinder arguments by learned counsel for the appellant. পাঠাট করে ওই দিন দিয়ে দেবেন 23rd
Is it Tuesday or Wednesday, my lord? 23rd?
Monday.
This Monday.
This Monday. It will be in the list as a parted matter.
Grateful to your lordship. I'm extremely grateful.
Thank you very much for coming and trying to complete.
I had to.
Yes.
to just
Your junior coerced you into coming.
to show justice. Will he say, my lord, that I came on my own? But because Mr. Chaudhary is talking a lot of rubbish, my lord, in the other court, so I could.
Which your friend, Mr. Chaudhary? You compete with each other in speaking rubbish when you are appearing against each other.
That's what Justice Orijit Banerjee also said.
Yes. Thank you. And thank you also, because you argued very well. You were arguing very well. Yes, 19.
May it please your lordships.
Yes, Mr. Medora, what is the matter?
Whether I appear on behalf of the appellant, this matter on the last occasion when your lordships had been pleased to take it up, had been referred for mediation.
Yes, failed.
Unfortunately, it failed. In one sitting only, it got over. So be that as it may, the
It
matter
was
will
over in one sitting.
the wife was there. We were there also for the wife. The husband side only, Mr. Mukherjee was there. And I don't think he had adequate instructions. We proposed a figure, one figure came from his side, and thereafter there was no middle path.
Then there is no way out.
So the matter will have to be argued. When the matter has suddenly come in the list today, my lord, can it be taken up on some other day subject to your lordship's convenience? If your lordships insist, I will start, but I'm not as well prepared as I should
So
be.
then do. Very well.
Could it be next Wednesday or Thursday, subject to your lordship's convenience?
Very well. It is submitted by learned counsel for the parties that the attempts at mediation have failed. Accordingly, the matter is required to be taken up for final hearing. On the prayer of learned counsel appearing for the appellant, we adjourn the matter till, give us a date, Wednesday or Thursday.
I think Thursday will be better. Lordship takes up hearing matters the entire day.
Till June 26, 2025.
Most grateful, my lord.
Please come back. Your Passover matter, you are ready in that?
Yes.
Can we call it?
Yes.
The other side is there?
Yes, other side is also there. I informed.
Very well. Thale Passover matter table taken in.
Yes, please come. Yeah, I'm told.
Then we'll take that up now.
Yes. Supplementary evidence. He has really come, my lord.
Yes, pardon?
He has really come.
He has?
He has really come to the court. My lord, on the last day, I have tried to show that there was really no challenge. But even if there was a challenge, I said that I would have succeeded because my documents are there. I have shown it to the court. I am not relying for the time being, and one document 49 where it is finally is being approved, that has been already annexed by them in another suit in the court bill. So I have shown to them on that. So lordship, that argument do not hold goods that they were not aware. And moreover, this came in 2022 and he took all benefit under that because number of days of vacation, then little enhancement of the salary and the job allocation, everything he enjoyed. Only in 2023 and 24, he started doing this. Now, lordship, I would now place before your lordship the inquiry report. If your lordship kindly takes up page 28 of the supplementary affidavit, and immediately thereafter I will take your lordship to page 36, 28 and 36.
Supplementary affidavit?
Yes, lordship. They filed it, lordship.
One.
Inquiry report, they filed.
Just give us half a second.
Supplementary.
Yes.
Can two. Yes.
Right. Take.
Lordship, now I am trying to show.
Yes.
This is, of course, not within the purview of the
supplementary affidavit. Page 28.
No, lordship. Can two. First, your lordship.
Can two itself. Can two ta dekhachhe.
Page
28. Inquiry report. Second minutes of inquiry officer. These are second minutes of the inquiry officer.
Page 28 is the first minute, and then 36
page
is the
28
second.
is the. Acha.
28 is
yes,
the first.
right. I was wrong. So you are placing page 28.
28 first.
Right.
Because that was the first.
Yes.
Now, lordship, now we will try, because since they have brought the second issue in here, and I substituted and then this happened. So they also wanted to have a scrutiny on the act of the learned retired judge who acted as an inquiry officer. So, lordship, to keep myself above board, I want to also place the minutes as well as by supplementary affidavit, they have given the report. So, from the report,
because his was the biasness against the Director General. I have shown from the document that Director General alone cannot do anything. It has to be by the Executive Council. I have shown that because they took this, has to be done by Executive Council. I have shown that. Then they said President should have done. I said no, President was the appellate authority. Now here they have come after this.
Please continue. Yes.
Now, Lordship, now since though it is a matter of appeal before the President, but they placed before your Lordship. So, Lordship, I want to place it before your Lordship to show it was also not malified or in haste or a biased inquiry. Lordship, first document. A notice for hearing of the domestic inquiry was issued under sign on such and such, and the same was sent to the charged officer, presenting officer. On being informed, the charge officer appeared today before the inquiry and submitted an application dated such and such. The charge officer, after receiving the notice such and such through email, sent an email to the undersigned requesting the copy of the appointment of the undersigned. The charge officer was accordingly informed that the copy of appointment would be handed over to the charge officer today. Accordingly, the photocopy of the appointment letter such and such of the handover served upon the charge officer, who accepted the said copy after putting his signature today. Hard copy of the notice such is served upon the charge officer. The presenting officer, in compliance with the direction given by the undersigned, has submitted affidavit of evidence duly notarized with all the document on which the instant will rely upon. The presenting officer has submitted that the hard copy of the affidavit was also supplied to the charge officer, but the charge officer refused to accept it. The presenting officer submitted that thereafter sent the copy of the entire affidavit in evidence to the charge officer through email. The charge officer submitted that he received the affidavit of evidence sent to him through email, but he admits that he refused to receive the hard copy of the same on the ground that the domestic inquiry is invalid. The charge officer, Mr. Such and Such, has made submission a number of points to establish the claim that the steps taken by the disciplinary authority by serving the memo of charges against him is invalid, illegal in clause 3 of his application filed today. I pause here for a moment. This memorandum of charge, the initiation of proceedings, is also challenged by him in a suit. That suit did not pass injunction in his favor. He came to this court before this division bench, and there also he failed. So the obvious consequences was flowing, but at this stage he cannot fall back upon and can say that point. Interlocutory decision, but he cannot stop it. But he can always take that point as a final adjudication that it goes to the jurisdictional issue or something. Now, Lordship, the officer has submitted that the HR manual such and such on basis of which the memorandum of charge dated was issued against him has not been approved by the management council. So, Lordship, that I have said before your Lordship today, I have given the document, and the final document copy 49 is relied by them in another suit. So this is barely.
Where is that copy you mentioned on the last occasion?
They filed it in the suit 2104.
No, you have handed over separate.
I handed over the separate copy. In the suit they have annexed it.
Right.
If your Lordship want, I can hand over the suit as well as the copy.
Had you given on the last occasion? No.
Go. Yeah, I handed over, but Lordship has said that Lordship will only take after I hand over to them.
This one.
Ache ekhane.
This one.
Is this the one?
Yes.
No.
There's a
No.
memorandum and
And this is
আমি
different.
কিন্তু তোমার থেকে ফেরত নেব আমি জুলাই করছি বলে তুমি 49টা ফেরত নেবো তুমি তো অ্যানেক্স করছো দেখো তোমার
না না আমার কিছু নেই
তোমার স্যুট তো এটা
হতে পারে
Lordship, it is annexed in their suit, but just for a handy reference, Lordship, if your Lordship kindly takes up
এটা কি 48
48টা তোমাদের কাছে নেই থাকা সম্ভব না আর 49টা তোমাদের কাছে আছে মার্কিং কপিটা কি জজ সাহেবের কাছে চলে গেল? ঠিক তো? মার্কিংটা উঠে গেছে? ওটাও মার্ক না, দেখো মার্ক কপি আরো থাকবে।
Page 11. 49 minutes. 49th meeting minutes they have annexed.
Yes, yes, that they are supposed to.
We dispute it, my lord.
You say you have not annexed.
No, my lord. There's no pagination. On the last occasion I saw that it is, maybe it was given to them as part of their instruction, and they thought that since they are stitched together, I have annexed it, but I have not annexed it. We don't have it.
তাই কি?
Why you think it is annexed?
দেখো ওরা কি বলছে, সুটটার প্রিডিংস থেকে বের করে দাও যেগুলো অ্যানেক্স করে থাকে।
সার্ভিস ল সার্ভিস যেটা আপনি বলছেন সেলের ডেপুটেশন এখানে অ্যাপ্লাই করবে।
196 পড়ছে
একটা সোসাইটি।
এই সুটটা দেখো, সেকেন্ড সুটটা।
না অ্যাপ্লাই করে তারা এইটা অ্যাপ্লাই করছে না, ওই রুলগুলো অ্যাপ্লাই করছে না যেমন সেই জন্য
Which rule was prevailed?
Cell rule was it? It is substantially after formation until this we've followed the cell.
Therefore, his argument that EC, there had to be an EC approval, that holds good then. Because this HR manual comes in only with the EC approval. As per the sale rules, it had to be approved by the EC.
Yes, that time it was written in the.
This becomes crucial. If this was not before the court below, because you had an opportunity to, this was final hearing of the injunction.
I had no objection because in the lower court, I still did not get that opportunity. I can only discuss.
No, this is not coming up from an ad interim stage.
No, ad interim stage.
You had filed an objection.
This is from
ad interim. Then you had no opportunity till now. No, ad interim.
On caveat, they were on caveat, but they did not. It was contested at the ad interim stage.
They argued.
They argued. Yes, yes, that is recorded also.
Then, Mr. Banerjee, how far we can look into this, it becomes questionable. You have to argue on that also. If this was not before the trial. Because you had an opportunity, you had lodged a caveat, you had appeared. There is no reference in the impugned order, at least, to any approval by the EC. You can also argue independently that EC approval is not necessary. That is a different argument.
But how can I? I cannot argue. Now it has been approved. It is the rule is there.
No, this approval itself, HR manual, this approval of the HR manual becomes crucial then. Although you have argued separate points also that this point was not taken by them and other things, but insofar as the authority derived from this HR manual, this becomes questionable then, because as per the sale rules, HR manual had to be approved. Whatever change in the rules and regulations had to be done by the EC. EC.
And it has done. In 48
it has done, that comes only from this document which was not there before the trial. It is coming before us for the first time. You had an opportunity but did not produce this in the trial court.
No, I mean, that point of time I completely argued in a different point.
Then you have not produced this, then how can you rely before the trial?
What was the argument before the court? Lordship, he said the man who has been appointed as an inquiry officer is an unfit man. And respondent number 3 who appointed him is biased. These two were the point. So from the document I have shown, which I argued before your lordship, that see, Director General is the Secretary of the Director General. He is also ex officio member of the Executive Council. He has to keep everything informed to the thing. He only came into the picture in 2022. He cannot have a previous animosity. And third, you tried for the same post. You could not succeed. I succeed. So you think that I am a.
So you fall back upon your argument also that in specifically this HR manual was not challenged.
Yes.
In the suit.
I
You showed us
that
that
in the court.
in furtherance of HR manual, nothing can be given, can go both ways. I mean, they are admitting the HR manual, but saying in furtherance of that, or they do not admit.
And then, Lordship, this HR manual is, he filed 2 suits. When I issued him the so cause, when I issued the memorandum of charge, and then after this.
Yes.
So in both the 2 cases, there is no clear-cut declaration where he said that this HR manual is not. So he is only making a one averment in the plaint that it is not been approved. Now, Lordship, how far a averment made by him will hold good for granting him injunction?
But if you appeared before the court below you are on caveat, you could have pointed out that this HR manual has been approved.
Verbally, I did not argue or argue. Now I cannot say since it has not been recorded. But Lordship, what I argued primarily, that HR manual he did not challenge because he is second man in the organization. He knows everything. He is also.
Who was the inquiry officer? He was below the rank of the this person.
The initial inquiry officer is an UPSC cadre.
No, cadre is
Railway service, yes, much higher. It's a society under 1961 Societies Act.
This is the material. The delinquent officer
Is it? We call him as call him by any name. We call him by DGM, Director General, whatever we call him. He is one of the man serving in a society under 1961 Societies Act.
No, what is his qualification?
he was the officer in the rank.
He
He
cannot have a rank. Rank is only amongst the 2 government officials.
Yeah.
Like, so I am working in Army Major, which is equivalent to Superintendent of Police in IPS. So, gradation of the service can be done if only in government. Government versus private cannot be done, sir. My lord, this is.
Oh, whether they are private organization?
Yes, this is a absolutely private organization under 1961, as good as a local clubs. Good club, name, but it's a club is under a company, private company. It's like that. And then, Lordship, that's what I repeatedly said, that I appointed a cadre.
Then how they were come under the rule and manuals of sale and
No, not rule, they come under. I formed a association.
Good question.
I formed an association. I formed a security agency company.
How are you governed by the sale rules then?
I am coming. Sir, I formed a security agency company. And I said that I will follow the rules, regulation and discipline of a paramilitary force, CISP. It is my private company. My duty is to give security agencies to them. So I said the physical fitness, as well as the allowances, as well as the duty hours, I will do as per a ITBT or CIP.
These are not about qualifications or criteria. This is the entire rules have been adopted.
I can.
You adopted by virtue of what document?
By virtue of my own
Your articles.
Article. And I could follow anything. I could follow Tatars also, Mittals also, because they are all my members. So I found it is more handy for me to.
You are fishing out arguments, Mr. Banerjee.
no. As per service jurisprudence, inquiry officer must be above the rank of the delinquent officer or staff.
It is. This is.
Whether inquiry officer was holding the above the rank of delinquent
Yes.
officer or not.
Yes.
This is the measure.
Simple. Let's go by a simple test.
Yes.
My previous one was a gazetted officer. UPSC cadre, so it's a gazetted officer. Whether this man is a gazetted officer or not. Let's come down to ekdam bottom line. Let's get that test.
What is he? What is his qualification?
He is an engineer. He is working in an organization. If he is not a gazetted officer,
Contender of DG rank for the post of DG.
he
Your
applied for the
company.
pay with the DG. DG is also a
No, in your organization, he is immediately under the Director General. And the previous inquiry officer was below him in rank in your company.
no. He is a UPSC cadre retired from railway service.
Maybe. But what was his rank in the hierarchy of your company, your organization? Below him or above him?
Much above him. Much above my DG also.
There is no scope much above him because above him is the DG.
Yes.
What is above the DG?
DG is the highest.
If a retired Supreme Court judge is appointed as an arbitrator, and if he's an ordinary arbitrator and somebody else is the umpire, Mr. Banerjee, whatever he might have been in his past life, he will act under the aegis of the rules. So, in your organization, what was the hierarchy? That is the question of my lord.
My lordship, my hierarchy.
What was he? What was his designation? The previous inquiry officer?
He was a IR UPSC cadre, IR.
Forget UPSC cadre, whatever cadre. What was he in your company? What was his designation in the company? Did he act under this person?
He is a inquiry officer outside my organization.
Maybe. Cadre and rank is both two different things.
He was not a person, he was not an employee of your company at all.
No. He is not a person from my company. When I found that I am the only one man above him, so I decided to give it to a outside my organization, and to understand his ability of doing departmental, I have chosen a very high official retired from the central government railway service.
Permits this.
Yes, I have shown that, your lordship.
Where is the HR manual? But
yes,
prior to HR manual,
Cell
rule.
Cell rule. What does the cell rule provide?
For that,
in the cell rule, lordship is not there in the record.
Cell rule was there.
No.
That was the terms of the bylaws of division number 1. That is not seal rules.
But as per that, let us see that that's there. Something was shown to us.
Yes.
This is at page 42. Yes, this is the memorandum of this institute.
Of division number 1.
Yes, page 42. Page 42 of, sorry, page 42 of Can 2, yes. No, not of Can 2, Can 1. Mr. Banerjee, page 42 of Can 1, that memorandum of this
is my formation.
Your
my formation. Then my rules is at page 98. HR manual rules.
That is different. Because if you come to page 80, 9.6.4 C says that the Executive Council is empowered to make such bylaws from time to time for the management of the association.
Yes.
And cancel and amend.
Yes.
And to appoint, dismiss and exercise full control regarding the working of the employees of the association.
Right.
So dismissal, appointment, full control is vested in the Executive Council.
Yes, it is.
So here the Executive Council did not function. It was the Director General who had been doing it all.
It's the Secretary. He is the ex officio. I have shown it from the other day. If your lordship kindly takes it, then
he's a secretary.
Where is the procedure for disciplinary inquiry? Procedure for disciplinary inquiry.
Before the HR manual, what was being followed?
Cell rules.
Where is the provision regarding disciplinary inquiry in the cell rules?
Cell rules is not in a record.
Not a part of the record. So does that contemplate appointing an outsider?
That I have to check. That part I have to check. So lordship, then we have to first presume my HR manual is not
yes
done by you have to give a go by to my HR manual.
We won't presume anything. It's your burden to show, because they are taking a point that there is nothing on record to show that it was placed before the trial court. There is nothing to show that the trial court considered whether the HR manual has any valid basis. Unless it's accepted or initiated by the Executive Council or approved by the Executive Council, HR manual has no value as per this your own articles.
Yes.
Because
I completely agree with my lord.
So we have to have something to indicate that the HR manual, because you relied on the HR manual all along. for taking this process against
Ad
it.
interim, they were arguing, I cannot ask for any this. Then Lordship, if your Lordship allow, then I will place my HR manual approval on record, along with the cell rules, if your Lordship so desire. Cell rules is third-party document, but still, if your Lordship wants to rely, I will place it.
No, you were adopting a third-party document.
I was.
So if you are adopting
I was. Then in 2020,
HR manual, it is dependent on whether the HR manual was validly accepted. If it was not validly approved, then that continues. So therefore, we have to look into both. If you adopted it, it does not remain a third-party document.
So Lordship, kindly see, will that will do or not, we will look it later. First, I will place this.
And you are saying that they did not challenge. That is also your one of the cardinal points.
And I succeeded. Now here, Lordship, I will then place it before your Lordship. It is ad interim stage only. If your Lordship so desire, I will place it on record. And then Lordship can look into and can say it is validly accepted or not. Because that document prima facie I have handed over to them and given to your Lordship. I did not give in the trial court, but here I have given. 48 and 49, both the two meetings I have given. That how we decided to do it and how it is approved.
Can we take this on record and record your submission, make it a part of the record and submit
Yes,
that
please,
you have?
please do, my lord. I am doing it under
You have
instruction.
given a copy to them.
Yes, Lordship, I have given it.
I have only got the 48th.
No, 49 is
49 is also there.
continued.
Dekhi dao.
Please look
No,
into that.
no. Dekhi go.
No, 49th continues.
48,
It's a
49
continuation.
to thakbe to. Ei dekho.
Page 6 of that
देखो।
contains 40. You must have missed out.
Mere ko na.
Go to page 6, handwritten page 6, circled. That is the 49th.
Ei dekho.
That is 48th.
Ei je. 48.
Sorry, go to the next page. I'm sorry. This is page 10. Please go to page 10.
49.
Yes.
And not only that, I have given my working committee report, everything I have given.
This bunch you have given to
Yes,
him.
yes.
This contains 49.
How the working committee form, how the working committee done it. So, Lordship, this was my interim stage. I said that they have not challenged. I bring it before your Lordship just to show my bona fide. So, Lordship, now.
That remains in addition or bona fide? Anyway, yes.
Now, Lordship, assuming for a moment, this has to be tested. Now, if this prima facie holds good, now, Lordship, if this has to be tested, this has to be tested by trial.
By
trial. This cannot be tested in a interlocutory application or appeal from interlocutory applications. So, Lordship, today I am before your Lordship in a very limited purpose. Lordship, they have received it. Now they will challenge the entire proceeding, including the termination. There they will, I'm not there to advise them, but their Lordship, this will surface.
No, this is becoming like a memory game for them. Every time a document is produced, they challenge that and another suit is filed.
Now, if your Lordship kindly takes up
এটা তো ডিস্ট্রিক্ট জজকে দিয়ে করেছে যেন রিস্ক না নিয়ে সুরঞ্জন কুণ্ডুকে দিয়ে করেছে so he did not take a risk and appointed a district judge, retired district judge.
They know everything, Lordship. They are testing my memory. I am failing into it.
What is this?
Lordship, this is the interlocutory order of 2104, where HR manual they challenged and I said that they have annexed. Lordship, there kindly see the middle portion. I have taken that specific point.
This was what was challenged before us.
No, this is not challenged before you. This has completely, they have not come up before High Court.
So this, give 2 copies at least so that we can look
I'm so sorry, Lordship, because they are testing mine. I am taking out one by one.
Time of hearing.
So, Lordship, there they challenge my HR manual. Ekusher interim order ta dekho 2104.
So they relied on the HR manual.
They said that in that suit, they said that HR man, they took the same point. Yes. While I was arguing, I said, no, it is approved. It is their suit. They have not come up against.
You are the plaintiff there.
Yes, yes. In all suits, they are the
They
plaintiff.
submitted that HR manual does not lay down any procedure to be followed in domestic inquiry.
Yes.
So implicitly,
they accepted it, and then I have shown by my HR manual না এই অর্ডারটা দেখো তো, অর্ডার নাম্বার 2 11/12/2024 এই জায়গাটা দেখাচ্ছি, এই পাতার অর্ডার কই রে, হাকিমকে কি দিলি, এখানে কি দিলি, সেকেন্ড পাতা কোথায়?
স্পেসিফিক্যালি চ্যালেঞ্জ কিন্তু করেন এই ফার্দারেন্স অফ বিচারের বডি তো ফিটিং আছে কিন্তু দিতে চাই না।
দেখো দেখো ইন্ডিয়ান অর্ডার বের করো, আছে বলতে তো আছে। এটা হচ্ছে অর্ডার নাম্বার 8 গো 13/2/2025।
মিস্টেক ছিল না, করে দিয়েছিল
25
আগের বার আইডেন্টি রিকোয়েস্ট করেছিল।
এটা আমি বলেছো, তুমি বলেছো perusal of the HR manual annexed to the petition itself it appears। বলছিলাম না HR manual তুমি
আমি অ্যানেক্স করেছি।
So Lordship, in the other suit we have elaborately discussed that. If your Lordship wants, then I can give a compilation of this order, but then
not a compilation, you can give individual copies of this order later on. You can continue.
First part of it.
Whatever you give us, give a copy to him so that there is.
This is the suit order, Lordship. So this is the order.
You can continue with that.
Now what Lordship?
Page 29.
Yes, Lordship. What I was
29. It appears to be the provisions have been, given opportunity and all.
Yes. So Lordship, what was the tenor of this suit in the ad interim stage? A unfit man and a biased man. There was a game of an unfit man and a biased man.
Unfit way?
Unfit because the UPSC cadre who was appointed outside is an unfit man, and then the biased. So these two persons were playing. So Lordship, I tried to remove at least the unfit person. Then Lordship, I approached to a judicial officer who hold a very high rank till the rank of district judge, Lordship, and then he was our tribunal member also. Then Lordship, I tried to convince him.
Which tribunal?
Taxation tribunal, I might be wrong, my lord.
No, I don't know.
But I'm sure that he retired from.
District judge, no doubt on that. It's written there.
Yes. Second part, Lordship. Lordship, then what I'm only saying is today. So then, kindly see even the scan 2 which is filed. There at least the biasness or unfit person is not set. Now we are on can 2. There is no averment that the present inquiry officer was biased against them, or he is not fit because this gentleman is also above him. That was also not the averment. So Lordship, if I take away those two parts from my earlier argument, then the only point remains. That's HR manual, which they have not challenged properly, and the biasness of that judge. So my matter boils down to biasness and that. Now, Lordship, we will see this inquiry trial itself, because now it has been placed before you. If we see that there is no biasness, because he did not aver anything in can 2 with regard to biasness. So biasness is not there. Now, Lordship, we will see whether that biased man can have any approach here. Now I am arguing against me, Lordship. First is, they did not say anything against my inquiry officer. Now the second part is whether any pleadings is there in can 2 that the gentleman who appointed him or the council appointed him used any biasness on him. That is also not there in can 2.
Yes, we get it. Move on.
So it is not there. So if those two are not there, now, Lordship, we will see how the first 2 meetings and his findings. In fact, they tried to say many a time that since he was speaking to someone else, I was vindictive and issued this. The enquiry officer found that is not a grounded.
Show us that portion.
I will take your lordship.
Need not read the entire thing.
No, how the
Charged
lordship-
officer was heard, did not submit anything. Was he heard personally?
No, he did not that
Appear.
way participate. Lordship, then kindly come to page 33.
But it is stated that charged officer argues that since the
Lordship, kindly come to page 33 now. Please refer to the first meaning in such and such. The meaning states that the presenting of apparent clauses as per submitted such and such. You are requested to direct the presenting officer to give me a copy of the agenda note, minutes of meeting of the May in which the HR manual has been approved.
So didn't hand over this to him. But he had a right to challenge the authority of the inquiry officer in the
He
hearing.
can.
But this is by way of a
Manual
discovery.
is there. Lordship, he will presuppose something. Lordship, he will presuppose something.
If you are penalizing somebody and a hearing is being given to him, he has every right to ask for the authority of the inquiry officer.
That we have given. Lordship, kindly see the first minute.
Ask for the
HR manual approval note.
That has been given.
HR manual approval note I have not given. Today we have given. Sir, Lordship,
This person took a specific point. He wanted to say that the inquiry officer does not have the locus standi because he derives authority under a particular HR manual,
which is not approved.
Not approved. If he takes that point, he has a right to ask for the authority by which HR manual was approved. He had a right. You deprived him of, you did not give him a copy. This is itself bias. I ask you, if you ask for a document, Mr. Banerjee, today if you penalize your client and you ask for a document specifically, under the Code of Civil Procedure, you have a right, inspection, discovery, everything is there. And there are consequences. Order even Rule 21 is there.
Yes, yes.
Your suit may be dismissed, your defense may be struck out.
All my minutes, Lordship, kindly now see, it's a 1961.
Specifically asked for the authority. If he had a right to take the point before the inquiry officer that you don't have authority because the HR manuals have not been approved by the EC.
True.
This is all a question of justice must also appear to be done, Mr. Banerjee.
True.
And that
Very
applies to a disciplinary proceeding also. The principles broadly at least apply. So I mean, what you alternate party is hit because the right of opportunity of hearing has to be a proper right.
I'm absolutely with your Lordship.
He asked specifically, you did not give him.
True. I'm absolutely with your Lordship.
Why this ego?
No, ego is not there. Lordship, someone cannot take
But
me.
what can be the reason for not giving
I'm
you?
saying. Lordship, every minute of a 1961 society is filed with the registrar of the society. Please, if I am not giving him, he can take a certified copy. In the trial, he can participate, he can call for that document.
Did you even give an answer to this?
Yes, every answer.
Show us that answer.
Lordship, I will.
The answer to page 34.
Now, answer is minute 2. Lordship.
That is not an answer.
Lordship,
Did
whatever
not reply
I
to
read-
this.
No, Lordship, kindly see. He has asked for a document which he has access for everyone. Then tomorrow he will ask that kindly arrange my brief and I will arrange his brief so that otherwise it is not.
This
No.
is grossly different from arranging for a brief.
Lordship, kindly see. Lordship,
Inquiry officer was asked the provisions.
can
from-
inquiry officer, I'm saying, I put this question to
Could have said that to him. Could have replied and said
That
no.
is all reflected in his order sheet. All reflected. Lordship, kindly see, when the manual he is asking, it is far beyond the reach of the inquiry officer. Because
He did not ask from the inquiry officer. You have misread this letter. Please come back to this letter at page 34. See the last paragraph, Mr.
Yes.
Banerjee. He specifically says, in view of the above, he gives the reasons. Minute states that the presenting officer pointed such and such clause. You relied on a particular clause. He says you are requested to direct the presenting
no,
officer
the
to give you a
minute
copy.
says that the presiding officer appointed under such and such memorandum of decision manager and approved the HR manual.
You
In view
relied
of
on
that-
this.
And so then,
You relied on this. You relied on a particular document. He asks the inquiry officer direct that person who relied on it to give him a copy so that he can rebut it. Did not given to him.
so it is why it becomes bias. Even that is existing.
Definitely biased.
Lordship, then
At least if not biased,
Then-
Mr. Banerjee, this is absolutely, it hits audio alternate partum. He did not have an educated hearing. I mean, he was not apprised.
Lordship, kindly see what is his challenge. His
You
challenge.
rely on a document, whatever
Lordship, kindly see.
document, Mr. Banerjee, whatever document you rely on. If you rely on a picture of the president also, you can say he knows who is the president. No, you have to give a copy of that picture of the president to him.
Lordship, then I will place what are the affidavit of evidence we have filed. If so, then I will give the evidence of evidence.
It's recording in the minutes. Presenting officer, by pointing to a particular clause, said that on such and such being empowered under section 9.4.6, this meeting.
Lordship, this letter is dated. Kindly don't mind, Lordship. This letter is
29th
dated.
April.
Lordship, then this matter was in the court below, then in the higher court, and all.
But the inquiry office that did not prevent you from moving on with the proceeding.
Lordship,
it was before courts.
Then in the court,
you proceed with that. He also had a right of asking for what document you relied on. Only that.
So the document, which is a public document, because that become a part of the minutes of the society's register. If a public document, I have only. If it is a public document, he asks.
How can it be a public document?
Lordship, has to be a public document. Every minutes and every return is becoming a part of the register of society. It has to
run after the register of society. You might have produced a copy which was not the correct replica of what is lying with the register of company. How does one know? He asked for a copy which was presented by the presenting officer. Presenting officer, what was the difficulty in directing the presenting officer? Give a copy. Come on, give a copy to him. Let him have an informed hearing. He does not get a copy, and how can he rebut that point?
Then, Lordship, I'm putting this question to myself. Lordship, are we not making extreme technical in saying that even it is there in the court now, today it is being produced, but still I found.
Now, post facto, after you continue with the hearing without giving him that document and terminating him.
Post facto. But if the existence of the document.
Yes, very well. Then we'll grant status quo ante. You are right, Mr. Banerjee. You are producing that document. We are not being hyper technical. We'll give him an opportunity to rebut that and restore status quo ante. It goes back to the position on that date when he asked for this document. You give him that document. We won't resort to technicalities. We'll give you another opportunity to have a hearing and have him heard and pass whatever order you like. But if it has to be technicality, if you're relying on technicality, you also cannot be hyper technical. You did did not even care to give any reply to this.
Lordship has to.
Inquiry officer is not acting in the capacity of Mr. Banerjee. Inquiry officer is not a district judge.
No, he is
a district judge. Even if a high court or a supreme court judge operates, he chooses the option, chooses the assignment to act as an inquiry officer of a company, of a private company. He becomes an inquiry officer of a private company. He is not acting as a district judge or a supreme court judge or a high court judge. He is an inquiry officer.
Lordship, allow me 2 minutes time. I will show that they were completely aware of this fact. Then I have to come out.
Which fact?
Of this HR manual. What he challenged. Lordship, we have to divide the thing into 3 parts. One challenge, what he has thrown before the civil court, that is
different. But we want to be sure on this.
I will show him the respect of this.
We'll continue after this. Yes.
Now, Lordship, before I take your Lordship to any other page, let's come to page 7. I will reply that query. Whether that was, first is not required to given. Second, I again say, like approval, I placed it before your Lordship. Here I will say that the inspection arrangement was given. Natural justice has been. Lordship, kindly turn to page 7. We will quickly look into this. No, it was page 7 to 550. Okay. Notice the page. If your Lordship kindly turn to page, pull up. Lordship, kindly turn to page, I'm sorry, kindly turn to page 24. I have given chance of inspection, everything. Lordship, if your Lordship kindly. Page 24 পড়ছে
প্রডিউস করেছে, কোথায় প্রডিউস করেছে?
and 2 at 24.
কিন্তু ওকে দিয়েছে কিনা, ওকে দেওয়ার জন্য ডেকেছে বলেনি, আগে বলেছে। এটা দেওয়ার জন্য ডাকেনি, ওটা প্রডিউস করেছে এনকোয়ারি অফিসারের সামনে। Page 24.
Yes. I will take your Lordship sequentially that he had an opportunity of that.
Yes.
So 24, this is the hearing notice issued on 27th. Lordship got it? Issuing date is 27th, the notice for hearing on 24th. Now, Lordship, kindly turn to the next page 24, page 26. Request for postponing the schedule on 24th, such and such. Because of this, HR manual, inquiry officer defect 1, 2, 3, 4, 5. Lordship has got it. So that on 24th he said so. Now, Lordship, kindly turn to 24th meeting. Lordship, first hearing which held on 24th starts at page 28. Lordship, I have shown that these notices was received by him. Then he duly submit that entire affidavit to be given. Lordship, kindly turn to next page, page 29. Then last but 3 paragraph, the charge officer submitted that he has filed an appeal before the High Court and such challenging constitution of the domestic violence. He submits that until the said order of the High Court such and such domestic violence, the appointment of the inquiry letter is received by him. He will not participate in the proceedings. That is his all determination. Now,
where is that? Where is that?
Page 29, last but 3 paragraph.
Yes, yes. Very well. Yes.
The inquiry officer received by him, he will not participate in the proceedings. That's what his time. Now,
Yes.
Lordship, kindly come to page 30. Last but 1 paragraph. Since there is no specific guideline in HR manual as to how the domestic inquiry will be concluded, the basic principle of natural justice will be followed. So far as the procedure is concerned, the various guideline time to time, Honorable Supreme Court and High Court will be followed. So ensure fair trial. Lordship, this is the first. Now, Lordship, kindly turn to page 31.
Yes.
Page 31. Written objection against the first minutes. Lordship has got it?
Yes.
Before starting the inquiry, I submitted a non-participation letter of my non-participation by email as well as when you reached your office conference room before starting. I have handed over the letter to you, tried to leave the room. You urge me to stay for few minutes to explain my letter. I did so on a number of occasions. I have told you that I am not participating, then I have left the room with your permission. Hence, it is proof that I have not participated in the meeting. So that is categorically, he also said the recording is not wrong, Lordship. Now, Lordship, the minutes acknowledge the receipt of the minutes. In your minutes, you have said has admitted that he received the affidavit of evidence sent to him. Please set out the record, Lordship. Then he said certain things. And then 32. 1 second, I request you to postpone the hearing till any specific order is available from the High Court. Page 32. Lordship, I am just trying to show his conduct. Now, page 33. Next day, he writes, in view of the above, you are requested to direct the present officer give the present of the such and such on the missing in which the HR manual has been approved. Lordship has got it. So this is the letter which Lordship was indicating to me. Lordship, kindly turn to the minutes of the meeting. Next, 29. He gives another letter. Presenting officer by pointing his clause such and such, you request to direct the present officer give me a copy of the such and such of the meeting in which the HR manual has been approved. Lordship has got it. Now, Lordship, kindly turn to the next meeting, page 36. It is exactly written whatever he said in 2 letters. The first minute such and such, the charge officer of first minutes held on this, send a letter on 28 through the email undersigned. The said letter written objection against such, he sent the hard copy of this such and such. The charge officer sent another letter undersigned through email dated such and such. 29. The document where he asked for, with a copy to the Director General and to presenting officer. In this, charge officer prayed for a direction presenting to give him a copy of the agenda note minutes of this such and such in which HR manual. Today at 1, the charge officer served another letter to the undersigned alleging that he has not yet received a copy of such and such from he in this letter has formed an opinion since those documents not received by him, the same do not exist. And therefore, he alleged to prove in the letter he once again submit that the memorandum such and such is invalid in India. Next part. The charge officer has not appeared before the committee till now 255. The charge officer on the other hand claiming he will appear. He will not appear in the meeting, but on the other hand, he is submitting letter to the undersigned on other claiming some of the document for perusal so that he can reply accordingly. The intention of the charge officer is so to contest this case from behind the curtain, which is unjust and cannot be allowed. The charge officer will get a lot of opportunity to defend himself. If he appears, then only he will have the opportunity to peruse all the documents on which the disciplinary authority will rely soon. The charge officer is also authorized to bring another person to help him. In spite of getting such assurance, the charge officer is not appearing. It is learned from the presiding officer. He has joined office today and present in the office. I am therefore requesting the presenting officer to send a message to the charge officer to appear before the inquiry officer. See, he is sitting in the office in the other room inquiries. Now it is 3:10 p.m. The stenographer such and such. In view of the request made by the charge officer in this letter dated this, for giving the copy of agenda note such and such and such, with his format to do not exist, the presiding officer, the presenting officer has produced the relevant document in that regard, on perusal of which the undersigned once again find that HR manual of a duly valid and legal, and hence the memorandum charges such and such has been framed against the charge officer. Basis of such is not invalid or agitated by the charge officer. So, Lordship, there was a direction. We informed he is sitting other room. He is not taking inspection of that. Lordship said, what is my ego to produce it? Lordship, I said, what is his ego to come and see it, Lordship? No, Lordship, the story do not end there. The presenting officer already submitted affidavit of evidence. Along with this, the such and such, the presenting officer tendered the same before the switch. On oath, the presenting officer submitted his affidavit, may be treated as an affidavit in chief, and such exhibit. So, Lordship, now that then Lordship, in this document, they did not annex hearing number 4 and 3 and 4. 5 they have annexed. Lordship, 3 and 4 I have taken printout for your Lordship. No. 3, 4. Again, 3 though. 3 control. 3. 3 আমার হাতে সব 3 তো এই মার্কিংটা 4টা পড়ে দেবো 4 পড়ে আগে 3 my lord can you see 3 একটা কপি কম করেছে বলে 3 এর আরেকটা আছে কপি 3 তো সফট কপি দাও 3 তে ওকে সফট কপি দাও ওকে সফট কপি দাও ফোর পড়ে নিচ্ছি না 3 সফট কপি না পাঠিয়ে দিচ্ছি পরে তুমি পড়ো lordship such and such the undersigned is constrained to proceed the hearing no Senator, the charge second officer served with the charge of on the last date of hearing the second officer requested once again to remain present but he has not appeared he sent a letter such and such peruse the content of the said letter the matter has already been discussed in the meeting since the charge officer is not present and submit anyone this letter the undersigned is not inclined to pass any opinion such conduct of the charge officer once again proves his not interest. The charge officer is constrained to proceed with this ex parte. The officer of such and such, witness number 1, such and such, then lordship examination in chief. Now, lordship, this he did not conclude the examination in chief. Lordship, then he case, kindly come to the last page of it. The next date is the 15th May 2002 p.m. at the same venue. Charge officer is once again given positively along with any person such and such, so that he can cross-examine. He did not peruse, then cross-examine. Now, lordship, kindly see 4th. ওটার পরেই 4th আছে স্ক্রল করলে পাবে মার্কিং কোনটা মার্কিং lordship, kindly see the 4th. Lordship, he is next to me. He knows everything when it is approved, everything. He is just trying to make a technical shell. That's why he did not challenge it. Otherwise, every normal lawyer or his instruction will be a declaration that this is invalid and never passed. He bypassed some way. When I have tried to give him inspection, he did not. When he is alleging very sharply. When I am trying to show that yes, it is there, he is shying out. Now, lordship, 4th. The charge officer, despite repeated instruction given to him by the undersigned to appear before this, has not appeared today, and the proceeding of Dominica against him is being ex parte. The charge officer is not appearing before this. He has sent an email dated such and such, which was discussed earlier in the minute. The charge officer in the dated has claimed that the previous inquiry officer not even resigned as inquiry officer. The present officer such and such. So, lordship, now he is saying that earlier resignation is not correct. Now he has shifted back. Resignation is not correct. Now, lordship, kindly see. The presiding officer such and such submitted, peruse the letter dated 9, wherein it informed the Director General, the charge officer has leveled baseless against an undersigned. I have given all reasonable opportunity of the charge officer from January to participate in the inquiry. However, he never cooperated. Rather, I find action of CO mean to delay the process. The presenting officer also told me that the copy of the officer such and such mentioning the acceptance of the resignation of the served upon. On perusal of the above observation made the previous inquiry such and such in his resignation letter, it is crystal clear that the charge officer is deliberately trying to derail the such and such, and by hook and by leveling such and such against the impeded such and such. The charge officer in his letter dated once again asked for the CC2B footage held on 24/4/2025 to verify the authenticity of the recording of the minutes of this. Now, lordship is shifted. He is not participating. That's what I'm trying to show from these two meetings. They have hid it. So, lordship, what strike the mind that one document asked and why didn't you give? Lordship, that I said. Now, moment he found that those minutes have been recorded, that it is given, he was sitting by the side. Then he said, now the CCTV is there. The hearing is being held in the conference room of the institute, and the presenting officer submitted that the conference room is not covered under any CCTV. Therefore, the question of production of such and such, the stenographer submit that, then the examination in chief is resumed. He resumed this, concluded in chief. It is learned that the charge officer, next page 3, internal page 3. Joined today, it is now, kindly see, after that. The presenting officer conducted his it is learned that the charge officer has joined his office today and is now available in his office. The charge officer is therefore once again requested to appear before to cross-examine the presenting of his defense. He is liberty to see all CCTV footage so produced by this, and he may take assistance of any other person to CCTV footage is that he was talking with someone, what he was not doing. So all CCTV footage we produce before him. So then again, he is sitting to the next room, he is not coming, and then he is saying, give me the CCTV footage of that conference room. In order to give his opportunity, the undersigned is again adjourned the meeting for 15 minutes, and now the present request to inform that so that he appears the cross-examination second best charge of in order to give na suppress kotata bola jabe. So Lordship, in order to give you opportunity, again 15 minutes. So every time he is sitting just outside, it's not a very big room, it's not like a high court. Lordship is just like a few hundred square feet. Lordship, this is the way he dealt the inquiry officer. This is the way he dealt the entire domestic inquiry proceedings. This is the way he filed three.
The inquiry officer himself cross-examines, in fact. Since he did not come.
Yes, because
for him.
like 165, he exercised his power under 165. I mean, now the new section, I don't remember. Earlier 165. That is the judge's prerogative to ask. Or even order 10 rule. So, Lordship, he can, the judge has the power to call upon any officer or any person before him to examine. That is there in the CPC, and 165 is the evidence. So, Lordship is there. So, he exercised from all angles.
And he asks good questions, in fact, in the cross-examination.
Of course, Lordship, I mean, so Lordship, he tried. And
4 is very specific. Question number 4 in cross-examination is very specific.
Because of your choice association, this is I have MBA from it is a reputed institute of education human resources. I have given the charge of HR. I have no role to present that again. Presenting officer George. Before I took him to there, he reached there. So, Lordship, now if this today, Lordship says me that only that document was not given to you, and so I will reverse it. So, Lordship, every time I have shown that if the meeting was adjourned for 15 minutes, we called him, he did not come. And then he started shifting this prayer. So, after we say that that is there in the report, you come and take inspection, then he shifted that I need a CCTV footage. The cross-examiner, since the charge officer, despite repeated requests to the last 4 days, did not appear, the undersigned is inclined to close the hearing. The such and such, and then the order has been passed. So, Lordship, kindly see how the inquiry has been done. Now, Lordship, I will take you to the Lordship to the inquiry 5th, which Lordship will get at page 7 and onward of the supplementary. Final order. Lordship, in the final order, since it was an employee and all the judges usually very soft on the employee, Lordship, he cornered us. চারটা দেবে চার নম্বর তুমি তো এটা 3 দেখলে না 4 দেখে নিয়েছো তাহলে ঠিক আছে Lordship, kindly, the charge officer is in your absent, but he has sent email to the undersigned today. In the way it is once again claimed that the entire proceeding is invalid. Hence, once again, the claim the entire proceeding of the domain is invalid and the reason is not participating. The peruse the content of the letter, these were already discussed the earlier matter. This Therefore, the undersigned is not inclined to pass any comment. Let this matter be kept on the record. In the minutes of this, the charge officer given an opportunity to cross-examination. He did not appear by sending letter, and he expressed in not to appear. The undersigned therefore had no option but to conclude the evidence. The presenting officer submitted the written notes of document, Lordship. Then I am not going there. Report, since it is not appeal court of this. Lordship, I am not taking your Lordship. Kindly come to page 14. Lordship, kindly come to the page 14. I will show what are the things gone against me. Page 14. Lordship has got it. Lordship, last sentence of para 24. Under such circumstances, the undersigned is of the opinion that the talking inside the office during the office hours by the CO is not coming within the definition of the misconduct as enumerated as such and such of the HR man. Lordship, it was shown that on that basis we were holding. The inquiry officer said, no, I will not take into account how many times who has talked with him. I will say whether the task given to him has been completed or not. Next, while summing up this, I find that the charge level against the committing this clause this of the manual is beyond doubt. The charge has shown extreme apathy towards the job allocated to him, did not submit any progress report which he was supposed to submit regularly in compliance with the official order, did not achieve the target, such and such. The charge officer is always defiant more and such and never care to comply with any of the orders of the superior. He challenge each and every steps taken by the Director General, who is at the aim of the such and management. The charge officer left no stone unturned to drag the such and such and such and such. The charge officer tried to derail the proceeding, such and such and such. Then Lordship is fine. So Lordship, then if your Lordship today holds me that this was a setup inquiry, Lordship, then I am the last person to accept it, and then Lordship, I will try to fight till my last. The Lordship, now today what I am saying is, he did not challenge in the civil court. He did not take inspection in the inquiry. So Lordship, then if I sum up, then he has 3 suits against me. In none of the suits he has gone this. He did not succeed in getting that stay order of this. So it has fallen. Lordship, then he bullet কথাটা ইউজ করা ঠিক হবে না, কি বলবো বলুন? He deliberately, Lordship, tried to touch very sensitive parts of the inquiry. Then Lordship, he did not participate in that. Now Lordship, he is coming back to your Lordship without, he knows that he has appeal. He comes back here for the status quo. He has always right of challenge in the appeal or in the civil court as a whole.
Another very important aspect has come up from what you placed before us. Although it was not stressed upon you, but we find it from page 30 of Can 2. The inquiry officer specifically says that HR manual will not be followed. Principles of natural justice I'll follow.
No.
Please
he
come
said,
to,
yes.
please
He
come
said, Lordship, so far as the procedure is maintained, what procedure to be
since
followed?
there is no specific guideline in HR manual as to how domestic inquiry will be conducted.
Yes.
The basic principles of natural justice will be followed.
Yes.
Therefore, the argument that HR manual is not applicable, I mean, even generally, we are speaking in your favor for the time being, that even if HR manual was not applicable, inquiry officer says general principles of natural justice, insofar as the procedure is followed, will follow.
So
and that has been followed, and he has been given repeated opportunities sitting in the next room and all, knowing CCTV is not there, conference room, and all these things come up. So therefore, even otherwise natural justice principles were followed. So as we were saying, audio alternative partem, that has been taken care of by this observation and the subsequent minutes which you have placed before us. Apparently, subject to what they say.
My lord, those 2 documents which I handed over, an earlier document, kindly take it on record. Because this is the ad interim stage, ad interim appeal.
3rd, 4th meeting and this 49th meeting of executive.
48 and 49. Including the working committee report. There is a working committee report also. Now,
That working committee report was the basis of the adjudication.
আমাদের কি কাল
Mr. Banerjee, the working committee report was the basis of the adjudication.
No. I voluntarily disclosed everything that how it happened.
Working committee report regarding what?
Formation rules, how it worked. It was not formed in one
We are
single
interested
day.
in the 49th meeting where the HR manual was.
No, working group meeting, this is where it was approved. And 48th, it says that it has already been approved. And my learned friend placed
No, we'll
a
hear
rule.
it. We'll hear
Lordship,
it. Good.
So, Lordship, এটা কোনটা দেবো?
Anything else?
I have given a both side photocopy.
No difficulty. Easier for us.
Now, Lordship, I have.
It's not a both side photocopy. Not a both side.
Yes, sir.
আপনাকে both side photocopy? থাকুন, অসুবিধা আছে কেন? both side থাকলে সুবিধা, ছোট হবে, পাতলা হবে। কোনটা both side?
Highlighted one question. And Lordship on the.
ঠিকই তো আছে, both side না তো?
ওটা দাও।
You might have given both side photocopy to Mr. Ali.
তাহলে ঠিক আছে।
I think so.
And Lordship, on the other day, I have already shown to your Lordship that when the bylaws.
Yes.
I have shown that how the working committee forms from the bylaws. Under which provision, Lordship, on that day, I have shown that how the.
9.6 point.
Every point, Lordship, I have.
Yes, you had placed several points.
Where is tab? Lordship, we have given that how the working committee will form, how.
We'll take a short written notes from you also, both of you. Just bullet points, only those points. Points you have taken note of basically, but yes. So that is all. Thank you. Yes, Mr. Ali, short reply.
Firstly, my lord, I would like to say about the suits. Lordship, there are 4 suits, including this one. The first suit, when I got the first show cause notice with respect to my alleged misconduct, I filed my first suit. There, I secured an interim order before this honorable court that no coercive action be taken. Lordship, during pendency of that suit, the second show cause comes. By that time, I had already filed a suit challenging the appointment of the respondent number 3.
Inquiry officer, then inquiry officer.
The Director General, not the
the
inquiry
Director
officer,
General
the
himself.
Director General.
Right.
So that is the second suit, the appointment of the Director General. The third suit, I only challenged, it was restricted to the show cause notice because at that point of time, I did not know show cause notice and charge sheet. At that point of time, I did not know whether the HR manual has been approved or not. So the third suit was confined to that. Now, it kindly takes my pleading apropos that paragraph 34, which is a verbatim reproduction, my lord. Paragraph 33 of this stay application, which is also in this plaint as well as in the injunction application, page 25.
Can 1.
Of can 1, my lord. The petitioner, may I, my lord, please?
Can 1 is page 20. Can 1, mota, sabse mota.
The fat one, my lord. the fat.
তলা একদম তলা। ওটার পেজ 25, page 25, para 33.
I'm sorry, my lord. Page 25.
Para 30 তলা para. Yes, Mr. Ali.
Yes. The petitioner has recently come to know that the HR manual, which has been relied upon and issued pursuant to the said and or issued pursuant to the said HR manual in all notices, including show cause notice dated 1st November 2024, letter framing charges against the petitioner dated 20th November 2024, and letter of appointment issued by the defendant number 3 in favor of the defendant number 4. This is the old inquiry officer, dated 1st January 2025, has not been adopted by the Executive Council of the defendant number 1. Thus, the HR manual issued on 1st September cannot be relied upon. 34A, the defendant number 4 is not eligible to act as the inquiry officer for
Sir,
the following
Ali,
reasons.
how can you say you recently came to know it was not adopted? We could have understood if you recently came to know that it had been adopted. But till you know that it is adopted, you always knew that you did not know that it was adopted. You never took this point. This point was open to you to be taken at all points of time in all suits.
This HR manual was circulated by an email to all the employees. Lordship, we have continuously asked for whether there has been any adoption by the Executive
So from
Council.
the inception, whenever it was circulated, when was it circulated? Before your first suit?
In 2022.
Before your
Before
first
my
suit.
first suit.
So therefore, from the inception, it was open to you to contend that this HR manual has not been adopted.
Yes, but my lord,
If you
I
don't know
assume
it has been adopted, that you
I assume that the respondent number 3 would not be so crass that
not a question of being crass, because you also cannot be taken to be so naive that you don't know that it has been adopted, but you don't take the point.
No, we have asked for
not a negative. I mean, you cannot come to know suddenly that it has not been adopted because they did not specifically tell you we have not adopted. Never. Nothing is there. So
Huh?
that position remained from the inception. How do you know that it was adopted?
Huh?
And there is the jurisdiction point, basic authority point.
What I'm been instructed, my lord, that we inquired with the registrar of societies. Only then we came to know that there is no such document which is there.
Inception.
No, that was not from inception, my lord. That is recent.
Yes,
that
it
is
could have
why,
been
lordship, we could not take the point in all the other suits.
This is not a defense for not taking the point. The point could have been taken because subsequently, if you came to know that it has been adopted, it would be different. But from the inception, you had no knowledge that it has been adopted. You are the second man after the Director General. If you
Yes, but I'm not part of Executive Council.
If you don't,
and since since the respondent number 3 has taken charge, lordship, I have been
is the
kept
Director
out
General a part of the Executive Council?
an ex officio as a secretary of the Executive Council.
He's a part of the Executive Council.
I am not.
So very well. Then, if you did not know that that HR manual has ever been adopted, could have taken this point. It has not been adopted.
I did not know that it has not been appointed. I assume that it has been adopted by approved by the Executive Council, and I have proceeded all throughout that assuming that it has not been approved. It has been approved.
What is the basis of your assumption?
The
You
basis
are
of
facing an
assumption that
inquiry.
the presumption as per
You are facing an inquiry. You are. It's open to you to take all points. Should have taken this point.
Lordship has seen how hostile the respondent number 3 is with
We've
respect
also
to
seen how
yes,
adamant
yes.
you were. We also have seen that.
Lordship. But
till Mr. Banerjee placed those meetings here, we were acquainted only with their hostility. But now we see how adamant a person can be. You are
Lordship,
sitting in the next room
my
repeatedly.
my
You are asking
stand.
which CCTV footage. Don't you know in the next room, in the conference room, there is no CCTV? You
No,
are the
not
second
the
man.
No,
They
not
have
the CCTV.
taken a point. You asked for CCTV footage of that meeting also, their meeting.
Of their meeting.
Yes, in the third. It was placed by Mr. Banerjee at length. You were
I was trying
unmindful.
to tab. Those things were not there. I was asking which was being read. Anyway,
he read it out in open court.
I was trying to.
And all these things, at least on 3 occasions,
the CCTV, lordship, I'm not
very well. But you are sitting in the next room. You are asked. He could have taken this point.
Lordship, my stand has throughout been
taken this point before the inquiry officer itself. Why didn't you take it? Repeated opportunities given to you.
Lordship, may I place those then documents, my lord?
What documents?
Lordship.
This here it was placed
kindly
at length.
takes can 2. No, only 2 documents, my lord.
Third and fourth meetings, first of all, were not annexed by you.
No, third and fourth, my lord, somehow it has been missed.
Third and fourth, repeated opportunities given to you and recorded. You are sitting in the next room.
Lordship, but it was.
Do not come after being called. It's like a hide and seek game. You are behaving like a child. You are being called. You are not coming. You are taking points, and inquiry officer was apparently right in saying that you are playing Meghnad, sort of.
Behind the curtain.
Behind the clouds.
The cloud.
Curtain, clouds, whatever. Lordship, kindly. You're writing letters, shooting of letters, give me copies of the CCTV meeting where you refuse the invitation to come to that meeting itself physically.
Lordship, how there has been
Understand this?
wrong recording, Lordship, may I place that, my lord, once? Lord, kindly takes page 26.
26, yes.
Page 26 of Can 2, my lord. Lordship, here, my lord, I'm writing. Please refer to your notice. I would like to inform you the following. Number one, HR Manual 2022, you have referred to in your notice, has been promulgated, which is effective from before the sale CMA rules were being followed since inception. However, as per rules and regulation of INSTAG, section such and such, the Management Executive Council is the only authority to approve any new rules. The HR Manual 2022 of INSTAG has been approved by management till today. Has not been approved by management till today, hence it is invalid. Therefore, Memorandum of Charges dated 20th November issued is invalid and illegal. Your appointment as an inquiry officer is too invalid and illegal for the same reasons.
This was after this was after you received the information from the Register of Companies.
This is after, during continuing of this appeal.
You said that you came to know that it was never adopted.
Yes.
You have alleged that in Can 2.
This is during pendency of appeal.
No. You have stated in page 25, at page 25 you placed
Yes, after my information. After the information that I got,
this letter is after that. This letter is after that.
Much after that. When the first hearing took place, my learned friend assured that nothing will happen and this inquiry officer was appointed. Lordship, this is 1 to 5. Yes. I have said.
Now, how does the Register of Companies know whether the...
Not the Register of Companies, the Register of Societies.
Or is the Register of Society has any means of knowing whether it has been approved by the EC?
Because they have to give the approved rules to, they have to file it, the approved rules to the, all the documents are required to be filed with the...
Did you take any information whether this HR manual was given?
Lordship,
it had been given to the Register of Societies.
No, we have inquired that it has not been.
Only then I came. Yes.
Only then I came to know that
HR manual was never given to the
never. Lordship, today
is there any requirement in law to do that?
Yes, yes. I have brought the act, my lord. The act, the rules. There is a requirement.
You should have taken this point all along. I mean, why you could have asked the Register of Companies that before you file your suit even.
Lordship, the delay has occurred because I have been asking for documents.
Of your blind faith in them, while you were filing suits, 4 suits.
Lordship.
And you had so much faith.
I must be candid, my lord. I was so sure about this point that there is no approval. That till date I have not participated in that meeting. That was the sole reason.
You should have participated in the meeting and taken the point in the first.
That's what I'm going to show, my lord. Lordship, kindly see page 28. In between Mr. Banerjee such and such, there was a statement which was made by me.
Yes, first hearing.
Page 20, first hearing.
Yes.
Lordship, the last para of this page. The charged officer, Mr. Oshim Kumar Samanto, has however made submission on a number of points to establish his claim that the steps taken by the disciplinary authority by serving memorandum of charges against him is invalid, illegal. In clause 3 of his application filed today, the charged officer has submitted the HR manual of INSTAG on the basis of which the memorandum of charges was issued against him, has not been approved by the management till today. In support, he mentioned in clause 2 of the application dated such and such that as per rules and regulations of INSTAG, section 9.6.4c of the rules, the charged officer argues that since the HR manual has not yet been approved as per section such and such, the memo of charges drawn on the basis of HR manual is invalid and not acted upon. Now, kindly see, the presenting officer has produced the memorandum of association registered on 26th August 1996, and on perusal of section such and such, the memorandum of association, the undersigned finds that the Executive Council is authorized to make bylaws time to time for management of INSTAG as they think proper. The presenting officer, by pointing this clause, has submitted that on being empowered by the by section 964C of the Memorandum of Association, the management has approved the HR manual of 2022 of INSTAC. The presenting officer submits that all procedures as required by law has been strictly followed before introduction of HR manual, which had come effect from 1st September 2022. The charged officer has, however, not submitted anything on this point and has also not denied the claim of the presenting officer that all formalities as required by various provisions of law were strictly followed before introduction of HR manual. The undersigned therefore finds that the submission of charged officer as mentioned in clause 2 and 3 of his application dated such and such has no substance. Since the memorandum of charges was issued under HR Manual 2020 of INSTAC, which is apparently found valid and legal by the undersigned is not finding any merit in the submissions of charged officer that the appointment of undersigned as inquiry officer is invalid and illegal. So, my lord, the inquiry officer comes to this finding in the minutes. Now, I have given my protest with the recording of this minutes. Let's kindly see page 31.
You have protested by not participating.
Lordship, the incorrect recording
taken by you, turned down by the by the inquiry officer. Still, you don't participate.
Lordship, why I did not find any faith, my lord? In Lordship, kindly your minutes you have recorded a number of wrong statements. Few of these are Lordship 1 and 2. I am not bothering Lordships. Kindly see 3. Regarding the approval of HR Manual 2022, you have recorded that the presenting officer submits that all procedures as required by law have been strictly followed before introduction of HR Manual, which has come to effect from 1st September 2023. The charged officer has, however, not submitted anything on this point and has also not denied the claim of the presiding officer, presenting officer, Manual 2020. This is a false statement in totality. When I have informed you about the invalidity of the manual before starting of hearing, the presenting officer was silent. You might have discussed the issue after I have left the room, so it was not possible for me to interfere or deny. However, in the subsequent line, you have concluded that HR manual is a valid document. You did not mention the name of the documents you have verified to draw such conclusion. Regarding the court cases in your Lordship, I have talked about the present appeal, and I have done the last 3 lines. I have even requested you to watch the video recording of the hearing. I have also sent you the link. This is the link of Calcutta High Court website, my lord, of the YouTube link. There's a small video clip, but you have not mentioned the same. So, my lord, I have specifically, so it was,
but then again,
the inquiry officer comes to the conclusion he has jurisdiction.
In the second hearing, you had been sending your written objections without appearing. Page 36 bottom, it has been recorded that you have stated that those are invalid and illegal. All your objections have been recorded. Page 37, it is stated that the charged officer has not appeared before this committee. Charged officer on one hand is claiming that he will not appear in the hearing, but on the other hand, he is submitting letters to the undersigned one after the other, claiming some of the documents not.
Yes.
The intention of the charged officer.
Had it been
if he appears, then only he will have the opportunity to peruse all the documents on which the disciplinary authority will rely upon. You have to appear before the charged inquiry officer to get the copies.
Lordship,
The charged
I have challenged the jurisdiction. The inquiry officer in the first hearing comes to the conclusion. Post conclusion, Lordship, I only want the agenda notes and the minutes of the meeting or whatever
of the executive council. Still, you are continuing
on
to
the
want
executive council on which the inquiry officer has relied upon.
Even after his adjudication, you ask for those documents. You do not come. He says that if you came, you would have got those.
Yes.
And
Lordship, Lordship will see what he is writing.
Please come to page 37, 310.
Yes.
It's specifically recorded in view of the request of.
I can only see, my lord.
On
that is what is written. The charged officer on one hand is claiming that he will not appear in his hearing, but on the other hand, he is submitting letters to the undersigned, one after the another, claiming some of the documents.
That was presented.
Yes. The intention of the charged officer is to contest.
Mr. Ali, 1 minute. 310, it's recorded in the second paragraph. Please read out second paragraph after 310. Please read it out loudly.
310.
It is now 3:10 p.m.
It is now 3:10.
Second paragraph
The
after that.
stenographer, Mr. S.P.
Second
Samant,
paragraph after that.
in view of the request made by the charged officer in his letter dated 29/4 for giving him a copy of agenda notes and minutes of the meeting of Executive Council meeting, which in his opinion do not exist, the presenting officer has produced the relevant documents in that regard, on perusal of which the undersigned once again find that the HR manual of Instag is apparently found valid and legal, and since memorandum of charges has been framed against the charged officer, the same is not valid as agitated by the charged
Now
officer.
let us stop here. Our specific question to you is, if you don't appear before the inquiry officer to participate in the proceeding, the documents are produced, how is it expected that you will get to look at those documents?
They are prudent enough to give the affidavit of evidence by email. They are very prudent in that point of time. This point, only with respect to this agenda notes, Lordship, even Mr. Banerjee said that I have tried my best to keep it with myself. Lordship, why it has been kept out, my lord? Lordship, kindly seize the bunch of documents now, my lord. Before that, I will place page 73 of Can 1. Page 73, 9.1c. Page 73.
Yes.
The Executive Council may delegate all or any of their powers to any subcommittee, person, branch, or body of association. So, my lord, the Executive Council may delegate all or some. Lordship, my learned friend has relied on page 7, where it is the record notes of the 5th working group meeting held on 12th August 2022, where apparently the HR manual, the requirement for HR manual was approved. HR manual. Yes. 3B. The death benefit scheme for the family of S.K. Puri was discussed in line with the provisions of the, I'm sorry, 3A. The human resource manual, including the delegation of powers and the purchase procedure as circulated along with agenda points dated such and such, were taken up for discussions. The highlights of the changes compared to prevailing sale rules were presented. The WG approved the HR manual with the DOP and the purchase procedure. It was advised to keep the EC informed. The Executive Council, so my lord, the HR manual, the so-called HR manual, was approved in the working group meeting. So, my lord, the first thing that is required to ascertain that whether clause 9.6.4c, which was to make the power of the Executive Council to make bylaws to appoint, dismiss, and exercise full control regarding working of employees of association, has been delegated or not?
49th meeting, because the EC approves, ratifies that. EC says at page 11 of that bunch. EC noted the
EC
information.
says that it has already been approved.
Yes.
So we are not discussing on it.
Therefore, it is ratifying it. It presupposes that working group was empowered. EC says itself, it was informed that as per decision of the 48th EC meeting.
The EC was informed that as per decision of 48th EC meeting, HR manual, it is
Yes.
the approval is in the nature of information, my lord. EC was informed as per decision of 48th EC meeting, revised delegation of power purchase procedures has been made for Instag, and they have been already been approved by the working group.
The decision of the working committee, working group.
But my lord, even then, the working group's decision and the delegation, that's if they have to show that they're at all delegated or not.
Never been challenged by you till date.
The HR manual. This we are getting it now. Which they say that yes, I have kept it out from them. I've tried my best.
You said you came to know from the Register of Societies.
Only immediately after that, we have filed this suit.
In the suit also, you have not challenged the HR manual.
Lordship, I have asked for an injunction, my lord, that they should not
proceed. There may not be an injunction pursuant to that. This is that. That does not mean that that is invalid.
Lordship, there is a pleading that it is invalid.
Where is the relief?
There is that the different thus the paragraph 20, page 26, thus the HR manual issued on order cannot be relied upon. And the relief, my lord, all I have claimed is the permanent injunction, press C, from giving effect or further effect or acting pursuant to or furtherance to the HR manual.
Anyway, you could have taken all these points by appearing before the inquiry officer.
Lordship,
There was no bar. Every
Lordship,
point
the
can
last,
be taken before the inquiry.
last the fallback mechanism, which I have taken instruction. Lordship kindly grants me that opportunity.
You have been terminated. After that, how can you reopen that issue?
Lordship, kindly, Lordship, because I was all throughout. I relied on the fact that it has not been approved. And
appeared and argued. Since that was turned down by the inquiry committee, your next step would be to contest it on merit. If you challenge ultimately the entire process, you could have taken it within the fold of your challenge.
As I have
but
said,
you choose not to appear there.
As I have said, my lord, I was so sure about the fact that it has not been approved and there is no such document. We thought that everything will go from the root. It will be uprooted because no document was given to me.
They have produced documents now.
They have produced before your lordships.
How could you be so sure that that has been not been approved?
Because they were not showing it.
So that's why you knew that it had not been approved. You make your own assumption. You abstain from the hearing, every hearing of the, and you continue writing objections in writing.
The objections, my lord, I'm not sure about
how an inquiry proceeding is conducted. You are the accused officer. You have to appear before the inquiry committee and take the point. That point was turned down. This person was a retired district judge. How could he be even? I mean, there is an allegation of bias. You are not alleging that.
I have not alleged that, my lord.
But even
what I'm only saying is the inquiry.
According to you, if the HR manual was not in place, then what would be the procedure for an inquiry?
The executive council would have
it itself would have conducted the inquiry.
The executive council, the president would have appointed
conducted the inquiry.
No, the president would have appointed the.
But there was
the inquiry officer.
There was a complete absence of any procedure on that, either in the sale rules or even in the HR manual.
No, sale rules. There's no absence. The president can, lordship, appoint an inquiry officer. Lordship, in fact, lordship, if lordship recalls, it's impossible to recall. Lordship hears so many matters. On the first day, when during the era of the first inquiry officer, lordship, we said that lordship may appoint any inquiry officer. We are ready to participate. And then it was decided that we shall agree on a name and come.
Ultimately, a retired district judge has been appointed. Why didn't you participate even before him? What could be your point on that? Whoever has appointed, he has been appointed. There is no allegation against him of bias. Why did you appear before him? Just appear before him. Whoever appoints.
Lordship, I have been, as lordship said, that I was in the just next room. I did not participate. I have said, I have asked that you do not have any jurisdiction. There is an appeal pending. I have given him the link of the first hearing.
Pendency of appeal does not mean anything.
Pendency of it does not. But the assurance given by Mr. Banerjee ought to have been honored by
it does not come into the picture at all. Cut out Mr. Banerjee out of this. Your counsel, we are not, whatever, what assurance he has given.
Lordship,
you don't participate. Your point is turned down. Still, you did not participate. Now, your previous argument, they have cut off your previous argument. They have preempted that by appointing a district judge.
Yes.
But so whoever appoints, you appear before the district judge and make out your points. Cross-examine the detailed report was filed. Everything was before you. You could have just cross-examined the presenting officer. You did not do anything. You said that I would not participate because you don't have jurisdiction. After the point was turned down. This is absurd.
The number one criteria for any disciplinary proceeding, lordship, it is quasi-criminal. Lordship, they have to prove their case. And the basic natural justice is I must be allowed all the documents on which the inquiry officer relies on. If the inquiry officer comes to a conclusion that he has jurisdiction on some
what
documents.
What was not given to you? You are not
the
given
approvals.
No, no, the report on the basis of which it was the presenting officer's report was not given to you.
Not the presenting officer report, but on the
that
basis
is
of
the-
which he decides his jurisdiction.
No, no, not jurisdiction. Jurisdiction is a separate issue that has been turned down.
Lordship, but at that point of time,
But you had the report on the basis of which you were incriminated ultimately.
yes,
You could have cross-examined. Oral evidence was taken. You could have cross-examined. You did not you chose not to participate at all. You played an ostrich. You bury your head in the sand and you say that I can't see the world, therefore the world won't hit me. There is a disciplinary proceeding. This is not a child's game.
no, my
You
lord.
take a point of jurisdiction that is turned down by the inquiry officer. He's a retired district judge. There cannot be any palpable, expressive allegation of bias against him. And you do not take any point, you do not cross-examine the presenting officer on all the documents. You let it go by non-traverse. And ultimately, you have been terminated on the basis of that. And now you come up and say, no, I was of the belief on the basis of the goodness of the Director General, whom I have challenged in 4 suits, that yes, this must have been, there must have been some approval.
But the document which was before the inquiry officer, on the basis of which he decides
It was
his
before him,
jurisdiction,
even on the third hearing probably, which
Yes.
was, it
the
was
inqui-
there.
the
It was
inquiry
evidence
officer says,
presented.
if you come, you can come and see.
Yes.
Why not a copy given to me? That
Why
is
didn't
the
you
only.
go and see? We often offered inspections.
Yes. In the second minutes after he decides in
In
the.
a suit also, you cannot have a better right than a suit. In a suit also, always copies of documents are not given to you. Inspection is meant for that. You had a right when the document was presented before the presenting officer. You don't go there. You sit in the next room. Could have just been present there and look at the document and take your points.
Even in my opening arguments, Lordship would recall, I only pressed this point that there is no HR manual.
Whatever
And
you
now,
have
Lordship,
taken.
these documents come.
No, the minutes where you are given opportunity notice at every. Please let him finish, then we'll argue. This is very disturbing. Please take your instructions at one go and then we'll talk with you. This is not possible for us. This is not the way. This is like the inquiry officer.
Yeah, I'm avoiding. I'm
Yes, yes. Yeah,
not
we
even
cannot cut
considering
him
his
off because we can see we can visually see him. It's a continuous disturbance. He's becoming a pest. Let him finish. Yes, please finish your consultation. No, have it, Miss Ali. Please take your seat and have your consultation. We'll give you 2 minutes for that. Have it, please. Because this will go on. Please take your seat and have your conferences. We'll give you we'll give you 2 minutes. Please have it. Complete it. No, complete it, please. This is very disturbing, we are telling you. We are visually, you cannot see him. We can see him all the time.
most passionate of the matters are pro bono matters.
If you
So
are
that
passionate
is
in a
the-
matter, Mr. Ali, the moment you are passionate in a matter for your client, you should leave the matter. You are an officer of the court first.
I'm not. That's
and
why
you are an officer of the court last. If you are so passionate, you are personally involved, leave the matter. Let somebody else, neutral person, come in. We can be passionate outside court. What do you think? We are computers. We are hardware. We are a combination of hardware and software. That we are. But that's a different belief system. But we are human beings also. Passions flow through us also, all along.
That is
When
why
we hold against a person, extreme passion flows through us. Through you also, when you are arguing a matter. But we have to take control of that. That cannot mean you can disrupt the court like this. He's continually doing this. Please have a conference.
I apologize, my lord, on his
No,
behalf, my lord.
don't apologize. We are not
No, my lord,
anything, not personal.
No,
but
I'm disregarding all
he
instructions.
was
that he
saying
gives.
something. Please listen to him so that you make a complete argument. Please listen to him. Every question we put, we see your head turned that way because he's speaking to you. Mr. Ali, we cannot go on like this. We are not habituated to this. Please let him finish. Take his last instruction and let him stop. Please.
Anything that you want to say?
Because this disrupts the hearing entirely.
That is why, my lord, I'm saying that the 2R is human, as the lordship said.
No,
Lordship
we
would
are-
put me back to the position before the inquiry officer. We shall participate.
we are very specific here. Your conduct does not impress us. Yes, we were with you up to a point. Definitely, we are still with you up to a point, but not beyond that. An inquiry proceeding is going on. You take a point regarding bias. That person is removed.
That person is removed.
District judge, no allegation of bias against him. Now, then You take a point of jurisdiction that you don't have authority, HR manual is not approved by the EC. He turns it down. You write to him in a written letter that you recorded wrongly, that accepted, might have recorded wrongly. You had a notice of the second hearing. You could have gone there and argued this. You could have gone there and asked for a copy. It was placed in the third hearing. The document was placed itself. He relies on that in the hearing itself. You don't appear there. If you would have appeared, you would have got to go through that document, and probably, Mr. Ali, if you're a sane, reasonable person, you would not have, if there was no other point, you would have considered to that point, and you had to cross-examine. You don't go there. You say categorically in bold letters in your writings, I would not participate. Why? You lost your opportunity to go through that document. You lost your opportunity to cross-examine. You could have cross-examined. Maybe your cross-examination would have revealed that you have not been guilty of any dereliction of duty. Given several opportunities, Mr. Ali.
Only thing, the reason that I may think of, Lordship, my suit, the prayers are declaration that defendant number 4 is not eligible. That goes, my lord, because defendant number 4 is no more. B, permanent injunction restraining defendants from giving effect or further effect to the letter of appointment dated 1st January 2025. That also goes. The C, permanent injunction restraining defendants from giving effect to the HR manual issued on in connection with the disciplinary proceeding. This is the only
Is
relief.
this permanent injunction relief, Mr. Ali? Tell us
This is
truly.
only.
Tell us truly. Without a specific declaration that this HR manual is invalid, can you ask for permanent injunction directly? Unless you put up a challenge to the HR manual. Can I directly come to a court? Let us forget the first two. You tell us as an advocate. Forget that you are representing.
That prayer ought to have been there.
Can I come before a court and outright make a permanent injunction prayer? I file a suit for permanent injunction, restraining them from proceeding on the basis of an HR manual, without putting up a challenge to it in the first relief. Can I ask for that? Can you ask for that injunction independently?
That ought to have been there.
That is the difficulty.
That ought to have been there.
If that injunction, if it is taken, then also without a declaration preceding it, challenging that HR manual, this does not mean anything. I cannot just come up and say that please grant me a permanent injunction restraining the such and such person from acting as that authority. Is that
without challenging the HR manual? That
yes.
we can incorporate later, because the pleadings are there. It is not. It won't be
one line of pleading, yes.
The
But that also probably is in murky waters because of what they produce. They are equipped with documents. Now we know.
Now,
but you can challenge that you have got grounds.
I'm saying that the only reason why he has not participated, perhaps, because that would make my suit infructuous.
Why?
By saying that, because I have already, because I am saying that the show cause notice, etc., should not be given effect to, because it is on the basis of HR manual. Now, if I participate, so I am just submitting to the jurisdiction.
Accepted, but if
my suit becomes
you ask for an injunction before the suit court, that ad interim was refused. Further proceeding was refused.
And Lordship,
that you had no option but to participate, and it would be subject. It would be subject to the determination in the suit. Everything would go if you succeeded in the suit.
That will be decided in some time.
Now there is no scope because the inquiry officer, your premise was wrong. Your first premise should have been HR manual challenge. And if you say that permanent injunction challenge incorporated a challenge to the HR manual, then before the information from the Secretary of Societies, you knew that. That's a self-defeating argument then. Then you could have taken that point before the...
that argument is still... This changing of HR manual also won't be enough. That is rule 8 and 9 of the Act, my lord. Section 8 and 9.
There is no challenge to the HR manual in any event. And if you say that that permanent injunction included a challenge to the HR manual, Mr. Ali, then you could have taken that challenge before because your other logic goes then that before I wrote to the companies, the secretary of this registrar of societies, and that information I got, I could not know. But if you could not know, then that injunction could not be deemed to incorporate that challenge to the HR manual because you did not know.
I could not follow.
Sorry. That permanent injunction suit was filed before you wrote to the secretary of the register of societies. Is it?
I did not write, my lord. I came to know that it has not been approved. There is no such intimation with the registrar of society.
That you came to know after filing of this suit?
Before suit.
Before suit.
That is the cause of action for filing this suit. That is the precise reason.
But then you could have taken that point before the district
But
judge also.
since it was all verbal, which was given to us, my lord, that's why perhaps.
That's a double speak, Mr. Ali.
Yes.
I mean, if you could not take that point, then
no, that is why.
Then you could take that ground in the declaration. You could have
That is
sought
why I
that
said that
declaration.
I
in
have
the suit.
recently come to know.
Then you could have taken that declaration in the suit also. Could have asked for the declaration. If you ask, you could ask for a permanent injunction, don't give effect to it. And if you ask us to treat that as a challenge to the HR manual, then you could have sought up for a declaration outright on the same day as you filed the suit. Along with that permanent injunction, you are asking us to believe that that permanent injunction incorporated a challenge to the HR manual. If that be so, you could have asked for a declaration on the same logic.
I could have. I
It's
did
difficult.
not. I
It's a
did not
difficult
ask.
case for you, Mr. Ali.
That is why, my lord, to our
Judicial value is high. Because as Mr. Banerjee said, yes, first sympathy goes with the employee.
Lordship, I am saying that, repeating that, please be sympathetic, and Lordship may.
And one other aspect
grant
is
us an
there, Mr. Ali,
opportunity.
frankly speaking, initially we were more sympathetic because of the second ground that that was highlighted by you also in your past arguments before us, that you have been speaking to another employee and who is also against him probably. That's why he's taking a vendetta against you. But that has been turned down now by the inquiry officer. That has been obliterated. And you have been
find that the two charges had been
two charges. Second
charges,
charge, that charge of talking with Mr. starting with P.
Pairi.
That regular gossip with Mr. Pairi, that charge has been disbelieved quite rightly. I mean, if that was the charge, only charge on which you had been implemented, we would be different.
That was the argument on the first day.
Yeah, you remember.
The clue.
No,
That
they
is
did
why-
not get the clue.
Huh?
And
Yes,
it
yes,
was-
yes.
No, the district judge, we would go with the district.
No, I'm not causing any aspersion.
It's not their cue. They pursued that ground also. That was rightly turned down. It was not logical, but the other ground was accepted. And now it's, I mean, it's very difficult for us to hold in your favor. We'll think it over. We'll
Lordship will
keep it. I mean, we'll not pass our judgment right now. We'll think it over.
because it has only happened because of the strong conviction that there is no such HR manual, and it was never.
So yes, anything else to add, Mr. Ali? Then we'll conclude.
The other only thing is that
We'll take a short written notes of arguments from both, so that we don't miss out anything. So bullet points only. I mean, you can refer to the pages, both of you. So how soon can we file, both of you file it? Thursday today.
1 week.
Next Thursday.
By Monday.
Next Thursday.
Monday.
Monday. Yes, you get the weekend.
No, he is
Shall you
running a
get
pro
here?
bono matter, so he will take little more time. This is my.
Why pro bono matter?
That's what he said.
You know him.
No, it's not. It was Mr. Srivastava's.
You should never appear in a pro bono matter then.
Unfortunately, I appear in many pro bono matters.
You don't get passionate.
No, I don't.
A person who gets passionate in a
If
pro
I
bono
get
matter.
passionate, Lordship, I leave the brief.
But generally, you will find Mr. Ali in pro bono matters. All of us have done pro bono matters.
Yes.
Of course, all of us have. Otherwise, I mean, anyway.
It's
so
a duty. We have to
pro
leave
bono
all
matters,
other
you see-
matters and then be present in pro bono.
You have to. You have to. You're a human being. In pro bono matters, you see the client is most, I mean, picks up faults more and is more specific, finds out faults more, takes more time. In pro bono matters, you see, as a matter of rule, in pro bono matters, it always happens. But that's a different chapter altogether.
But for my pro bono matter, it has not happened because I was arguing a very core matter.
Not in
before
all
your
matters.
Lordship, when Lordship was sitting singly, legal aid matter for the compensation. Then I said,
So
my
those matters, they are not in a position to argue with you. Some people are, I mean,
No, no, that is now reported judgment which fallen from your lordship. I argued the matter.
Regarding?
Regarding compensation in a rape victim case.
Yes, absolutely.
Lordship, I argued that matter. Lordship said you don't have any right to, no big brother attitude that I am giving you money. It's your duty, you have to disburse.
For that.
So
No,
that
pro
is-
bono matters, yes. Anyway.
And that's
So-
a very hot topic in the live law. Moment you
Live law, don't speak about live law. Every day a new proposition of law is coming out which you have learned from childhood. It's a new proposition of law. Each and every day you'll see so many matters. Wrong matters are reported, right matters are not reported.
And the YouTube shorts. Lordship's
YouTube
video
shorts.
was viral.
I've started loving my anger. I've fallen in love with my anger now. I've forgotten my other aspects. And it's anyway. So we'll close arguments. We'll keep it on
Monday.
Monday we'll keep it. Heard learned counsel for the parties. Full stop. The photocopies of the 48th and the 49th meetings of the EC of the defendant stroke respondent number 1 association, as well as the working group report, which are filed by learned counsel appearing for the respondents today, be kept on record. Full stop. Copies thereof are handed over in court during today's hearing to learned counsel for the appellant. Full stop. Hearing is concluded and
minutes of meeting for 3rd and 4th of the domestic inquiry.
আচ্ছা, yes. যেখানে বললাম যে এই ডকুমেন্টগুলো দিচ্ছি সেখানে অ্যাড হয়ে যাবে, as well as the minutes of the 3rd and 4th meetings
Inquiry office.
of the inquiry
Domestic inquiry proceeding.
Domestic inquiry proceeding, right. যেটা hearing is concluded and the oral hearings are concluded, full stop. Oral arguments are concluded, full stop. Learned counsel for the parties are requested to file their respective brief written notes of arguments on June 23, 2024, when the matter shall be listed for such purpose under the heading to be mentioned.
I'm the
ব্রিফটা বাড়িতে যাবে
আজকেই পাঠিয়ে দেব। হ্যাঁ, ওনার কাছে। Yes.
Answer the respondent.
ফটাফট লিখে ফেলুন।
Respondent number 1.
Opinion form করে দিয়েছেন। এটা আপনি বেশি কমপ্লিটেন্ট, এটা আমি opinion
Lordship, praying for the adjournment for the.
No, refuse.
The earlier once
Adjournments
this
are
matter has been dismissed for default and
No,
your
no.
lordship
no
restored it.
question of adjournment.
Lordship, 5 minutes pass over. Can I call?
Yes, we see, we find. And we had recorded that you have been repeatedly absent. For that reason, we had repeatedly adjourned the matter, ultimately dismissed for default. Only when it was dismissed for default, you came up with a restoration application. We restored it. Again, you did not appear on the last occasion.
Lordship, 5 minutes pass over. Can I call my senior?
No short passover. You start the matter. Where is the brief?
I have a brief. My senior is coming. Lordship, just
No, Mr. Mukherjee, what is the case about? We'll hear you.
A suit initiated, my lord,
Yes.
by the plaintiff appellant before the learned trial court, treating me, my lord, the declaration was sought for that he is the lawful tenant under the Waqf estate, and I don't have any right, so permanent injunction restraining me, my lord, from disturbing his possession. This is, my lord, he started the story that his father, my lord, his father was a tenant in respect of the property in question, and my lord, after the death, my lord, he alone have, my lord, since his father has given, my lord, that, my lord, right to him, he alone is, my lord, the tenant. He is, my lord, occupying the property. I don't have any right. My lord, the case, my lord, may I place, my lord, some portion, since the first appeal, my lord, the plaintiff. One Noor Muhammad, my lord, the page 3 of the paper book.
Pages have stuck with each other. God knows how long this was pending.
It's
Appeal was filed when?
Lord, its FA number is 2019.
FA number won't indicate.
FA
2000?
of
সুটটা তো 2008 এর এফএটি নাম্বারটা কত ছিল 2017 yes
27. Well, may I just paragraph 1, page 3 of the paper book.
yes 2017 it was filed one day before I became a judge. So very nostalgic value. Move the matter. Yes.
One Noor Muhammad, husband of the plaintiff number 1 and the father of the plaintiff number 2 to 4, and pro forma defendant number 2 to 4 was a tenant in respect of the tile shed room, hotel room, Pakka southern side with pawn shop attached to a hotel under the Waqaf estate of Laskar Lane Mosque at the monthly rental of such and such. The said tenanted portion is fully described in the schedule hereunder. I'm not kindly turns over the page. The pro forma defendant number 1 had been realizing rent to the suit premises on behalf of the Waqaf estate. The said Muhammad died intestate on 11th of May 2007, leaving behind the plaintiffs and the pro forma defendant number 2, 3, 4 as his only heirs and successors residing with him at the time of his death. The plaintiff number 1 is the widow, and the plaintiffs and pro forma defendant number 2, 3, and 4 are sons of the deceased Noor Muhammad. He said Noor Muhammad carried on business of
Eatery house.
Eatery house in one portion of the suit premises and conducting another business of STD, ISD, and PCO and Panbiri in other portion of the suit premises. Since the death of the Noor Muhammad, the plaintiffs as the widow and the son of the deceased have been carrying on the said business are in possession of the suit premises. The defendant number 2.
It should be 2.
It is the brother. No, it should be 1.
Have you got a copy of the
Defendant number
plate?
2.
Check up whether you have got a copy. Let us see.
Defendant number 2. It should be defendant number 2.
Check up.
Yes, yes,
Don't take the risk.
May I just.
Let us just check up from the application whether you have annexed the plaint or they have annexed it.
But I will check up. Mr. Ahmed has come. Let's see.
Yes, Mr. Ahmed.
But may I just check up whether from the law court record?
Trial court records ফেলে আমার দিকে তাকাচ্ছেন
হ্যাঁ
Yes. But you're more interested in affairs of the state than the personal clients.
No.
It's not that, my lord.
The combination,
Not that, my lord.
the combination proves it.
No, my lord.
Yes.
My lord, the thing, my lord, this was a suit, my lord, for declaration and power injunction against the defendants, my lord, seeking declared right of my tenancy, and my lord, permanent injunction against the defendants from disturbing peaceful possession of the plaintiffs in respect of the suit premises, my lord. My lord, my case was, my lord,
it's blank. Key blank. এই প্যারাগ্রাফটা প্লেন করতে এই কপি
In the original also it is blank.
Oh, acha. Amended copy. Amended. Duplicate copy, na? The duplicate copy.
Anyway, Mr. Ahmed, leave it. Carry on. Yes. We'll fill in the blanks. No difficult. Carry on. Leave it. Yes. So you are tenants in respect of the property.
My lord. My lord. My lord, one Noor Muhammad, who was the husband of the plaintiff number 1 and father of the plaintiff number 2 to 5 and defendant number 2 to 4, was a tenant in respect of a tile shed room.
Up to paragraph 4 you have read.
My lord. Now, my lord, the defendants, my lord, it will be defendant number 2, my lord. The defendant number 2, my lord. Okay. Is the brother of Noor Muhammad, who was the original tenant.
Defendant number 2.
My lord.
Achha, it's peculiarly mentioned in the cause title of the plaint. Come to page.
It should be 1, my lord. It should be Siddiq Mirza. It should be 1, not 2, my lord.
Siddiq Mirza is 1. Then who is the chief executive officer?
My lord,
They are the all the others are
they are the performer defendants.
So then this has to be defendant number 1. Is the
this has to be defendant number 1, my lord.
Yes.
It has to be read as defendant number 1.
Right. 1 is the brother. Yes.
Brother.
Trying to grab.
My lord, he started creating disturbance, my lord. Now, The fact of the case is that, my lord, in his written statement, the defendant, the original defendant, stated that paragraph 8, my lord. He stated that earlier this suit premises was in the name of one Kuplain Mirza.
Paragraph number 8 of the written statement.
Of the written statement, my lord. That is that is page 12, my lord.
Yes, paragraph 8, please.
Lord, before going to the paragraphs wise comment of the said plaint, this defendant states that one Kuplain Mirza, since deceased, the father of this defendant, and also the father of the deceased, Noor Muhammad, who is the husband of the plaintiff number, well, it's blank, my lord, over here, and father of plaintiff number 2 to 4 and pro forma defendant 2 to 4. And one Maqbool Mirza were the tenants in respect of the suit premises under the Waqf estate of Lashkar Inn Mosque at a monthly rental of 429. The said Kuplain Mirza, since deceased, started a partnership business of an eating house with his nephew, namely Maqbool Mirza, in the year 1963. The said partnership was duly registered at Office of Sub-Registrar of Assurance as Calcutta, being book number such and such for the year 1963. Thereafter, the said Kuplain Mirza, since deceased on 24/5/1965, appointed his two sons, namely Noor Muhammad and the defendant, as his constituted attorney to act on behalf of his in the said partnership business, along with Maqbool Mirza. Thereafter, Kuplain died on 28/11/1965, leaving behind his wife Zohra Bibi, his two sons, namely Noor Muhammad and the defendant, and one daughter, namely Ajmeran Khatun, as his legal heirs and successors according to Mohammedan law to inherit his tenants' property. After mutual agreement between the legal heirs of late Kuplain Mirza, that is his wife Zohra Bibi, his two sons, namely Noor Muhammad and defendant, and one daughter, namely Ajmeran Khatun, some affidavits was done by the said deceased Noor Muhammad, and some letters were issued to the office of the Mutawalli of the Board of Waqf, West Bengal, from which it is ascertained that all the legal heirs are the co-sharer of the business and co-tenants of the suit premises, along with Maqbool Mirza. And only for convenience of the said business, the name of the deceased Noor Muhammad was used after mutual agreement between the legal heirs of late Kuplain Mirza. So, on the deceased, Noor Muhammad and his legal heirs are not the absolute owners and tenant of the suit premises. Moreover, the defendant is running the STD ISD business along with eating house business from the suit premises. This defendant annexed the said documents and also crave leave to rely upon the said documents at the time of the hearing. So his case was that originally the tenancy was in the name of Kuplain Mirza.
Yes. Kuplain died, and agreement mutual, all became co-owners, co-tenants.
Yes.
And co-owners of the business.
And the father of the defendant and the plaintiff. My lord, there was one exhibit, my lord, exhibit 5, my lord, which was marked as exhibit 5 series, my lord. If your lordship may kindly see that rent bill, the lordship will become more clear with respect to the tenancy of the suit premises, my lord. That is in page number exhibit 5. Parenthesis here 96 and 102. Page 96, my lord. This was the rent receipt issued in the year 1965, which stands in the name of Noor Muhammad and Raitan Bibi. Noor Muhammad is my father.
Who is Raitan?
My father.
Raitan?
Raitan Bibi.
Who is she?
My lord, I'll come to that, my lord. But from this 1965 rent bill, your lordship will see that the name of Noor Muhammad, who is
Yes.
my father, who is the predecessor in interest of the plaintiffs and the performer defendants. So since 1965, the name of my father, Noor Muhammad, exists in the rent bill.
Along with someone else.
Along with one Raitan Bibi, who was the wife of Maqbul Mirza.
That
the
is their
joint heir.
case. That is
No.
their case. That you and your
His case is that Copland Mirza. Copland Mirza is the father, is my grandfather and the father of defendant number one. And the
rent
Maqbul
receipt,
Mirza.
that itself does not mean anything. If all of you, if initially Kuplin and Maqbul were co-tenants, Mr. Ahmed, and upon the demise of your father, if it was issued in the name of one of you, it would be deemed that you would be representing them, all of your branch. Because there were other documents also apparently produced as per the trial court judgment.
This was challenged by the defendant in the year 1990.
How?
Before the Waqf board.
Achha.
They made a representation to the Waqf board and challenged this rent bill in the year 90. Your lordship will see Exhibit G, my lord, which is in page.
But joint documents have been produced, page 111 and all, KMC license and all. Noor Muhammad and Siddiq were running.
Red license, my lord, can be obtained by anybody, my lord. That is, my lord, that is
joint names. He would have obtained in his own name then. Noor Muhammad plus Siddiq.
I have been in possession of the supervisor. Now the rent bill in my predecessor's name,
along with at least Maqbul's wife.
Maqbul's wife,
at least.
Who
then
is,
you cannot
who is
claim
in no way related with the defendant.
But then you cannot claim you have claimed exclusive tenancy in respect of the tenancy.
That is what I'm coming to. Well, Raitan Bibi, she surrendered her tenancy, right? And exclusively my name, thereafter my name was recorded in the rent.
Documents are there to prove that. Raitan has. Exhibit G, where is it? You are.
These are the rent bills which were produced by the.
Rent bills you have seen, yes.
My lord. Kindly see page 108, my lord, which is the rent bill which stands in the sole name of Muhammad Noor Muhammad. That is page 108, exhibit 9, my lord. That was for the year March to June 2007. Then in the year May, exhibit 10, that is May 1999, Noor Muhammad, 109, and 110, my lord. That was the rent. That is the rent bill for the month of August 1999.
আঠা দিয়ে জুড়ে দিয়েছে মনে হচ্ছে এখানে কতগুলো আঠা দিয়ে জুড়ে দিয়েছে মনে হয়। মনে হচ্ছে আঠা দিয়ে জোড়া যায় তারপরে ছেড়ে দেবো পাঠাটা করে নেক্সট ওটা ফার্স্ট ডে একটু খারাপ হলে জমা যখন অনেক অনেক ডকুমেন্ট আছে তো ফার্স্ট ডে কপিটা এসবগুলো দেখলে মুশকিল ছোটবেলা একবার মা করে দিয়েছিল ফটোগ্রাফি বই কিনেছিলাম কিন্তু ফটোগ্রাফি ছিল ফটোগ্রাফির ইন্টারেস্ট ছোট ছিল স্কুলে পড়তাম ঠিক সেই কেস Your journey ends at page 110. And from 111, their journey begins. No. As far as the documents are concerned. Rent bills and all, trade licenses, trade licenses and all.
I'll come back to that, Milord.
Rely on their document.
No, I will rely on their documents. I will not on my documents.
Such a bonhomie. Good to see.
Milord, kindly see when they challenge the
yes
rent bill, Milord.
Shows that.
Exhibit 1, that is 91, page 91 of 91. This is the copy of the certified copy of the order issued by the Commissioner of Waqf Board. This was filed by Muhammad Siddiq Mirza, the defendant, my lord. Date of issue, my lord, see 16/1/1990. Yes. My lord, the order, my lord, in pursuance of my order dated 16/12, my lord, it has, my lord, I'm assuming it's 90 or it says 89. I'm assuming it's 89. 16/12. This is to inform that the Commissioner of Waqf Board has nothing to interfere in the tenancy matter, as the Bengal Waqf Act 94 does not provide for any interference in such matter, which is completely civil nature involving title. Hence, the civil suit is the best forum to take decision in such matter. Therefore, you may seek relief in the competent court if you so desire, my lord. So, since 1990, my lord, the defendant did not take any action. He was sitting tight over this order since 1990. And the rent bill was being issued in the name of my father.
Have you taken the point of limitation also?
My lord.
Even if you don't take, the court has to look into it, but just asking. And suit is filed in which year, Mr. Ahmed?
Suit was filed in the year, my lord, 2008.
All right.
My lord, can I make a candid submission, my lord?
We were waiting for that.
My lord, if this can be taken next Thursday, my lord, because to be very honest, my lord, I was expecting the matter to be taken up next week. I was not fully prepared that it will be taken up.
Yes, Mr. Mukherjee. But we'll record that this is the last chance because
keep it as a part heard matter, my lord. It will certainly come up on next Thursday, my lord.
part heard matters would not deter you from asking for time again
No,
because
no,
of
no, certainly
past
not.
conduct of your client. We have seen.
No, certainly not. I will definitely appear. And when I have started the matter, I will definitely close my argument.
Heard in part, full stop on the prayer of learned counsel for the appellants, comma. Let the matter stand adjourned for further hearing till June 26, 2025, when it will be listed under the heading part heard matters.
I'm grateful.
Thank you. শুরু করিয়ে দিয়ে যখন করবে এটা না শুরু করলে জিন্দেগিতে শুরু করতে না সারাক্ষণ স্টেটের মামলা করে বেড়ায় করতে করতে দেখে গেছিল সুমন সেন
Item number 21, my lord, I am appearing for the appellant.
Yes, please. You're for the appellant, yes.
For the appellant, my lord.
But I'm for the respondent.
I am
Yes.
paying for 10 days more time because
10 days, start the matter.
Man,
We
because
won't
there
even
was-
grant to 10 minutes time.
There was a direction for filing the paper book, my lord. Paper book has not yet been ready, my lord, because appeal has
You are
been.
directed to file. We'll dismiss the appeal for non-compliance of the court's order. Why haven't you
kindly-
filed the paper?
Then 1 week time, my lord.
No. Why? What is the reason?
Because, my lord, the paper book has not ready yet, my lord. Kindly give me 1 week time.
1st of May, we had granted you time.
Uh,
You
due
have
to some-
crossed over 1.5 months. What prevented you?
My lord, for
We'll
some of the
impose
paper-
costs on your client then.
Kindly
If
keep
you
it
can
on-
afford Mr. Basu, you can afford costs also.
Madam, kindly accommodate for 1 week, madam. This is the last time, madam.
No, not 1 week. You file it by Monday. File the paper, informal paper books without comparing with the records. Why didn't you prepare it?
Kindly
Today we are on 19th. File it on 23rd. We'll fix it on 26th.
20, madam, kindly fix it on 25th then. 25th.
26th. As per our choice, not your choice.
20.
Your heart is on the left side. Don't touch that side.
No, that's a mobile.
Diary.
At 25th, madam. Can you keep it on 25th?
30th we are adjourning till 30th. File your paper book by 24th. Give copies to her.
Yes.
On the prayer of learned counsel for the appellant, we extend the time for filing paper books, informal paper books, till June 24, 2025. First up, the appellant shall positively file the paper books by such time. Now, prepare the paper books by such time and file requisite copies of those on the returnable date in court. First up, next para. Advance copies of the paper books shall be circulated among the learned counsel for the respondent by June 25, 2025. The matter shall next be listed under the same heading on June 30, 2025. File by 24th, give copies by 25th. You will come prepared on 30th. Thank you.
Milord, I beg to appear, Milord.
Yes.
The last occasion, Milord, my junior has pointed out that there is a Milord one particular document, the rate chart, which is Milord the important document, which was
You are
not-
the requiring body. Bangur, you are Bangur or you are state?
No, no, I'm the state. I'm the state.
You are the state.
I'm the state.
No, no, I'm for the land loser claimant Bangur.
Bangur has lost land.
Yes.
Good to see that. Yes. We have been getting individuals, now a company. Yes.
Now, in the last occasion,
Yeah.
prior to that, on 11th December, Milord, we have pointed out, Milord, some of the Milord, the document was not part of the Milord, the paper book. Milord, the document which I was supposed to rely upon, that is the rate chart. Now, the rate chart which upon
Why
the-
didn't you prepare a supplementary paper book and can prepare?
I can. If your lordship so grants me the leave, I can.
What are the papers? Do you have the papers?
Whether that was exhibited.
Not exhibited.
Milord, that is the whole trouble, Milord. I have to, Milord, go through the entire record. I have to tally.
If you did not go through the entire record till now, Mr. Sengupta, we won't give you that opportunity. Sorry.
No, Milord.
Sorry, a very pleasant sorry, but sorry still.
No,
If you have not gone through the records because you have been asking for time.
No, that is, I admit, Milord. I have.
What admit?
Milord, it is not in the record, Milord. That is why, Milord.
It has been pending since before us, even from long.
Quite a number of times.
Several occasions taken up. You could not get the time to take your go through your papers, Mr.
Milord, I
Sengupta, we are
admit
sorry.
that, Milord. Admit
No,
that.
no.
Milord, so far, Milord, another point.
And I have been sitting with different judges. Justice Parthasarathi Singh, Justice Shubhendu Shamunta, and my brother.
Yes.
At least 6 occasions we could not take up the matter. Not all your fault. Yes. State.
No, no,
Yes, state was directed on 8th of January.
Milord,
You are directed to file supplementary paper book.
Milord, I can file, but
No, what can? You were directed to file.
Milord, admittedly.
What admitted?
Milord,
And circulate advance copies of the same.
yes, if your lordship just give me just 1 week time, Milord, I can come up and contact COPT. Oh yes.
What difference will take place? Panel will change, government will change, or the state will change.
No.
It was directed to file paper books on on January, the first week of January,
Only
by
confusion is
27th.
that only confusion why I couldn't file, because I was not very sure whether that particular document was exhibited or not. To be very honest, Millard, I could.
You could go through the LCR. You know how to,
We
Mr.
have
Sengupta.
gone through, Millard. We have not, Millard, find out, Millard, the whisper of the same or the LCR.
Then
Rate report, it is required, Millard, in order to bring the same, Millard. The learned judge come to a finding, in what basis, Millard. Definitely a rate chart was given, Millard. This rate chart was not part of the record and not exhibited. I could not find.
What did the referral court refer to? The referral court referred to relied on what? The Section 18 court.
Yes, the 22,000 and.
No, it relied on what document?
Sorry, Millard.
Referral court relied on what document?
Well, that is the Millard. Definitely, this has to be referred upon the or relied upon the Millard the rate chart.
No.
Same award amount. The same amount.
Please, kindly come to page 33 of the judgment.
What did the court rely on?
Relied on Sundarlal Mitro, chartered valuer and surveyor.
Oh, that is they are appointed valuers. They
The state you could have produced documents, sale deeds, contemporaneous sale deeds.
They did not.
This is where we are.
Only one document that was also provided by us.
But so far, Mr. Thor is also filed a cross appeal. The cross appeal, I am not very sure of it, whether the section 5 has been condoned or not. I have not seen.
Cross appeal on what, Mr. Thor?
Regarding the
A regular cross objection, yes.
Yes.
Cross objection.
Statutory benefits I am entitled to get. Number 1 and number 2, I'd be relying on a special bench judgment where my lord, sitting my lord, Justice Bhaskar Bhattacharya, my lord, has decided that these proceedings had lapsed and I am entitled to get the value on the date when 93B notice was issued. So I'll be relying on that judgment, special bench judgment.
সেটা পরে বলবো, এখন ওকে বললেই নিতে দে, তারপরে আমরা বলছি।
Mr. Sengupta, supplementary affidavit, then you cannot, if those documents are not exhibited, we cannot look into that. What do those part of the before the LA collector? Before the LA collector?
Cannot, even your lordship's order, if I do so.
No, where those before the LA collector?
Yes. We got, Millard, we got.
Then we can look into it.
Amount is same, Millard. We got it, Millard, but
We gave the valuation of credit.
22,000, Millard. This was we got, but it is.
What document LA collector had decided rate? Upon which documents LA collector has decided rate?
Millard, kindly have a look into this, Millard.
No, LA collector's order must be there in the part of this paper book.
No, this is
The original award against which reference was made.
Original award to dekhana আছে. Yes, Millard, that is there.
That should be there. What does it rely on? Let us see. Award in LA, that page 1 to 4 is that. There is no reflection.
এটাই তো রেট রিপোর্ট। অ্যাওয়ার্ডটা কোনটা? এটা তো অ্যাওয়ার্ড। This is the Millard, the award.
LA collector.
আসছি তারা একটা করিস না।
Mr. Sengupta, most of these matters are very ill handled in the referral courts for the state.
I can.
The state is losing so much money for that.
I have seen. I have talked to the Millard, the officers. Millard, the manner this has been handled.
Not only this is better than not
The
better.
other matter is also, Millard. I know.
Pathetic. Nothing is done. Everything is being done by the referring claimants
Yes.
or the requiring body in some cases.
This is Millard. I understand, Millard.
State is filing an estimate note saying that there is no contemporaneous document, whereas several contemporaneous documents are filed by the requiring body as well as the claimants.
I cannot in that event improve the case, Millard. What is Millard?
No, if you are not sure that those who are before the LA collector, then you cannot put in. Then we'll hear the argue the appeal.
The CAN 5 has to be disposed of.
What is CAN 5?
CAN 5. Kindly see the order of 11th December, 2024,
In fact, the delay.
What is the reason for the delay?
507 days delay, my lord. Kindly come to straight away to page 4. Sorry, para. No.
We like
Para
to
4.
use an affidavit to that.
Well, they
No, I have
asked for it.
vehemently opposing that same. Lordship
record
may
the
pass an order. I have.
How can you have personal knowledge on any of these averments? What will you say in the affidavit?
I got it in the supplementary affidavit.
You cannot have state cannot have personal knowledge on any of these averments. We can at best record that you have denied, you have not accepted these arguments. But how can you say whether they went to their office and all, what happened in their office? How can the state have personal knowledge? What will you
Lordship is
deny?
referring the CAN 5.
Yes.
How can the state have personal knowledge? Whether the learned advocate had suffered bereavement, unless you deny that he suffered bereavement.
No, I am not on that. In that event, I cannot.
And being advised what happened in the chamber of the advocate,
No,
how can you know that?
All right. If it is shown the sufficient cause, it is up to your lordship.
So therefore, argue on the application. Where is the question of affidavit in opposition?
Generally and otherwise.
And generally,
I do not oppose the section 5 of application.
everybody says that. Everybody nowadays, everybody opposes and says generally I don't oppose. That has lost meaning, Mr.
This has to be the convention. We have learned from the millet yes.
We have also learned after becoming judges that this is said in every matter whenever it is opposed.
No,
we accept that. You generally don't oppose. This is only the case where you are opposing. But there is no scope of any opposition. Argue on this application, whatever is there.
Lordship is allowing the 507 days.
No, we are not allowing. We are hearing you on this.
Very well.
Argue on the basis of this application whether these are credible or not. See the grounds.
Very well. Judgment.
Pandemic you cannot deny. Durga Puja you cannot deny. Mr. Supratim Dhar received a phone. You can deny.
The original judgment of the section 5 was 1954, the BC Rai judgment. This is only.
What was said there? I don't know of the judgment.
Lordship knows everything. Miller, kindly don't.
I know everything.
Of course, Miller, better than of me, of course, at any point of time.
That is not a good taste.
No.
Better than you does not place me anywhere. No, Mr. Sengupta, yes. What is your proposition?
No.
Recent judgments are very strict. Some of the judgments are very strict, Supreme Court, regarding condonation.
I am, so for the condonation of.
Have you gone through the section 5?
I have not.
Come back on Monday. On the prayer of learned counsel for the state, let the matter stand adjourned till June 23, 2025. It transpires that all the exhibits have been made a part of the paper book. Learned counsel for the state submits that despite best efforts, it could not be ascertained as to whether the rate charts, rate reports in respect of the contemporaneous valuation of the adjacent property to which the land acquisition occurred, where a part of the consideration of the land acquisition collector while passing the initial award. Next para. Since the state cannot, since the state is not sure as to whether the rate reports which are sought to be relied on were a part of the records before the LA collector, we cannot permit such documents to be incorporated in the records. Accordingly, there is no scope for filing any further supplementary paper book. The matter will be, the appeal will be heard, subject to the outcome of the condonation application bearing CAN 5 of 2024,
in connection with COT.
In connection with COT 76 of 2024, on the papers which are already on record. Come back. If you're not sure, if the state is not sure whether those are part of the records, you cannot look into that.
Definitely. But I can rely upon as a the evidence of the
Whatever evidence was there before the referral court, we'll go by that. If we find it, no, Mr. Sengupta, if we find it insufficient, then court, we have the power to remand it also and pass directions on other counts also.
Naturally.
But you have to, till now, you could not find out any contemporaneous
Your
sale.
lordship,
You are the state. You had to have the sale deeds.
Yes,
the details of the sale deeds.
The difficulty is that we do not have a direct control over the
Council's difficulty, we very well know. As we are not speaking to in the, I mean, council. What can the council do?
This is the difficulty.
You must have tried your level best actually.
We have gone through Millard. It's not.
It's very difficult to appear for authorities. We know that. Particularly in land acquisition cases in our state. We don't know about other states. It's extremely difficult for the courts also.
Yes,
because this is public money at the end of the day. It is being lost.
Yes. It is going from our exchequer, Millard. We have to.
You are also paying. We are also paying. Everybody sitting here is paying, provided they pay tax.
Had it been a case the foundation was correct, then could have
nothing.
Nothing is there.
Rate reports we can rely on. There are judgments which say that we can rely on rate reports. Properly has to be reflected somewhere. Referral courts award should reflect that
correct,
at least.
Millard. Otherwise, I could
You
have
don't have any
come up
handle.
with the Millard the supplementary, but I have seen it is not there. Then it become a futile exercise.
Useless. We cannot rely on any document which is never there before us.
It is not there.
Come back on Monday.
My lord.
Yes. Yes, Mr. Podar.
My lord, I am for the appellant landlord in respect of the suit property, my lord. This appeal is directed against the rejection of Section 5 application in a miscase.
Why are you looking so helpless, Mr. Banerjee?
Setting aside the.
What was the delay?
My lord, delay is, my lord, 5 years and more. Because, my lord, here is a.
You are become a specialist in these sort of matters.
No.
That means you are becoming a better advocate.
I am not even general. How could I be specialist?
No, you not only a specialist, but you are a good advocate. That this is a proof of that. Tough cases are coming to you.
My lord,
5 years, what is the reason?
Thing is this, my lord.
Yes.
No summon was served. My lord, this is a suit at the instance of a brother of the judgment debtor. My lord, initially, my lord, I filed a suit. My father filed a suit for eviction of the elder brother who is the regular tenant under my father sometime in 1969. My lord, that suit was decreed sometime in, my lord, August 1970. My lord, appeal preferred. That was remanded. My lord, sometime in 1975. 1981, second time the suit was decreed by the trial court. 1982, my lord, stay was granted, and at last July 1986, that appeal was dismissed. Thereafter, my lord, put the decree into execution 1987. My lord, order of delivery of possession allowed 1988 April. My lord, miscellaneous case was allowed policial 8 February 1989. Thereafter, my lord, miscase was filed under 47 in 1989. And my lord, we later on come to know that in 1989, one suit was filed by the brother of the judgment debtor. At the same time, he was also filed a proceeding before the rent controller challenging that, claiming he was a pre-act subtenant.
Pre which act?
1956 Act. Fortunately enough, that was contested. That was within our knowledge, my father's knowledge.
Rent controller proceeding.
Yes, and that was dismissed. But nowhere he claimed that he filed this suit in 1989. But this 1989 suit, at that point of time, my father was alive. My father died in November 1989. we don't know whether my father received summon or not. Soon after my father died, we executed some Bhokalatnama and petition in order to contest the pending execution case, miscase, such and such. My lord, ultimately, my lord, a date of delivery of possession after their miscase was 47 dismissed, my lord, in 2009, delivery of possession was fixed. At that point, against that order, against the refusal of dismissal of 47 application, they preferred one revision application. They means the judgment debtor. And in that proceeding, they claim, the judgment debtor claim, the decree obtained by his brother. And what happened, my lord? That is our first knowledge according to us, that there was a suit against us wherein a decree was passed, ex parte decree. Now, my lord, we, my lord, filed application under Order 9, Rule 13 of the Code of Civil Procedure for setting aside of the.
What was the decree?
Declaring
his tenancy
decree
right.
was that the decree obtained by the
What was the nature of the decree? Yes.
Defendant is a nullity because there are no.
That the suit was a nullity. Your suit was a nullity.
Nullity because he was not made party. Well, kindly see that. In my application, I have quoted. Well, paper book, page 4. '69. Today we are 25. 2025. 30, 55 years gone. For a decree for declaration that the plaintiff is not bound by the ejectment decree dated 19 December 1981, passed by the learned Judge 10 Bench City Civil Court, Calcutta, and confirmed on 29 July 1986 in FA 142 of 1982 of the Honorable High Court, Calcutta, as the decree is nullity and or voidable one due to non-inclusion of this plaintiff who is a pre-act subtenant with knowledge of the defendant and for defect of the notice and irregularity. I don't know whether pre-act and post-act have any effect. We know that the decree passed against a tenant is binding upon the pre-act, post-act subtenant, anyone who is dependent under that judgment debtor. But the gentleman plaintiff who preferred the suit is a full-blooded brother residing with him. Whether he can claim, and my lord,
he claimed to be a subtenant under your defendant, your tenant.
Yes, he is claiming subtenance under his elder brother.
My lord, the copy of the decree I have annexed. That my application, my lord, which is in Order 4127, my lord, Can 3. The entire order, my lord, I have annexed it.
And for a decree for declaration that the plaintiff is a pre-act subtenant with approval, fortunately that was dismissed. That was dismissed at the proper forum. And my lord, Section 5 application, we preferred for a abundant precaution because the Limitation Act says that unless someone is served, it is the date of limitation is from the date of knowledge. Though we have filed for abundant because we had no knowledge, we have averred it, and they, per contra, the plaintiff said that 2-3 occasion, that is also 1991-92, we had filed application praying for adjournment, and that was allowed subject to payment of cost on 2-3 occasion. We don't know who pays cost, and the suit was decreed 2004. 15 years to time to obtain ex parte decree. 91-92 affairs, they are claiming that we appeared and prayed for time. When we contested the proceeding before the rent controller at the instance of this gentleman. And what prevented me that when we obtain a decree, we could not, knowing fully well, we could not defend that decree. And by that time, our advocate also died. My father's advocate, Mr. Tapan Chakraborty Chatterjee, he also died. So, my lord, now, my lord, may I place the section 5 application. Section 5, what affidavit we made.
Mr. Poddar, let us first see the impugned order once. Why was it dismissed? Then we'll go back.
Impugned
We'll read
order?
everything. Impugned order first.
My lord. Page 44.
No.
Order dated 22nd December 2021. Both parties have filed their respective ready slip through their respective learned advocates.
44 in the paper book copy which I have, there is no 44. After page 43, direct page 59.
44 to 58 is the impugned order.
একবার দিন এটা পোদ্দারকে দিন
ওহো বাইন্ডিংটা ভুল করেছে my lord in my copy also 59 is বার করো my lord sorry it is my lord in my page also my lord 59 60 all are previous to 44 করেছে.
When you filed the paper book, you had an apprehension about the first judge.
My lord,
filed the paper book, you had some apprehension regarding the first judge. Because my learned brother's copy is all right. No, we were not there. We were not there. It was filed previously. And you filed it, yes, your office.
Through
but we'll have it, so we'll
it was done through department.
Yes, we know, understand.
Both parties have filed their ready slip, their respective ready slips through their respective learned advocate. Today is fixed for passing order.
No,
here
59 to 62, then we will not find in their place. Those have come here. 59 to 62.
59 to
let us see after 58 what is there.
This is substitution application.
59 to 62, yes, very.
Substitution application.
No, understood. Yes, very well. We get it.
Here, the title should write 442 of 1989 was decreed ex parte on 23rd September 2024. Suit was filed in the year 1989. Suit was decreed ex parte 2004 September. And then to set aside the aforesaid decree passed ex parte, an application on Order 9 Rule 13 of Code of Civil Procedure was filed on 18th March 2010. And along with the aforesaid application, another application under Section 5 of the Limitation Act 1963 has been taken out, praying for condonation of delay of 1998 days in filing the application on Order 9 Rule 13 CPC, which has been registered as miss case number 329 of 2010. So my miss case was 329 of 2010. In the judgment of Johor, they reported in year 2000 Calcutta 280, it was held that in like case, application under Section 5 of the Limitation Act 1963 should be decided first, and without deciding application for condonation of delay, court has got no jurisdiction to decide application for setting aside ex parte decree, and hence let this court decide the application for condonation of delay first. Very good. In and the application for condonation of delay, it was recited that the predecessor of present petitioners, namely Pachu Shodoy Seth and others, since deceased, had filed one ejectment suit vide 892 of 1969, which was decreed by the learned Judge 11 Bench City Civil Court, Calcutta, on 19 December 1981. And the said decree was put into execution. Case was registered as ejectment execution case 176 of 2003. And challenging executability of the decree on application under Section 47
of the Code of Civil Procedure was also filed, but the said application under section 47 CPC was dismissed on contest, and date of delivery of possession of decretal property with police help was fixed on 15/12/2009. This 15/12/2009, this is a turning point now, by the executing court being Court of Learned 6 Judge Presidency Small Court Court, Calcutta. But before the date of delivery of possession, one copy of an application under Article 227 of the Constitution of India, which was registered as CO number 3629 of 2009, Shantilata Bose, the judgment debtor, versus Shankari Shet and others, which had been filed by the judgment debtor of ejectment suit number 892 of 1969 was served upon the decree holder, and on perusal of the aforesaid revision application, it came to the knowledge of the decree holder of said ejectment suit that one Sudhir Kumar Bose had filed one title suit being now by number 442 of 1989 against Pachu Soda they and others predecessor in interest of the petitioner, herein praying for decree of declaration to the effect that the decree passed in ejectment suit number 892 of 1969, which was confirmed on 29th July 1986 by the Honorable High Court, Calcutta, in FA number 142 of 1982, was nullity and or voidable one due to non-inclusion of the plaintiff therein, say Sudhir Kumar Bose, who happened to be the pre-act subtenant with the knowledge of the defendant, and also for defect of notice and other irregularities, and further declaration was sought for that plaintiff therein, says Mr. Bose, was a pre-act subtenant with approval of the defendant therein, and consequently plaintiff therein was not liable to be evicted in execution of decree dated 19 December 1981. It was further stated therein that one learned advocate Tapon Datto would look after the aforesaid suit on one suit on behalf of the defendant number 1 therein, say Pachu Soda said, who died intestate on 1st November 1989, leaving behind him his widow and 2 sons. And since Pachu Soda Shet during his lifetime would look after the said proceedings, present petitioners were not aware of that proceedings, and after demise of Pachu Soda Shet, said learned advocate Mr. Tapan Datto made a contact with the petitioner and took some signatures of the petitioners on some printed papers, stating to them that those documents would be used in the proceeding pending in different courts, and since the petitioner would treat the said learned advocate Mr. Datta as their family friend, guardians and philosopher, after the death of Mr. Pachu Soda Shet, they put signatures on those printed papers without raising any objection and without seeking any explanation from him. It was further recited therein that the said learned advocate Mr. Datto could not attend the court thereafter, since he had been suffering from cancer, and it was stated that Mr. Datto learned advocate died in 2007, and it was claimed that none of your petitioners was aware of those proceedings. And then on search in the chamber of Mr. Datta, since deceased, they only got some papers relating to ejectment suit number 892 of 1969, that is ours, and FA number 142 of 1981, and they did not get any other document relating to any proceeding, and hence the petitioner had no knowledge about title suit number 442 of 1989 and the decree passed ex parte in title suit number 442 of 1989 on 23rd September 2004, and it was claimed therein that the said decree dated 23rd September 2004 had initiated another proceeding, had not been put into execution, rather that Sudhir Kumar Bose initiated another proceeding, being case number 906 of 2003, before the rent controller concerned, to establish himself as the subtenant under Shantilata Bose and others by suppressing material fact, and it was stated that the petitioners have been contesting the aforesaid proceeding before the rent controller, and it was stated the petitioners such
in their house also, but could not find any document relating to TS 442 of 1989, and hence petitioner filed petition under Order 9 Rule 13 CPC for setting aside expiry decree passed in title suit number 442 of 1989.
What does this mean? Petitioner searched in their house but could not find any document relating to 442. And hence you filed application for setting aside. If you could not find any document.
After getting the copy of the 227 application, where against the rejection of 47 application by the regular
Where have you
judgment.
stated that?
Well, it is a judgment. It is in my application, in my affidavit. It is the judgment we are reading.
No, in the judgment, you are quoted. Your case has been quoted. That this is your narrative.
If the relevant portion is not quoted.
In your section 5, you have.
Yes, that is our case. We have no knowledge. We contested that proceeding and that was ended in dismissal.
Court's findings are that
court findings,
appearance was entered into on your
our
behalf.
appearance was there and we put cost, but reason best known to the other side or learned judge, what prevented me without filing the written statement or allow the.
Under the Evidence Act, Mr. Poddar, official and judicial acts are presumed to be properly done unless you rebut. What is the rebuttal that it was not? There was appearance on your behalf on several occasions. Time was sought for filing written statement.
They are saying specifically mentioning 2 dates, but we said the no summon we have received. That was that regarding summon, no question even put.
If you appear in the suit, where is the question of summon? It becomes
We
academic.
said that we have no knowledge. It is their case.
Appearance, it's recorded that in that suit you had appeared on several occasions.
We have no knowledge.
You had no knowledge, but you appeared in this.
It is their case. They appear. He appeared. It is not my case.
How can it be your case? That is the finding of the court also.
Finding of the court is it must be with some basis. There is no basis that we appeared. We let the suit go ex parte. When we obtained decree after fighting 30 years, we let this gentleman to obtain the ex parte decree, and we deprived ourselves to have the fruits of the decree.
On 5 dates, you have asked for time to file written statement. That is
the
the recording of the court. 5 dates, you have asked for time to file written statement in the suit.
But
After substitution.
But we know, and we never.
After your father's demise, you were substituted. And you had asked for written statement dates on 5 occasions.
It is their case, but no summon was served. No question even put that yes, summon was served upon us. It is the case. Date of knowledge would come when they are able to show that yes, summon was served, and you deliberately allowed the suit to go ex parte. I am completing this judgment, my lord. Thereafter, I will come to my evidence and applications.
Absolutely.
Relating to title suit number 442, and hence petitioner filed a petition under Order 9 Rule 13 CPC for setting aside expiry decree passed in title suit number 442 of 1989, and hence for the aforesaid reason there was a delay of 1998, that is from 23rd September 2004 to 15th March 2010, and hence by filing this application, prayer was made for condonation of delay 1998 days in filing the application under Order 9 Rule 13 CPC. Record postulates that decree holder respondents herein have resisted the application for condonation of delay by filing written objection thereto, wherein denying all the averments made in the said application. It was specifically contended therein that after death of Pachusodar Sheth, present petitioners were substituted in title suit number 442 of 1989, and in the appeal arising out of the same, as such, petitioner were conversant with the go of the above title suit number 442 of 1989, and it was stated therein that present petitioner being substituted, heirs and legal representative of Pachusodar Sheth did not take any steps in connection with the suit, and hence they have cooked one story for the purpose of application for condonation of delay. And it was claimed that the said application on Order 9 Rule 13 CPC has been filed almost 6 years, and hence such inordinate delay can't be condoned, and it was stated that in the said ejectment suit was filed without making Pachusodar Sheth as party to the said proceeding, although in the cross-examination taken in connection with the miscase 176 of 2003, which arose out of an application under section 140, section 47 CPC, petitioner Hiranmoy Sheth himself admitted that Sudhir Kumar Bose would live in the decretal premises along with his family. It is true. We have admitted. He was residing as brother. So said ejectment suit was filed by suppressing material fact, and it was contended that the aforesaid ex parte decree was not required to be put into execution since petitioners have been permanently restrained from executing the decree passed in the ejectment suit, and it was asserted that delay in filing application under Order 9 Rule 13 CPC was caused due to laches and negligence of the petitioner. Hence, delay is not condonable. And lastly, prayer was made for dismissal of the application for condonation of deal. Now, from the record, it transpires that one Hiranmoy Sheth, son of late Pachusodha Sheth, deposed to substantiate the contents of the application for condonation of delay on behalf of himself and other petitioners, and he filed affidavit in chief and presented himself on dock and was examined as PW1. And in his affidavit in chief, he reiterated the statement made in the said application, and in cross-examination on being asked, he could not produce a letter of authority of other petitioners authorizing to depose on their behalf, and he could not recollect as to whether after demise of his father on 1st September 1989, petitioner was substituted as 1A to 1C in title suit number 442 of 1989 or not, and he could not recollect as to whether they had entered their appearance in that suit or not, and even he could not recollect as to whether they made prayer for time to file written statement through their learned advocate on 26 March 1992 or not, and said prayer was allowed subject to payment of cost of ₹16 or not, and even he could not say as to whether again on 15th May 1992 prayer for further time was made for filing written statement or not, and as to whether said prayer was also allowed subject to payment of cost of ₹32 or not, and he could not say as to whether similar prayer was allowed on 16 July 1992 subject to payment of cost of 48 or not, and it was, and as to whether similar prayer was turned down on 5th September 1982 or not, and even he could not say whether the petitioner executed any power in favor of learned advocate Mr. Datta after demise of their father or not, and he deposed that his academic qualification was graduate, and he deposed that his father would look after the suit, white title suit number 442 of 1989, and then after demise of his father, petitioner would look after the same through the said learned advocate, and he could not recollect whether he put his signature on any document relating to suit white title suit 442 of 1989, and he deposed that he did not know anything about 892 of 1969, the eviction suit, and he could not say whether this suit was transferred from the Court of Precedency Small Causes Court to City Civil Court or not, and he could not state whether any execution proceeding was initiated on the basis of ejectment decree or not, and he stated title execution case 176 of 2003 might have been preferred on the basis of such decree, and the same has been transferred to Precedency Small Cause Court, and he admitted that he had deposed in execution proceeding, and he stated that decree was passed in one suit, but he could not state as to in which of the two suits the same was passed. No oral and documentary evidence have been adduced by either of the parties hereto. My lord, it is in which connection we could not ascertain.
If your witness could not say anything, then why did he come to the witness box? He could not say.
What
he does not deny specifically. He does not deny specifically.
What he knows specifically, he stated. He even say.
He only knows specifically that he is a graduate. Apart from that, everything he says he could not recollect. He does not even deny Mr. Poddar. What sort of evidence is this? He has worse memory than me. He comes to court to adduce evidence. He says he does not recollect whether he executed power to the advocate to file written statement, whether he asked for time to file written statement
that is
on 5 occasions.
That is in connection with TS 442.
442 is the deed.
He stated that after demise of his father, the Mr. Datta, who was conducting lawyer, he brought some printed papers, an application, and got endorsed from them. They thought that is for the purpose of the pending execution case. On that belief, they executed all those papers. That much he never denied. When he is saying that we have contested that,
he also could not recollect whether he had put signature on any document relating to the suit.
Kindly see, when the proceeding at the instance of this gentleman, who is the opposite party before you, respondent before your lordships, his prayer in that proceeding, that was turned down, and after having the said dismissal of that proceeding, if he produced that order, that will suffice.
He could not say whether the petitioner has executed any power in favor of learned advocate Mr. Dattu. He could not say that also.
Yes, regarding 442.
442 is the suit in which it was.
Yes, 442. He has no knowledge.
He does not say that. He could not say whether the petitioner has executed any power in favor of learned advocate.
Yes.
He could have said, I did not execute any power in favor of. He does not say, it's your case that you executed. It's your case you executed power in favor of Mr. Dattu. But he could not say whether you executed power.
My lord, learned advocate Mr. Dattu was, my lord, prosecuting for on their behalf in the pending proceedings.
No, not that. It is not specific to 442. Page 50 top.
Yes.
Even he could not say whether the petitioners executed any power in favor of learned advocate Mr. Dattu after demise of their father. And he deposed that his academic qualification was graduate.
Stated, my lord, that we have executed.
That's why he contradicts his own petition.
This is the quoting of the learned judge, my lord.
Learned judge has quoted wrongly, and he came up to this court.
If my lord, evidence is otherwise,
he could not recollect whether he had put his signature on any document relating to the suit.
Complete your lordship will ascertain what is what.
What is what?
Let me complete. He specifically stated.
You have completed.
Not evidence.
You have ended, not only completed.
It is the judgment. That is the highest.
If your witness,
I wanted to
witness does not deny, it does not say we did not put any signature on any document relating to title suit for 42. He says he cannot recollect.
At that point of time, in 1989, how they could he could know about the existence of some other suits in 1989. 1989, when November, when his father...
They were substituted in much later than 1989. Suit was filed in 1989 in the name of your father.
No, but
then you were substituted and you entered appearance on 5 times. You asked for written statement time. You're filing written statement.
This is the case of...
You cannot recollect, your witness, sole witness cannot recollect whether you executed any document regarding title suit number 442 or executed power to Mr. Dattu.
This is in connection with the 442. It is the plaintiff of 442's his case.
442 is the suit where the expected
was. But my lord, my father died in 1989 November. From 1989 to 1992, the pending proceeding, that is the eviction suit at the instance of my father, our father, that was there. We have to prosecute those proceedings from 1989 to in between 1992. We have not stopped there. My father died. We have to take steps. For that reason, we executed the power, my lord, power and papers in favor of my lord, Mr. Datta, for prosecuting all those pending proceedings, because we know that there was a eviction suit. My father was, my lord, pursuing the suit against the tenant.
But there is one question, Mr. Poddar. The court records at page 50, the second last paragraph, no oral and documented evidence have been adduced by either of the parties. Then if no oral evidence, when did he say that he could not say all these things?
My lord,
We don't understand
my lord,
this.
on last occasion, your lordship also pointed out, but I can't say under what reference the learned judge mean. It is not that,
Exactly.
it is not that in the,
No.
here, my lord, we have deposed, but not
No,
opposite party not deposed.
court says
Plaintiff, opposite party never.
you are cross-examined.
I have been cross-examined. But
That sentence is an extra sentence.
Yes, my lord, this is my lord, under what context, what reference, we can't say.
No,
Though your lordship on last occasion, my lord, observed only for this sentence, the judgment to be set aside. But I am not on that.
Yes, because that says
In what context he made
Must be
this
some
statement, I can't say. But when there was sufficient analysis of the evidence, then we can't say.
But what is the basis of these observations?
That I can't say.
Must be your cross-examination at best. Maybe your
No oral and document.
that sentence is
Yes,
wrong.
yes.
But because cross-examination was there, let us see.
Yes. Plaintiff
understand
opposite
this.
party never deposed. In this.
No, only you deposed.
Yes. Now, learned
Yes, you can. You have said you cannot recollect and all this. In your cross-examination, page 33, we'll look into that on the next topic.
Now,
you are cross-examined. Page 33 onwards, you are cross-examined. You have said, I cannot recollect. There are many cannot recollects.
And evidence is also considered. My lord, these two lines, probably my lord,
These two lines is stray line.
Stray lines. Because subsequently, your lordship, all the evidence has been considered by the court below.
We'll continue on the next occasion. Hard in part.
And there is an application under Order 40 Rule 27 also.
Your application.
Yes.
That is to bring on record.
That Order 2099 filed on the basis of this judgment degree that has been allowed.
Generally, appellant files Order 41 Rule 20.
No, we don't understand. Yes.
They filed a suit for eviction. There also filed an application under Order 99 that application was allowed and degree was modified to the extent that it should not be executed against the respondent hearing. That is after filing of this appeal.
Not in respect of the others.
Yes, only restricted to my.
You will take that. That is a part of the record.
That
The degree which you are, the expertise degree was restricted only to them.
Entire my lord decree has been execution stalled due to this.
That is
subsequent fact. We'll look into that.
No
That will help you. That does not go against.
My lord, may we come back on next Thursday?
No, you may not come back on next.
No,
Thursday. Come back on next.
Monday I am ready. Monday at 2.
Why at 2?
My lord,
what will happen in between? Anyway, we cannot also reach the matter probably Monday before 2.
So for a specific date, if it is
There is no specific date. Part means specific.
For that reason,
Hard in part for further hearing on June 23, 2025.
If it is fixed on Tuesday, no.
Not fixed.
ও পরে কেউ থাকবে দাদা
থাকুক
Not fixed.
আমি আটকে আছি 1969
সে ঠিক আছে
Yes, we'll relieve you of your agony.
for patient hearing on the end of the day.